I'm body coded, liberated, and uncontrolled. I'm body coded, color popped, and ready to go. I'm body coded with that white chicken set too low. I'm body coded, let me hear you scream. No more talking, just these motions. Feel the beat, you got permission. Move your body and shut your mouth. Not so hard if you work it out. Feel it go. Lose control. Simulation override. I will make my own good time. Simulation override. HTML customized. Simulation override. Intercepted, televised. Simulation override. Circumstances modified. Move your body and shut your mouth. Not so hard if you work it out. Feel it go. Lose control. Move your body and shut your mouth. Not so hard if you work it out. Feel it go. Lose
Hey there, I'm Dan D. You may remember... Let me start again. Hey there, I'm Dan D. You may remember me from such true crime videos as Betty Broderick. What did that Boston cream pie do to you? Or Afro Man. Lemon pound cake never sounded so good. Today we are here for a classic television trope, the clip show. Revered comedies from The Cosby Show to Alf use the clip show to save money and reuse resources. Today, join me as we travel down the path of all those universally beloved shows with absolutely no tarnish on their legacy. Once I complete this over-the-top voiceover, I'll be joining you to react to these clips from Sarah's earliest TV court appearances, right into her pro se splendor. But no clip show is complete without added value. And to that end, Dan D will be reading every approach the pinch moment from jury selection. Sound good? Great. Well, let's get started. Are you fine? Here's Dan D. All right, that's the over-the-top intro. I'm Dan D. Welcome to the show. If you're not on all messages, turn it on now. Otherwise, you'll be missing some of the best messages from the people in the chat. People like Charles Grieve and Phil Dom Russo, Ramono. You might be missing messages from all of them. Mama Lola's been popping in the chat this morning. Just getting my headset right. Blue River's here. Dev Richardson. All right, that's enough for a quorum. We're going to start the show. What we're doing today, it's a rewatch of a rewatch. So don't get confused. The orange shirt me is me. If I'm wearing an orange shirt in one of the other pictures, well, no, won't happen today. Orange shirt is live. Anything that's not an orange shirt is not live. I've added a second camera. So whenever, when I just need a me and you moment, so it's just, speaking from the heart, that's just between us. It's not, for the general public here. Anyway, we'll see how that works. What my plan is for today's show is I have clips from the first 3 episodes of the Sarah Boone trial rewatch show. That includes Bankowitz asking for a withdrawal. It includes Cashman asking for a withdrawal. And then it includes a lot of pro se Sarah. The first clip is about 25 minutes long. The second one's about 45 minutes. And the third one is 2.5 hours. I'm going to let my commentary do the heavy lifting. I just want to, relax and chill in the chat with you guys. But, it would be pretty lazy just to watch myself. So what I'll be doing in addition to watching myself, there, that's a better angle. In addition to watching myself, I'll be doing transcript reads in between. And the way I've chosen the sections to do a transcript read is I just did a search on the word approach. They approach the bench 200, well, there's 202 pages that have the word approach on it. A big chunk of them is in the pretrial. So, or not pretrial, but jury selection. And jury selection, we don't have our televised footage of that from court TV. So what I thought I would do is, once we've had a chance to warm up, we'll watch the first video, but then we'll come back and I'll do some transcript reads. It's kind of interesting to hear some of the earliest complaints by James Owens and how they manifested by the end of the trial. So we have all that and more to look forward to. Danielle Chavon has put out a couple very interesting videos lately. So you guys will have to remind me. But once we get an hour or two in, we'll pop in for a minute or two of each of those videos so you guys know what we're all talking about and have somewhere you can go after this on your fabulous, fine and dandy Friday morning. But, oh yeah, you know what? What did I... Okay, that would have been a great time to just segue into the show, but... This is my own clip? Okay, good. This is it. Okay.
Make in the defense of their case.
So to set up this clip, this is the very first one of the series. I am collabing with Cowboy Criminology. Dan D in blue only has a mustache and no beard. So that's a prioristic Dan D. Derek Judd is there in a black shirt against a backdrop of a spooky forest. So the two of us, this is Derek's first reaction. He hasn't seen any Sarah Boone footage prior to this. He still hasn't seen a lot of it. So that's kind of nice. I'll be able to revisit some of this for the first time with him in the future. But nonetheless, that's what we're doing here. If you see the chat in bubbles on the corner, that is a previous chat. By all means, read it. There's some funny comments there too. And that's a note to always turn the live chat on if you're watching a replay. Anyway, here we go.
That are absolutely theirs, such as whether they go to trial or not, such as whether they testify or not. But there are many decisions in a case that a lawyer gets to make. And while you certainly have a right to consult with your lawyer and discuss with your lawyer, they don't automatically just do whatever you say. They use their professional judgment and experience and look at the evidence, look at the law, and do the best they can. Also, you've got court-appointed counsel. As I explained to you before, court-appointed counsel rarely have the luxury of representing one person and only having one case to focus on. I have concerns that your expectations of what any court-appointed counsel might do as far as spending time with you and the depth and degree of communication may be unrealistic expectations.
Maybe.
You always have the right to retain a lawyer to represent you, and then that's between you and that lawyer. You can demand whatever expectations that you have as part of that agreement. But when it's a court-appointed lawyer, you have to accept and understand that they have other cases, other courtrooms, other responsibilities. And I'm cognizant of that when I'm addressing these types of issues about communication. So that's just food for thought. Nothing to do today. I don't need a response. I just wanted to make
Sarah likes food.
About that as we proceeded forward. So again, the court minutes reflect that I'm in court continuing pretrial. I have granted a motion withdrawal. I have appointed Mr. Hobson to represent the defendant, and I'm taking no action on the motion, the ex parte motion for costs directed where GAC is responding. Ms. Boone will be returned to the Orange County Jail pending disposition of her case.
Am I able to say anything?
That's my favorite part of that. Am I able to say anything? Can you rewind that? Just go back 10 seconds and...
Oh, yeah, of course.
Sarah should have been told this way more often, but yeah, just let it run.
Able to say anything?
We could make a great mixtape out of that.
Am I able to say
Yeah,
anything?
it'd be nice to me. Am I able to say anything?
For directed where GAC is responding. Ms. Boone will be returned to the Orange County Jail pending disposition of her case.
Am I able to say anything?
And that look she has, like, I figured I wouldn't be allowed to say anything. Got a younger Ralph Fiennes up on the screen for you there too. That's looking a little bit more Matthew Cacciatore like.
Yeah, that is. Yeah, I mean, just where in the world does she find? I mean, who knows? Who knows?
You know, there's something to be said there. There, like, to have that level of confidence with the commensurate and opposite amount of talent. Like most people that are full of themselves have something that makes them, like they're strikingly attractive. They're smarter than everyone. Sarah is so below average on almost every bell curve of, and manages to still think that she's, yeah, it's such a dichotomy, like to have those equal and opposing belief in oneself, which is good. Like, I think Summa Cum Loudmouth was saying, like, I wish I could just, have a fraction of her belief in herself, and really just a fraction, not too much more than that. But
if we all had the self-confidence that Sarah Boone has,
yeah,
I mean,
the levels of achievement.
We'd have a world full of narcissists is what we'd have. Maybe that's not a good thing.
Well, yeah, there'd be a lot more people unpleased with the way the rest of the world's treating them. Like, they think they're the main character.
Maybe a little humility is a good thing.
Congratulations, Paul.
But I don't know that she knows how to express humility in any way, shape, or form. She kind of seems to, anytime somebody's trying to help her, and I think I mentioned this in my videos, it's every time somebody tries to extend a lifeline to her. Right. She swims as far and as fast away from it as she possibly can. And it's like, you do understand this is your chance to be helped.
Hey, exactly.
And A to B. The only reason she's in the position she is because of who she is. She literally made it impossible for anybody not only to help her, but to want to help her.
Because I think, too, she makes, like, when somebody does an outreach to her, instantly it becomes a test of, well, how willing to help me are you? So instead of just taking the help that's being offered, she now wants to, well, are you really on my side? So then, like you say, swimming away from the rescuers, as the buoy's being thrown to her. And, okay, you really do want to help me. I can trust you now because you gave 110%.
She's a special kind of person, isn't she?
If you go to the next video in the feed, I believe this will be Patricia Cashman and the Please Make Her Start Being Nice to Me.
Oh, this is going to be gold. I already know.
Patricia Cashman will be the blonde lawyer with the curly hair. You just see the back of her head through most of but I think she's going to be the one that starts off this video. And there's a good part to look to just listen for Sarah trying to interrupt her as she's talking about phone calls. And Judge Kraynick shuts her down with, nobody told you to stop talking this morning. And I wish I could find the clip because she did talk for a while, but I don't know if Court TV still has that one. But anyway, yeah, let's let it run with Patricia, known as Bitch-Ass Cashman in Sarah's tablet messages. Bitch-Ass Cashman. Good morning, Summa.
Judge, I've obviously not seen the letter. Ms. Boone is correct. She has walked out of the last two visits when I've tried to review things with her. Just so the court knows, I've spent probably 20 hours, a little bit more, a little bit less, with Ms. Boone. She has lots of lists, lots of questions. In reviewing the court file, she was distressed previously about having access to her lawyers. I have taken collect phone calls from her that are at my expense. JAC doesn't reimburse you because I think it's important for clients to have access. I have spent...
Please, no one's interrupted you this morning, Ms. Boone.
As I said, I've spent over 20 hours going through...
Just a little talk to the hand.
When I tried to update her with regard to the depositions that I took recently, she opted to exit the jail conference when I tried to review some things with regard to discovery as to things I wanted to make sure she was aware of. She walked out. She has asked me repeatedly for a copy.
I'll go back for that. A to B asked, what did she try and what did she start to say there? Let's go back. I remember at the time thinking I knew why she was complaining, but let's listen. You can't really hear what Sarah says, but if you listen to what Miss Cashman says immediately before, it's probably easy to work out what Sarah's complaining about.
Things I wanted to make sure she was aware of. She walked out. She has asked me repeatedly for a copy of some medical records. Based
this is good.
Previous attorneys, one of the copies of those medical records had her handwritten notes. So she had a copy given to her previously. She'd reviewed them.
Did I not go back far enough?
Repeatedly for a copy of some. She has.
Good time for a pause. LZB has sent out a gift membership that, perfect. I'm not buying it. I get it. You don't want to buy a membership. That's cool. You don't need to. Being a subscriber is certainly welcome. I'm not buying it. Got a gift membership. So sometimes when you make a stand, you make a strategic, you plant your flag. I'm not buying it. Boom. Someone buys it for you. Thank you, LZB, and congratulations. I'm not buying it.
Asked me repeatedly for a copy of some medical records. Based
this is good.
Previous attorneys, one of the copies of those medical records, they asked me where review some things with regard to discovery as to things I wanted to make sure she was aware of. She walked out. She has asked me repeatedly for a copy of some medical records.
This is good. Okay. Am I losing my mind? How much further back would I have to go?
These attorneys, one of the copies of those medical records had her handwritten notes. So she had a copy given to her previously. She'd reviewed them with previous attorneys. I sent her a new copy. Some of the things that she thinks are important from a lawyer perspective, perhaps I don't attach the same importance to.
Farther? Okay.
And you try to explain that to a client.
You try and explain it.
I know the court's in a difficult position, but at this point, we're at that impasse of.
Okay, so I'm at 1426. Oh, I know what the problem is. I'm used to watching these. I'm usually watching like 8-hour long clips. So when I bump the bar back, the tiniest bit, that's like way too much. Now it's going second by second on the bar. Okay, we'll bring it back. We'll just let her talk. We'll.
So the court knows I've spent probably 20 hours, a little bit more, a little bit less, with Miss Boone. She has lots of lists, lots of questions. In reviewing the court file, she was distressed previously about having access to her lawyers. I have taken collect phone calls from her.
I'm just going to address too while we're waiting for the moment to come back up. I think, Patricia Cashman was, if the strategy was keep shitting on every lawyer until you got a good one, that can be a good strategy. And if Sarah stopped when she got Patricia, she would have been a winner. But it's almost like that Price is Right game where you can keep exchanging your prize for the next prize. And at a certain point, you just keep what you got. Is it Price is Right? Probably. Let's make a deal. But yeah, she didn't know when it got good for her. And I think at that 15-year plea, if she was serious about it, Patricia Cashman could have gone in and said, look, give me something better than that. I know you guys don't want the house. Whatever it is, she seems like the one that could have made that negotiation and got her down into the Courtney Clenny range, which, undeserved 100%. But if Sarah had any chance for it, it was with Patricia Cashman.
Are at my expense. JAC doesn't reimburse you.
Yeah, Sarah bid over the asking price. Just, oh, Sarah, the magic number was 8. You went for 13. Boom, 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 boom.
I think it's important for clients to have access. I have spent...
Please, no one's interrupted you this morning.
Okay, there. Thank you. Okay, we know where it happened now. Going back 10 seconds.
He doesn't reimburse you because I think it's important for clients to have access. I have spent...
Please, no one...
Okay, so she just said, how come when I... But what Patricia Cashman said is, I accept calls from her because I think it's important, and well, I can let her play because we can hear her.
That are at my expense. JAC doesn't reimburse you because I think it's important for clients to have access. I have spent...
So she's saying that I've taken calls, not that I've taken every call, but she's like, I've taken calls. I've, collect call from OCC prison. Fine, take this one. So she's taken calls. She doesn't have to, but she's going above and beyond. Sarah doesn't appreciate it. And Patricia Cashman is making a shouldn't have had my morning beverage. Making a substantial claim by backing it up with receipts. And one of them is, hey, it's not much, but I paid for this out of my pocket. Didn't need to do that. Don't tell me I'm not being a good lawyer. I'm doing above and beyond. And Sarah, how come when I... So I'm sure she wanted to just bring up, well, how come when I called on Tuesday the 29th at 9:28 p.m. or 9, whatever. I think that's where Sarah's interjection was going. Good stop on me, too. All right, let it run.
No one's interrupted you this morning, Ms. Boone.
As I said, I've spent over 20 hours going through...
Just a little talk to the hand.
Oh, we'll just let that play on its own, too.
Because I think it's important for clients to have access. I have spent...
Please, no one's interrupted you this morning, Ms. Boone.
I have taken collect phone calls from her that are at my expense. JAC doesn't reimburse you because I think it's important for clients to have access. I have spent...
Please, no one's interrupted you this morning, Ms. Boone.
As I said, I've spent over 20 hours.
And one more interruption to bring up that Kitten Pusher in the chat is thinking about writing some Sarah Boone fan fiction. I think Kitten Pusher, no, it might have been Hairball Yarn that brought up interest, wanting to help out with videos, but maybe that could be something that would be a group project. If you do writing, I would be happy to read some fan fiction and then do it up as a collab between the two sites if it's ever something you get around to doing.
Just a little talk to the hand.
When I tried to update her with regard to the depositions that I took recently, she opted to exit the jail conference. When I tried to review some things with regard to discovery as to things I wanted to make sure she was aware of, she walked out. She has asked me repeatedly for a copy of some medical records. Based
this
on
is good.
Previous attorneys, one of the copies of those medical records had her handwritten notes. So she had a copy given to her previously. She'd reviewed them with previous attorneys. I sent her a new copy. Some of the things that she thinks are important from a lawyer perspective, perhaps I don't attach the same importance to. And you try to explain that to a client.
You try and explain it.
I know the court's in a difficult position, but at this point...
That's an iconic bit of dialogue from Patricia Cashman, too. And you try and explain that to a client. She sounds even exhausted just by the end of the sentence.
Attach the same importance to, and you try to explain that to a client.
You try and explain it.
I know the court's in a difficult position, but at this point, we're at that impasse of if she walks out of every conference that I have with her, I'm not sure what that says about the attorney-client relationship.
Fuck you on the McPotatoes face.
Ma'am, you said there was something else that you had other than a 58-page submittal or letter. What other information is it that you're seeking to have me take a look at?
It's things that I've been working on in the meantime. It's things that she likes to tell me is not necessary, but I know for a fact it is necessary. She likes to influence countries to rest all the time, and tells me I'm not having this conversation with you. So I'm not going to waste my time, and I, being in jail, have supposedly abundant amounts of. She's not going to waste my time because she's not going to explain something to me. And I have taken it upon myself to explain it to myself because she refuses to do so. I don't understand what it is that...
I've taken it upon myself to explain it to myself. Then you're done. What's the complaint? Like, you're a straight A student. You learned something. I had to take it upon myself to explain it to myself, Your Honor.
She has against me. I have told her from day one that her snotty attitude was inappropriate, and I try very hard to bear with her and her attitude.
Pause it right there.
I'm doing well to her, but...
Thank you, Suma. I'll take that pause. Suma in the chat says, she probably took offense at the call reimbursement claim. In one of her letters to Bankowitz, I think she made a point of all caps underlined, will be reimbursed.
Pause it and we'll rewind to the beginning of her giving her little speech here because a lot to unpack already. We don't want to lose it. This is your first time watching this, right?
Yes.
Could you imagine being in court and having this client give this assessment of your snotty attitude and how you're always trying to put things to rest?
So I can totally see somebody doing that, and I'm reminded of other attorneys I've talked to who have actually had this very same conversation that the attorney's having with the judge right now, just about the lack of cooperation and everything. And we talked about expectations earlier, but then Sarah rises it and she turns it into something. I really think she believes she's making an argument. I really think she does.
Yeah.
The only problem with that is she's the only one who thinks she's making an argument.
Yeah. And I think she has such vivid conversations in her own head that she reinforces herself. So, she initially maybe this is a good idea. By the time she gets to court, this is a great idea. I've thought of it. I've thought about it 100 different ways, plus the 100 prioristic ways I thought about it before, keeping track of all of them.
Totally see her as the kind of person that replays scenarios in her head, and each scenario gets, progressively more, successful, and to the point where everybody, and then everybody clapped and I gave my speech and and that would explain why her disappointment with the way the world reacts. Like, you guys are doing it all wrong. You're not playing your parts.
I know my arguments. I'm going to come in here and lay it all out for the judge, and he's going to be disgusted by Patricia Cashman's performance.
There's an Oscar Wilde quote that a man who represents himself has a fool for a client.
This was corrected in the comments as a Abraham Lincoln quote. I don't know whether the correction or Derek is correct, but just pointing out that it was corrected in the comments on the original video.
And it has nothing to do with what your knowledge or lack of knowledge of the law is. It has to do with the fact that you're so close to your own situation that you don't see your own pitfalls.
Exactly.
And that's why, you get these experienced lawyers who, anytime something comes up,
thank you, Hairball.
They very rarely try to handle it on their own. They always call another attorney, and it's not because they don't know the law. It's not because they're good. I mean, Alan Dershowitz could probably take on 90% of the of the attorneys in America.
But Alex Murdaugh recently overturned, but he keeps trying to act as his own lawyer on the stand, thinking he's smarter than everyone. And just like you say, way too close to the...
And for clarification, I know he had a lawyer, but I think that his conduct on the stand, he was trying to lawyer himself out of situations and just in the way his testimony was delivered.
Events that, he doesn't realize.
Way too close.
And he doesn't realize what he's coming off on the stand.
You can have a savvy attorney walk you right into a trap that you can't back out of. And if you're thinking that you've prepared for this, or you think you understand the intent of the question and you really don't, you can walk right into that. And then you're in a place that you can't back out of. And that's why it's so important, even if you know the law, even if you know your rights, you really should look to get an attorney because you're too close. You don't know.
Exactly. And then, and here, this is really, I think this was her last best shot from
Disney Mom says, Sarah has a booby belly. Boobs and belly look like one. Ma'am, get some better undergarments. I think with the shackle, it almost, and I think I point this out later, it's a bit of a front butt from the profile. Like the shackle cuts in the cleavage there and gives that little, I don't know, it looks like a double-cheeked butt. Yeah, I don't know what else to call it.
Everything that I know about Patricia Cashman.
Thank you, Kitten Busher.
I imagine that what happened is she came into a meeting with Sarah and said, look, you've had 6 lawyers. I'm the last one you're going to get. Smarten the fuck up. Sit the fuck down. I'm going to tell you, this is how, there's 3 defenses you have and all of...
I'm going to rewind that a little bit because that's exactly, I think, how Patricia Cashman came in with her snotty attitude. But rolling along takes us a little deeper in the history chain and says the earliest recorded version of this sentiment appeared in a 1682 book by Humane Prudence, or titled Humane Prudence by William de Bretagne, which stated, "He who will be his own counselor shall have... He who will be his own counselor shall be sure to have a fool."
I imagine that what happened is she came in...
Hard to pronounce without the soft Fs I was expecting for Old English. That's my explanation.
To a meeting with Sarah and said, look, you've had 6 lawyers. I'm the last one you're going to get. Smarten the fuck up. Sit the fuck down. I'm going to tell you, this is how, there's 3 defenses you have and all of them are going to get you 15 years minimum. Take the fucking plea. Yeah. And Sarah took offense, like, don't talk to me. I'm your client. I'm the boss. Like, can I talk to your manager? And that...
You're so right. Can I talk to your manager?
Yeah.
Sarah Boone would be that person.
And I think she thinks the judges are the prosecutor's managers.
And now we know that she thinks the DCA is the managers of the court. Like, can you guys just please advise me? I know you told me not to talk to you, but I don't know where else to go. You guys are in charge of these guys. What do I do? Judge Kraynick's mean.
I don't think, I think she's that, disconnected from the way the legal process works, that she thinks complaining to the judges about these prosecutors is getting them in trouble with, their manager.
Yeah, it's so... we can all agree, right? Her grasp of reality is tenuous at best.
Well, yeah. It's most...
Good morning to juror number 3, who's just joined the chat, Suze Watt, who helped me out with a 16-page Judge Kraynick order explaining why he made Sarah pro se. We may get into that today, too. We'll see.
And self-created. It's like she's living in her own little world, and we're just got to peek into the, looking glass. We want to rewind it by about a minute and a half. We'll listen to her complain about Cashman in full.
And for anyone who watched the stream where Cowboy and I just had problem after problem, in retrospect, it's actually more entertaining than I remember. There's definitely mistakes. It's not a great stream, but it's still better than I remember. This was how we pivoted. So I did the live stream and broadcast. Cowboy did all the video work, and all I had to do was share the screen images he was in control of, and totally took a lot off of my plate and made it a lot easier for the two of us to stream together. So big learnings, and that's why don't be afraid to make mistakes. Make mistakes, you learn, and when you learn, you do better the next time.
All right, yeah, let's go back right about here. Oh, a little further. There we go. We'll start here.
If she walks out of every conference that I have with her, I'm not sure what that says about the attorney-client relationship.
Ma'am, you said there was something else that you had other than a 58-page
Other.
submittal or letter. What other information is it that you're seeking to have me take a look at?
Did I hear him right? 58 pages?
Oh, yeah.
It's the first time Derek had heard about the 58-page letter. I love the processing time. Like, he's just listening and like, I take it, we all know about the 58-page letter. We've been in this case, chin deep in our hip waders since it came out. But yeah, just listen to Derek process it from the point. I have seen the 58-page letter.
Ma'am, you said there was something else that you had other than a 58-page
Other.
submittal or letter. What other information is it that you're seeking to have me take a look at?
Did I hear him right? 58 pages?
Oh yeah, that is a piece of work. I might send you the link. There's a creator named SKR that does reads of like all of her documentation, in addition to long form just rant videos over all of her content. But the 58-page letter, it's something, it's almost like my Mount Everest. Eventually I want to get to it, but I need to really build up my strength and power. Just reading 4 to 6 pages of her kind of drives me a little crazy.
I haven't read the 58 pages. Don't know a whole lot about what's in there. I might.
Her ad for the attorney's in there. So the circus ad for the
Okay.
attorney, that was part of the 58-page letter.
Gotcha. Oh,
Page 58.
okay. So I am familiar with a little bit. That I guess it's been a while since I've done anything with it. But we need to file get on gov.org or change.org or whatever it is, and get the 58.
Indoor camper. Put a pin in that thought. So I'm going to read Indoor Camper's statement here. I'm not going to give you any context. You have to stick around for that. Indoor Camper says, I would be shocked if her brother actually appears for an in-person. One of the first sidebars we're going to read, and we might even read it. Oh yeah, we're almost at the end of this video. We'll be reading it in 2 minutes. Interesting. I have questions.
Page letter in the Smithsonian, because that belongs to the world.
Yeah. Yeah.
You know, it's
Yeah, I don't know about the Smithsonian, but I think I suggest the Black Mirror Hall of Shameful Technology, and that letter could go there just as a testament of evilness.
going to be great.
It's already in the YouTube Smithsonian of Sarah Boone fans, I'm sure. Like,
Morning, Michael.
That might be a good video to do. I'll think about it. I'll work on that. But almost like
That'd be a good one.
like Black Mirror did an episode on the Black Museum, and it was all the terrible technology from the show kind of featured in this menagerie. I could see
Some might even say it was a clip show.
doing a similar thing with all of the Sarah Booneisms. I'm going to let that percolate while we watch.
Okay. All right. So we'll pick it up here.
I've been working on it all the time. It's things that she likes to tell me not necessary that I know for a fact is necessary.
I know for a fact.
That's all the time,
And on the know for a fact point, we did look at her 2018 arrest, where she had a lawyer that made a very onerous discovery claim when she was arrested for strangulation. It was like this 15-point, we want every witness statement that's ever been made against Sarah in all the years she lived at Tealwood. So just really... it seems like the sort of thing that would have made Sarah really happy and emboldened her to use the law in her favor in the future, knowing that, and it also probably set her expectations for what a public defender does in a crazy direction. because it's one thing as, you know, half of a he said, she said domestic violence dispute for the state to give up on a case because the discovery, like this, just pain in the ass, let it go, which is what happened to her, which is sad because maybe it would have stopped her sooner. But besides the point, I shouldn't have gone off.
Constantly tells me I'm not having this conversation with you. So I'm not.
Oh, so yeah, that letter, I think, gave her where she thought she knew the law and said, you know, I know for a fact it's possible. Probably because she had this, she still had the document from before with all these things that were discovery, you know, probably the lawyer telling her this discovery is a pain in the ass. They're not going to want to pursue the case, blah, blah, blah. She thought she could use that same strategy in the murder case. And she doesn't realize that it's a murder case. They're not going to, oh, well, it's a big hassle, so I guess we let her go. But she wanted to employ the same strategies, I'm sure. And I'm sure she's telling Patricia, I know you can do it, so ask for the discovery of everyone who ever made a complaint against me in Tealwood. She's like, not doing that. Not doing it.
I'm going to waste my time, and I, being in jail, have supposedly abundant amounts of. She's not going to waste my time because she's not going to explain something to me.
That is correct, too. So Hairball Yarn points out that the Bill of Rights was in the 58-page letter. When I started reading it, I realized that it wasn't nearly as robust as the 58-page sounded. It was padded. It was like a kid trying to, you know, stretch a report that was supposed to be 75 pages. She put in definitions, just wholesale copying from law books. Very little original material, which is, you know, disappointing for how creative Sarah claims to be.
And I have taken it upon myself to explain it to myself because she refuses to do so. I don't understand what it is that she has against me. I have told her from day one that her snotty attitude was inappropriate, and I try very hard to bear with her and her attitude. I don't know what it is that I'm doing wrong to her, but I feel that her attitude has equaled prejudice, which is not in my favor, especially considering she's supposedly representing my life.
Hey there. If you think live streams are just too damn long, we'll keep watching these fine and dandy clips. They're shorter.
You don't think that because you're here.
Hey there. Are live streams just...
No, they're not. No, they're not. All right. That's the next clip, but let's go into the transcripts now. So let me move it over to the transcript reading screen. That's this one. Gives you the side profile of me. So I'm in both sides. That's me. Hey. And that's me there. And there's no prioristic dandy. This is just me. What we'll be doing is reading from the transcript, the very first approach. So this is on page 16 of the 2,500-page transcript. Kitten Pusher says these streams aren't long enough. Today's stream is only going to be about 6 hours, so a short one by Dan D standards. Well, maybe right in the middle. Right in the middle. Not super long. And I'm unsure about doing a ramble tonight. We'll see how it goes. Tonight's ramble is pending. I think we're starting to move towards a weekend ramble as the new standard. So this is from jury selection. Beginning here is just Judge Kraynick introducing the court reporter. The importance of saying yes or no rather than or sure. Okay, Madam Clerk. Okay, one of the first things they do is ask, how many of you recognize the person that's sitting here? And juror 27, 38, and 35. And these numbers don't reflect the final juror numbers. They're just the juror selection numbers. Because, they're identified by badges, which are different than their juror numbers. I don't know what she called her, the Sarah Boone. Okay, all right, we'll come back to you. Juror 35. And whenever I'm reading the court, that is Judge Kraynick. Sarah Boone, court, okay. Juror 38, Sarah Boone, okay. Can the parties approach for a moment? Do we want to go ahead and address these specific persons now? Mr. J. No. Court. Okay. State. Or I'm sorry, defense. Mr. Henderson. You mean now, Judge? You mean call them up individually? Individually, correct? I'm all right with doing that at this time, but if the state wants to wait, all right, we'll make note and circle back on them because they may have other conflicts. Okay, thank you both. All right, thank you. State, if you could, please read a list of the witnesses that you may intend to call in this case. Bum, 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 bum. Here comes the interesting part. Pay attention. Well, not so much. This list is less important. So this is the list, Mr. Cacciatore, is all the people that they had on their list to call. There's a little gamesmanship here, right? You're not just going to put your exact, like everyone who gets called in the case. So interesting to look at the names that get left off. Part of the reason for including extra names is so that the defense would have to prepare to cross-examine extra witnesses. That's not time that they can spend on the rest of their case. So little gamesmanship in always giving more than you plan to call. But there's also, you don't know until you're in the trial how much evidence you're going to need. And so anyway, here's the list. It was Jennifer Albrecht, Sheriff's Office, John Alden, who was called, Sheriff's Office, Vincent Battaglia, who was called, neighbor, Carolina Benito, Florida Law Department, not called, Brian Boone, Gainesville, Florida, called, Jeffrey Brown, Sheriff's Office, I don't think was called, Kenneth Davis, Sheriff's Office, not called, Lisa De Leon, Sheriff's Office, not called, Rachel Fenner, Sheriff's Office, not called, Natasha Fisher, Lanya Herr, Devin Jamro, all not called, Chelsea Kepsel, called, Vincent LeBron, not called, Santia Leroy, not called, Scott Lowen. I've been spelling Lowen with an E this whole time, or two E's. Have I just been trying to be bougie with it? I'm sure I saw it Loewen, and I just thought it was wrong in the transcripts because he never identified himself by name. Maybe it's possible. Maybe. Look into that. I think it's Loewen. If somebody knows for sure, by all means, say it in the chat. John Martinez, Meredith McCaskill, also law enforcement. Brandon Motes, he was called. Abraham Moreno, called. Joseph O'Neill, not called. Daniel Pekoski, not called. Jessica Ramirez Delgado was called. Shanice Robinson, Sheriff's Office, not called. Kayla Rodriguez was called. Melissa Roughgarden, called. Melissa Sexton, not called. That's the property manager for Tealwood. Patrick Strawn, Sheriff's Office, not called. Nathaniel Taylor, Sheriff's Office, not called. Juan Torres, called. Yunella Woodon, called. Douglas Vest, not called. Stephanie Vieira, Orange County Fire Department. She may have come in to verify some 911 evidence. Tanya Werner, called. Joan Williams, not called. Matthew Williams, Kelly Wood, Anthony Zito, all not called from Sheriff's Office. Dr. Sarah Zidowitz, and District 9 Medical Examiner. Okay. So then the court asked, do you recognize any of those people? No paddles were raised. Now Mr. Owens does the same list. This is where it gets interesting. Here we go. Mr. Owens. Many of these may be the same. The first 20, all with the Orange County Sheriff's Office. Chelsea Capsule, Scott Lone, Lisa De Leon, Melissa Ruffengarden, Nathaniel Taylor, John Martinez, Kelly Wood, Jessica Ramirez Delgado, Anthony Zetto, Patrick Strong, Junella Judon, John Alden, Kenneth Davis, Joseph O'Neill, John Williams, Manny Lopez, Caleb Rodriguez, Kenneth Dale, Vincent Lebron, Matthew Williams. Those are the 20 with the sheriff with the Orange County Sheriff's Department. 2 with FDLE, that's the Florida Department of Law Enforcement. Carolina Beneteau and Meredith Maskaskal. And then the medical examiner, Dr. Sarah Zedowitz. Mr. Cacciatore. Zedowitz. Then we have Dr. Julie Harper. We have Michael Brand. We have Tanya Werner. Stephanie Vieira with Fire Department. Orange County. Brian Boone. Vincent Vitaglia. Brandon Moats. Juan Torres. Abraham Marno. Melissa Sexton. Maria Fernanda Gallipoli. Phil Paulson. Tyler Paulson. Who's Tyler Paulson? Pause. Why don't I... Do we know that name? We know who Philip is. I don't know of Tyler. It's not Uncle Tyler. That's Uncle Al, right? No, Tyler was never called. Neither was Philip, for that matter. But it's on the list here in the public record. It's James Owens given the list of people that could have potentially been called. Okay, if I may, please, who's Tyler? Is there, no, there's John and Philip, right? I think there's 2. Is it Tyler John Tyler? Maybe that. Aha. Okay. We'll leave it at that then. Wouldn't that be crazy if they called him? Wow. Like, to even be considering it. Especially with the whole allocution and, stabbed his wife in the head with a knife and mother of the child. And, what'd your brother do? Oh, just good. Just, serves the military. Okay. Well, thank you, chat. You guys have helped me out immediately there. We'll go through the rest of the list. Tyler Paulson, Devin Jamro, Shanice Robinson, Rachel Fenner, Victoria Shelton, John Harris, Marcus Bullock, Janice Burns, Dan Burns, Pearl Walker, Deborah Johnson. Judge, there are several that are just custodian of records. We don't have the individual's name. Okay, go ahead and list those persons, please. Mr. J, may we approach? The court says yes. Court says yes, sir. Before we list anybody from the state attorney's office, I would just like to object and point out that our protective order was granted. Response? Well, depending on the order, should I even mention the names? I'm probably going to try and proffer that testimony outside the presence of the judge for preserving the record on the issue, but identify for me who the custodians of records were. Was it the same ones identified in the state's motion? No. In the state's motion, I listed Christina Mills, domestic violence supervisor, Ann McCauley, director of victim services, Matt Storch, misdemeanor supervisor, Ibrahim Kazim Izalatin, assistant state attorney. Mr. J, we're going to object to those names being listed. It's confusing to the jury that people from the state's attorney's office would be listed as a witness when they're not being called. Court says, are those persons going to be called? Mr. Owens, remember, Judge, you had entered an order saying disallow the testimony. But the state's motion pertained to the records custodians. It didn't identify specific people. Mr. J, no, it's about these people. They issued subpoenas for the head of our victim advocacy. They issued subpoenas for the former and current prosecutors. And I objected based on fact and opinion work product. Judge, you'll remember, we were attempting to get in the record that the state attorney has the ultimate power, I recall, to dismiss the case or not. And we believe that one or more of those people is going to be able to establish that. Okay, look, all right. Give me a second. I just want to go back and look through that. It was through a notice, was it not, Mr. J?
Mr. J, I'm sorry. It was through a notice, was it? It wasn't your motion in limine. There it is. There's the state's request for a protective order. So, unless I'm missing something, and please forgive me if I am, the state's request for a protective order filed September 30th identified Custodian of Records, Orange County, Office of State Attorney, Domestic Violence Supervisor, Victim Advocate Supervisor, and Misdemeanor Supervisor. That's what your motion identified. It didn't give specific, Mr. J, because they didn't name those names yet. The court said, oh, okay, all right. That's why this is new to me. Okay, Mr. J. And I didn't realize who Ibrahim Medine or whatever his name was. He's a former ASA. Got it. Okay. So this order for the state's protective order pertained to those supervisors, not the specifically identified people. And it's your position that it's because they were not known or subpoenaed yet by the defense? Yes. Okay. Got it. Anything further, sir? We just didn't know their names at the time. We later learned from speaking to the state attorney's office the names, so we listed them. My position is they've objected. The court has made a ruling, but for the purposes of appeal, outside of the presence of the jury, I'm going to want to proffer that testimony. So based on that, I don't know whether you want me to go ahead and just mention that they might be witnesses or not. Either way. Anything further, Mr. J? No, sir. Due to the granting of the state's protective order, and if those are specific persons that were contemplated, and I'm seeing that you're in agreement with that, yes, I'm going to agree with the state for those not to be read at this time. Judge, the remaining witnesses that we have we don't know who they'll be, but there's Advent Health, their hospital records. Uh-huh. What's your position to the custodian of records? Mr. J, I don't have a problem with them just saying custodian of records. I don't think we've ever received any medical records regarding George Torres yet. Mr. Owens. George. Court says, okay. Mr. J, so there's that Richardson discovery issue if they plan on introducing any medical records to the deceased. Sure. Mr. J, because we don't have them. Okay, all right. Go ahead and read the records custodians for those persons. And if there's an issue, a Richardson issue that comes into play, we'll address that when and if we get there. Okay? All right. Thank you all very much. Back to open court. Okay, so those were the first two early ones. The next one doesn't appear until page 77, so we'll save that. I don't know what somebody being a dental hygienist has to do, but we'll save that. We'll come back to that, and we'll go back to the videos for a moment. I'll check in with the chat while I get that going. Let's see. That's not a great view. Well, that'll have to do. We'll do that. And all right, let it run.
This video was uploaded on August 5th, 2024. This is 2 months before the trial. 1 month before James Owens comes on. I think James Owens came on at the very beginning of September.
And it looks like Sarah's staring directly at you. She's saying hello to Paige, who's just joined the chat. Hello to Tammy Sellin, Peter Shane, who got a little chat hello, but not the full voice hello. Deb Richardson, who's here. Mary Mack, who has signed up for a few creators, added AG Tactical, Summa Cum Loudmouth, and Danielle Chavon. That's an incredible triumvirate. You're going to have a great time. It's a good day to have a good day with those three.
Which, you talking to Billy Lane there?
Red folder. That means Lana, I love you.
Love her little pink handcuffs. She likes to make a big show of having, I'm
thinking about, so the pink handcuffs, I thought it was just like a fashion thing. Is it to help law enforcement identify, like, when you're cuffing women who might have smaller wrists, like wrist to hand ratio? Are they specialized cuffs to be harder to slip?
I don't know if she's making a show of it or you were literally restricted, but I think it's funny to watch her. It's so hard for me to write with my hands shackled together.
I love that.
Pretend judge. 2 months of membership. Has moved on to the Pro Se badge. Welcome. Pretend judge, the very last footage we saw was her...
Indoor camper says, those are breast cancer awareness cuffs. That's good to know. I think Sarah had a mole once.
And Cowboy Derek from Cowboy Criminology.
But Seba says, nope, female cops like pink cuffs. I think, isn't it because a lot of female cops are also taking females into custody, like where they'll call a female onto the scene or whatever? I'm just speculating that my wrist's quite large, right? Maybe, well, obviously you can still cuff around them, but I don't know. I would think there needs to be certain cuffs that are designed so that a little hand, well, just like she does her little suitcase thing, a hand coming out of the suitcase, it looks like she could slip a cuff with her, especially 98-pound Sarah.
Joined me, but was her talking about pretend judge. And he was asking, like, I just picture like a little sock puppet, like she put a sock on her hand and it's like, pretend judge says you should be nice to me. So now I'm always thinking of it as a sock puppet.
Could you imagine if pretend judge actually had like a physical manifestation? Sarah just like was, pretend judge says you need to stop. Big thank you to Charles Grieve, who sent out 5 Dan D True Crime gift memberships. Your name is Crazy Mom Nat, Dana Schuler Brand Alchemist, Dan D reads, I got a gift. That's my other account. That's Carolyn Cross and Mystify. You've all received memberships to Dan D True Crime courtesy of Charles Grieve.
But judge, thanks to Cowboy Derek on that. If you want to watch the last video where it's there's a cartoon of me and a cowboy. Well, it's not. We're both cartoon characters, but a Avatar Canadian with an Avatar Texan, and we review the first 3 pretrial hearings. Not all of them, but just a selection of hearings leading up to the trial here. Oh, that's a zoom on her paperwork.
Spoiler alert, you don't get to see any closer, but it shows that I was into it right from the beginning. I was looking for extra details that may have been missed on previous watch-throughs. Worst part about this is you get a real close-up on those hands.
Oh, that's a shame. That's a shame.
Her stupid little jail pen with a little nub. Good morning, Lakeisha.
I really wish we could see more.
Yes,
that's
Kitten
too
Busher,
bad.
Dan D. Reeds did get a...
Got a lot of things to say.
Actually, it's interesting that the Reeds channel ended up getting a free membership because... Look at this...
Hey, Kitten Pusher, you've just joined us for the Sarah Boone portion of the program. If you've been listening to the horrific details of criminals from around the world, we're back to the familiar comfort food of Sarah Boone and her shenanigans.
That was a prioristic welcome to...
welcome back.
This view is...
Charles Grieve points out that she demanded hair and makeup when what she really needed most was a bra. And this particular smock isn't doing her any favors. It almost looks like...
Oh, this is where we get into the front butt discussion. Okay. It's hard to keep track of the prioristic snark and the current snark, but
It all blends nicely together. This view that I have set up here, I want to try doing dual streams, and I might be bringing my Dan D Reads channel back up. I was reading Robinson Crusoe. I also have A Tale of Two Cities. So I'd like to just do live reads of public domain literature, and I think this setup might be a way to do it. So a little test.
She has a double boob. Like the gut boob is equal in, yeah.
Oh, the analysis you
butt.
only get at Dan D True Crime.
Delilah says hi to Lola. Lola's sitting behind me. I don't want to make her get up, but see if I can get an appearance.
The call right around here to be sworn, please. Please swear in front of the testimony you should give, shall be the truth, the whole truth, and nothing but the truth, so help you God.
Yes. Ma'am, good morning. Can you please state your full name and date of birth?
So interesting. It seems like it's in stereo. So if anyone's listening and having difficulty with one side or the other, you might want to turn on mono, because I'm getting some audio in the right ear, some in the left ear. Judge.
In addition to Charles Grieve, LCB, and now Sue's What? More gift memberships going out. If your name is Free Soul London, Amanda Carstead, Kfar, Catmandu, Tamara Dolman, Elwood, Jokai, Canada Strong Forever, Gypsy Blue, and Disturbing the Pieces. You've all received Dan D True Crime gift memberships, this time courtesy to Sue's What?
Kraynick is all left ear, and Sarah appears to be right ear.
Birth the record for me.
Sarah Boone, 10777.
I'm going to throw on the captions. That should help anyone who is having listening difficulties.
I do see that we have a representative from JACS that's appearing virtually. Sir, can I get
She's my cherry pie.
your appearance for the record as well?
Yes, Your Honor. Christian Lake with the Justice Administrative Commission.
Okay, very good.
Is it?
We put up a poll in the premiere of this video. I was really surprised that Lana and Sarah didn't make fun of the lisp that Mr. Lake has. For all of the little sniping, Typhoid Mary for coughing 12 times in 40 or 2 hours. I think Mr. Lake, for some reason, gets away with having a lisp. I like it. I think it's endearing, but I'm just shocked that it wasn't a focus in the tablet messages of Sarah's ire. She had so much forgiveness gold to spread around, but none for Mr. Lake.
Too loud at all? Is it over, or is it perfect volume on court where you're able to turn it down yourselves?
Don't worry about commenting on the volume, because that's prioristic me talking about it. I can't change the old volume anymore, even if you don't like it. Well, I guess I can.
Just don't want it like cracking out.
And another pause, because rolling along, keeping it rolling, 10 more memberships to Dan D True Crime. This one went to Silly DK, Can Lowell, Catherine Hegarty, Jen for Justice, Ashley Lynn, Pumpkin Porter, Krista Francis, Tracy Foucault, that means Tracy Coldheart, Debbie Lanier, and Cheryl Sharp. You've all received memberships to Dan D True Crime, celebrating like Michael E. Wang, who's been a member for 5 months and got that Pro Se badge sitting after the name. If you've been gifted a membership, refresh the stream so that you can use all the emojis that are in the are available for members.
All right, we've got a couple of things that we're going to be addressing this morning. The first is the motions, Ms. Boone, that you had made reference the last time I saw you. The court has reviewed all of those motions. I've reviewed.
Good point, Elizabeth.
Also JACS's reply, specifically their response to the motion seeking due process costs.
Hold on, I just got to change my scene. If they're going to have Sarah over there, I need to change all of this.
I used to have. See, I didn't have intermission music before.
Getting better. better for various reactions.
That was filed on July 30, 2024. State, have you had the opportunity to review all of Ms. Boone's motions?
Yes, Your Honor.
Okay, all right. Ma'am, I want to go through each one of them and hear from the state, from yourself, and from JACS. We're going to start first with y'all can be seated, you don't need to stand, thank you. The defendant's temporary motion for reservation of proposed cause to acquire investigator for defendant's defense and trial dated July 18, 2024, received July 29th. That request seeks to reserve any and all costs proposed to be incurred to acquire investigator. The defendant's temporary motion for reservation of proposed costs to acquire all witnesses for defendant's defense in trial dated July 18, 24, received July 29th, 2024. The request is to reserve any and all costs proposed to be incurred to acquire all witnesses for trial. And then defendant's temporary motion for depositions to be conducted per FRCP Rule 3.220 by defendant under pro se attorney title and position ordered by the judge in court dated July 18, 2024 and received July 29, 2024. I have reviewed all of those motions. All three motions reflect to be determined or TBD with regard to the investigator, witnesses, and deponents. The total amounts are to be determined. How to calculate is unknown. As to the depositions, the date are to be determined, and the amount of transcripts are unknown. Mr. Lake, I've reviewed your response. Do you have anything else to add, sir, with regard to those items, investigators, witnesses, or deponents?
Not really, Your Honor. The only thing is if we can provide Ms. Boone a copy of our pro se packet that has information about including model motions. We would be happy to send her a copy or to send your JA a copy that you could send to give to her. That might help her for purposes of future motions. But as far as these are concerned, I think our response pretty much outlines what our position was to each of those requests.
Okay, thank you, sir. If you would be so kind to send that to Ms. Barrios, we will ensure that Ms. Boone gets a copy of it. State, do you have any position with regard to those three motions that the court just identified?
No, Your Honor.
Okay. All right, ma'am. So previously, Prison Break Investigations was already appointed to be your investigator. The JAC has no objection to authorizing $5,000 in costs for prison break and for $500 for obtaining case-related documents and materials on your behalf. So seeing as there's no objection, even though you were asking for a reservation, I'm going to go ahead and permit that cost to be incurred. With regard
what does
to
incur mean?
The costs for witnesses and the depositions, you are requesting, as I identified earlier, just to reserve those costs. And as I had said earlier, the motions do not identify who the witnesses are or what the deponents are. So I'm going to deny those motions with prejudice, but that means you can refile them and we can readdress them when you file motions in the future addressing any of those items for ensuring witnesses being subpoenaed or appearing for your defense at trial or for any persons that you may seek to depose. Because as of right now, I don't know who it is that you were seeking to depose based on your own motions. Do you understand the court's ruling as to those three motions, and do you have any questions, or do you want to add anything?
I would like to add, please.
Sure.
I would like to add, please.
With your delegated due date.
We knew that was the answer the whole time. Do you have any other questions? I would like to add, please.
Ruling as to those three motions, and do you have any questions, or do you want to add anything?
I would like to add, please.
Sure.
I would like to add, please.
And he's so chipper, too. Like, he's not that chipper by the end, but sure. Add. I'm sure you can contribute to the conversation. Ms. Boone, what do you have for us?
For delegated due date of July 22nd, for all of my pretrial motions to be committed, I have yet to receive my discovery, so I was trying to beat that deadline or at least meet it. So I don't know what I'm supposed to ask for or who I'm supposed to ask for, and again, I have yet to receive my discovery, so I don't even know who it is I need. So I understand for those, so you're telling me at a later date once I have that information to revise them.
I'm giving you the opportunity to refile them. Yes, ma'am.
Thank you.
With regard to the defendant's motion for reservation of proposed costs to
Big welcome, not intentional, has joined the chat.
hang on. With regard to defendant's motion for reservation of proposed costs to acquire expert witnesses for the defendant's defense in trial, dated July 18th, 2024, and received July 29th, 2024.
And this gets into, because Kitten Pusher's like the discovery that she'll never actually read a review in any way. Dumb bitch. And this gets back to why I think that 2018 lawyer interaction is so important in understanding the way Sarah's life spun out from there. Not that that moment was the spin out moment, but it changed the way that she looked at how lawyers worked. And I think from that point, she saw discovery as a cudgel that could be used to get her out of trouble. And by making a big deal about discovery, for some reason, she thought it would help in the murder trial because it worked so well when she was on trial, or not trial, but when she was arrested for strangulation battery. So that's my perspective anyway. I'm sticking to it.
Mr. Lake, anything else to add other than what is identified in your response?
No, Your Honor. Again, the issue here is, with the exception of the mental health expert that's already been approved, there would need to be much more specific motions for these costs. Ms. Boone needs to include essentially what we included in our...
Okay, so that's the thing. I don't think she ever wanted the discovery. I think she kept trying to make the discovery as hard as possible for them to give to her, either for being able to say, well, there's a discovery violation, so throw it away. I didn't, I have a right to it, and they didn't get it in time. And it's documented that I, wanted it and didn't get it. So there's that angle. But I think underlying all of it is that she never wanted the discovery to discover it. She wanted it because having it put in a box is a pain in the ass, and then having that box put into a computer was a pain in the ass, and having that computer changed back into a box of papers and then 3 fire retardant bags was a pain in the ass. And she thought, if I could just be a big enough pain in the ass, they're just going to let me go. And no, that's not how it works. Not for murder. Maybe for strangulation. Maybe in Florida.
And again, the model motions that we will be sending to will have that information. Without specific information, neither us nor the court can make an informed decision on whether the requests are appropriate.
Okay. Ma'am, the motion fails to identify any specifics. It has to be determined for your expert witness or
yeah, your motion fails at being a motion.
Witnesses. It does not identify the type of the witnesses. It doesn't identify the amounts, and it's difficult for me to identify the particular showing of need, which is what's required for the appointment of that expert. So again, I'm going to give you the opportunity to refile in the future a motion pertaining to any specific experts, identifying the specificity that JACS has requested in their response. So at this point in time, that motion is denied.
Denied. Welcome to Paula Nichols, another one to say. Everyone who's just joining in the recent minutes,
Jane Crow,
you're just here for the beginning of the Sarah Boone portion of the show. I wasn't able to schedule the show because I was having trouble sleeping and didn't know when I'd wake up.
Oh, quit whining.
Make sure that I got myself a full night's sleep. So I woke up, started a live, did a pre-show on some horrific women. And now that everyone's here, we're all enjoying each other's company. It's the Sarah Boone portion of the show.
Hey, Paige.
Without prejudice, and you'll have the opportunity to refile it. Lastly is the defendant's motion requesting immediate relief to the defendant by appointing effective standby counsel to aid and support and
And this is where Sarah Boone doesn't know what standby counsel is and doesn't realize that by firing every lawyer, she's not going to get a lawyer that just stands by and is her secretary, because she's already burned through all of her public attorneys.
Preparation of a criminal case for trial, dated July 18, 2024, and received July 29, 2024.
Big welcome to Kathy Callie. Good to see you from across the pond.
The request, ma'am, that you were seeking in that motion is to provide immediate relief to defendant by appointing effective standby counsel to aid and support in preparation of her criminal case for trial. State, do you have any position with regard to Ms. Boone's request for standby counsel?
No, Your Honor, other than what's already been placed on the record in the court's order.
Okay. Mr. Lake, anything over and above what's in your response?
Yes, briefly.
What, if I may, is over and above?
The point we would make, Your Honor, is I think Ms. Boone misunderstands the role of standby counsel.
You're absolutely correct. She doesn't understand the role of standby counsel. And from my understanding of standby counsel, mostly from trials like Darrell Brooks and Robert Tellez, but it's for a defendant that wants to go pro se, but may at some point decide, you know what, I'm wrong and I do want the public defender. And instead of having to have a big trial delay, the standby counsel who's already been there and advising on how to phrase a motion or, you know, how to say an objection can step in and immediately help take over the trial. But they're not going to give standby counsel to somebody who's fired 6 lawyers or, you know, gone through up to the public defender. Yeah, so she misunderstands it. Tell us about standby counsel. See if I'm correct.
Standby counsel is not co-counsel or assistant counsel to a defendant. Standby counsel is there for when in the situation where a pro se defendant who is elected to represent herself.
It's kind of interesting too, because it does look like Sarah's actually listening. She's like, okay, hold on. What is standby counsel? I know I want it, but fuck, that's what they do? Shit. I'm not going to get it, am I?
Decide at some point they want a lawyer, that allows the court to put a lawyer back into play at that point in time. In other words, it's a safety mechanism so that if a defendant who is asserted to represent themselves decides at some point they do no longer want to represent themselves, the court has a lawyer already in place so that the progress is not delayed. It is not an assistant or a co-counsel. It is someone whose role is.
She literally thought a standby lawyer meant a lawyer that would stand by and just like be the ask a lawyer. Psst, how do I make them stop doing this? Quick, case law.
Consenting not to get involved until the defendant says, I no longer want to represent myself.
Ma'am, the court's had the opportunity to review the case law on this issue. There is no constitutional right to standby counsel as decided by Paul versus State, 152 Southern 3rd, 635 at pinpoint 641 by the Florida 4th District Court of Appeal in 2014, citing to the Florida Supreme Court case in Jones v. State, 449 Southern 2nd, 253 at pinpoint 258 from 1984. As the court has determined that you have forfeited and alternatively waived by your conduct the right to court-appointed counsel, the court is not required to appoint standby counsel. That's Brown v. State, 45 Southern 3rd, 110 at pinpoint 114 through 115, Florida 1st DCA 2010, citing to, again, Jones v. State by the Florida Supreme Court in 1984. There is no Sixth Amendment right to simultaneously proceeding pro se and with legal representation by the Florida Supreme Court in 2009 in Shepard versus State, 17 Southern 3rd, 275 at 279. For the reasons that the court identified in its 16-page order previously entered, your request for standby counsel is denied.
I love the little look over too.
That is so good. I'm going to, rather than replay it, I know that prioristic me had fun with this. So let's just enjoy that, because he does look, he wants to see how she reacts to how summarily he denies it, but he also doesn't linger. Like, he knows better than that.
Do you have any other questions, ma'am?
How's she going to react to that? 1304. Just quickly looks over at her and then kind of right back to his notes.
Previously entered, your request for standby counsel is denied.
Little peek as she jump in the...
Do you have any other questions, ma'am, as to the court's rulings? This previously entered, your request for standby counsel is denied.
This looks like it's a long look, but he's so gray rock. He's not going to give her The satisfaction of looking for her reaction. Look how quickly he just gets back to business.
Do you have any other questions, ma'am, as to the court's rulings this morning?
First off, of course she has questions.
Not only
this is something to notice.
Not only do I have questions, I have a bulleted list of questions. First off, when can I get the ring?
In the early hearings with Judge Kraynick, is he often leaves it open-ended? Do you have anything else to say? Do you have any other questions? He starts really narrowing it down the more he deals with Sarah. Do you have anything else to say on the motion? Do you have anything further to say on this matter? But he starts narrowing it because he realizes anything else to say is way too much runway.
I'll check it out, Barbecue Queen. Thank you.
I did not forfeit my rights. You took them.
Your judgment. And also, I feel that I should have had some kind of evidentiary hearing prior to your decision. So
I feel like I should have had. Yeah, well, a lawyer could tell you whether you were entitled to what you feel like you should have had, but you don't have a lawyer.
Better explain myself, and you could have had a better understanding. So by you denying my standby counsel, which thank you to him for explaining to me what specifically it is, I don't want to be pro se any longer. So I
any longer
want to be pro se in the first place. And again, you, in my opinion, unlawfully denied me, or didn't even suggest an evidentiary hearing in order for me to avoid or try to go about a solution or remedy so you would understand. So I don't know if it's me either wasting your time or anybody else's time, if it's even an opportunity, or if it's just something that is denied, period.
It is denied, period. With regard to an evidentiary hearing, that seems to be in the realm of a Faraday inquiry where a criminal defendant is seeking to
Is it denied period or denied natural? Denied period. Thank you.
Represent themselves. And I would inquire of that person and have an evidentiary hearing as to the rights and remedies that you were forfeiting and the pros and cons of proceeding representing yourself and the benefits of being represented by counsel. Due to the Florida case law that was provided in the 16-page order, no such evidentiary hearing is required.
I wonder if this is a good time to get in on the 16-page order.
My understanding was the hearing, the Faraday hearing, is in regards to competency as opposed to having an understanding before you take someone's rights away.
Faraday pertains to a criminal defendant's seeking to represent themselves. Faraday was not applicable to your situation, and that's identified in the case law citations that were provided in the 16-page order.
Yes, I understand. It was the day of that I was...
Whenever she says, yes, I understand, it's never because she understands. It's, yes, please shut up. I'd like to say something.
Explain most of all of this, and as opposed to prior, so I would know what would happen or could happen. So my understanding is one thing, and then the explanation is another. So I'm just confused and feel that
I'm just confused.
That's
and
correct.
I had an opportunity prior to all of this to explain myself and to have a better understanding. So now my belief was that the evidence or the Faraday hearing was simply competency. So the evidentiary hearing I thought would be a collaboration of the information of why I wrote my letters in order for you to remove my right to counsel. In my opinion, I felt that it was a type of retaliation by the court because you did not understand or attempt to understand any of my letters that I wrote previously, which was for the intervention of the judge and or the court to avoid any of this with me sitting in front of you presently.
Ma'am, as identified in my 16-page order, I listened to every audio hearing.
I listened to every audio hearing. I've read every one of your letters. Poor guy.
That's crazy.
Yeah, she's complaining. If you were unable to hear Sarah's low-level whining there, her main complaint is in that little diatribe was, I don't know if you're just ignoring my letters, but you're not answering me. And he's like, I do read your letters. I read them to make sure there's nothing that I actually have to say back. Once I've determined that, I file them appropriately.
I specifically provided dates and times and words that were specifically said at particular hearings involving yourself and prior counsel. I also made reference in the 16-page order to statements that were made in your letters. I've promised you, I've read everything in the court file. I've read every single letter, and I've listened to every single audio.
The little thing her face does when he says, I've read every single letter. Like, oh, really? Even the ones to Wooten?
And that's the crazy part. Like, for how much she complained about, you know, oh, my case has been decided in the global court of public opinion. Oh, my case has been prejudged by the internet ruling, trying to sentence by anticipation. You ruined your own case. All those letters on the docket end up, you know, the judge has to read them. Ex parte communications, share them with the other side. Hey, I was contacted by this side. This is what they gave me. Didn't respond to it, but here it is. Now it's on the record. Totally prejudiced her own case.
You can probably see my pattern.
I also made reference in the 16-page order to statements that were made in your letters. I've promised you, I've read everything in the court file. I've read every single letter, and I've...
Kelia asks, have I read the 16-page order? I have not.
But I certainly can, now that Suze Watt has provided it to me. Speaking of provided, the Sasquatch blowing the dandelion was provided by Tammy Sellin here in the chat.
I've not. Maybe I'll do some reading for the Friday Night Ramble tonight. I've got a few documents. I don't know that I have the 16-page. Somebody's got access to that as a PDF. By all means, send it to Dan D True Crime at yahoo.com. No spaces for Dan D True Crime. Yeah, maybe that's what I'll do for tonight. I think we need a Dietz rest. I think it was a little too visceral. So I've decided to, if I'm going to do more Dietz coverage, I'm just going to do selections of his trial footage that are maybe not so visceral and do it as a combined video rather than an 8-hour marathon. We'll continue with Sarah here, but I think maybe tonight we'll do we'll just do readings. Oh yeah, it doesn't remember anyone reading it. Well, that's even better. Yeah, we'll do some live readings tonight. That's what we're doing. Thank you. I didn't really have an idea for the show tonight, and now I do. Tonight, Dan D, Friday Night Ramble, live readings. Classified Crime was good enough to provide me.
Spoiler, we didn't do that then, but I might do it now. Might not be tonight, but it'll be this weekend's Ramble. Might be tonight, too. We'll just see how I feel after we're complete here. You know, don't get ahead of yourself. Just one thing at a time, Dan.
It was some very early documents. I've read the Judge Wooten letter from March of 2022, but I think I still have 5 other letters that are in PDF form. And yeah, if we can find the 16-page order from Judge Kraynick, we'll put that in the mix because we're covering it today.
Listened to every single audio. That decision was not made lightly, and it took a lot of time to make that determination and that decision.
That decision was not made lightly. Can you imagine, like, after he reviews every letter in the court file just to take on this case, and he has to read all of the crazy, like,
okay, we're going to read it
and
after
then try
this.
and come in unbiased.
Which explains why it was also a 16-page order. That order stands, it remains. The court's not going to revise its findings or its determination as to your forfeiture, and alternatively a waiver by virtue of the conduct identified in that order.
Okay. I believe, in my opinion, the order is erroneous, and after I reviewed your 16-page order, there are quite a few incorrect entries, and some of them are based on perjury by...
You know what this is? This is a preview of Sarah's letter complaining about Judge Jackson's order. Have another listen, because we know she repeats herself. She repeats herself just like history. So if we go about 15 seconds back,
identified.
She's got a letter complaining about Judge Kraynick's letter. Judge Kraynick is like, yeah, well, I'm not reviewing the decision. The letter's the letter. Let's move on.
In that order.
Okay. I believe, in my opinion, the order is erroneous, and after I reviewed your 16-page order,
After I
quite a
refused
few
it.
incorrect entries, and some of them are based on perjury by the attorneys. And by you reading and then also listening to the audio, you did not listen to me in any way, shape, or form in order for me to explain myself better, so you have an exact understanding of the particulars of each letter for each attorney.
By reading my letters without talking to me, you're biased against me. You needed to talk to me so I could explain to you
the letters
one-on-one as peers, equals, as it were.
They weren't meant to be read without context.
I'm not going to revisit my prior decision.
I understand. I'm just trying to make you aware that it's my opinion.
You, and like we talked about last time, ma'am, you're certainly entitled to that opinion. All right. All right. My judicial assistant has been in contact with the representative from the Orange County Jail, Sergeant Donald Casey, who is on his way in order to facilitate the transfer of the USB drives from Prison Break Investigations. I do see that Mr. Lane is present. So as soon as he gets here, we'll be able to address that exchange.
There's about 15 minutes left in this video. We're going to save that and go directly into the 16-page order, which was just heavily referenced in the last few minutes of courtroom testimony. So this is it. This is the 16-page order. This is Judge Kraynick taking the totality of circumstances and making a decision that Sarah would have to be pro se. To wit, and that wasn't part of the letter. That's just me trying to sound, make it trumpet up a little bit. Order. This cause came before the court on June 28, 2024, on defense counsel Patricia A. Cashman's Esquire motion to withdraw as counsel filed June 11th, 2024. You know what? We're set. I've got this all set up. I'm gonna get myself back together. I'm gonna let this play. I'm gonna take a quick
What we can
break.
do
I'll
while
be
we're
back.
waiting for that representative to appear is address some of the things that were identified in the notice of hearing for
Phil for Dom Russo. I've seen you in a few chats from some other creators we enjoy together. I'm glad to see you in my chat. Welcome to the fine and dandy crew. Phil is obviously in favor of Dom Russo, who was one of the victims of Mackenzie Shirilla. So you can share your opinion on that too. Welcome to our little fine and dandy crew.
today, which is kind of a scheduling conference for when we might be setting up certain deadlines. As of right now, the trial is scheduled for October 7th. The trial will be extended from 2 weeks to 3 weeks. So the trial will take place on October 7th, October 14th, and the third week of October 21st.
So we know he scheduled 3 weeks knowing what a shit show it was going to be. That's perfect timing for the captions to be on screen. We know that Hurricane Milton, which is not a euphemism for James Owens coming in from Milton, Florida, but Hurricane Milton, the actual weather event, delayed the trial by 1 week after Judge Kraynick denied any delay. But the trial itself, I think, was over in a week. It must have started, was it the October 14th? And trial was over almost as quickly as the deliberations, especially in respect to the 3 weeks we were expecting. But pro se would have been a mess. It would have been, wouldn't have gone nearly as clean. And that's the one thing to give James Owens credit for. Well, there's a few things on a minor scale, but James Owens coming in at least allowed it to proceed like a trial, and with a lawyer making objections rather than Daryl Brooks objecting for things that were objectionable to him, but not objectionable in a court of law.
October 21st is not this division's normal trial week. However, the court has obtained coverage for that week so that should this trial proceed into a third week, we will not have to scramble in order to find coverage, and that we'll be able to efficiently proceed with any evidence or testimony on that third week on October 21. Pre-trial was scheduled for September 24th at 1:30.
Hey, Danielle, just missed you, but
typically
hello,
has
goodbye.
its regular trial case managements on that Tuesday. Due to Ms. Boone representing herself and some of the complex issues that may be involved in this case, I'm inclined to change the date of the pretrial so that we might be able to have our own pretrial separate and apart from all the other cases that may be set for that same trial period.
That was smart. He knew, I'm not going to schedule this to go from 9 to 11 on Tuesday, and I'm going to have another case that starts at 1 o'clock. Every day could be its own individual shit show, so I'm just going to carve out a week of time, of the court's time, to deal with it, or 3 weeks of the court's time, as he decided at this point.
My thought would be to move it to, rather than the Tuesday the 24th, to Tuesday the 26th. At 9 a.m.
We'll be watching more of the pretrial hearings as we lead up to the trial. I think I have just the playlist a little bit here.
Danielle, our
Phil
plan.
for Dom Russo, I think, was exposed to Dan D True Crime through the cooking collaboration I did.
There we go. Danielle, if you're okay with it, you can let me know in the chat, but I wanted to play a minute from each of your two videos, letting everyone know about the Kevin Beck news, as well as, what was the one before that? Oh, I've already lost my... Oh, Fuckface. Fuckface Virkins. Perkins? Vinkins. Vinkins? Virkins. Virkins said fuckface. Anyway, might not... Well, yeah, we'll play whatever part. Anyway, if you're okay with it, Danielle, we'll play a little of that just so that people know what we're talking about, and direct them to the two videos that you've put out very recently.
With Danielle Chavon, which is fantastic. True Crime through the cooking collaboration I did with Danielle Chavon, which is fantastic. Danielle Chavon and I did a little cooking with Dan D. We recreated a Lowell prison meal. Danny, my goodness, she did this prison tray, like if I was in prison, this would...
I'm going to do my impression of Danielle when she say, and then he told, no, fuckface.
Be the idealized, oh my God, it's actually really good.
Almost like there's that little breath. Fuckface.
But, just did it to the letter and did everything perfectly. I did this kind of Iron Chef style where I was inspired by every ingredient and, turned it into deconstructed this and reconstructed that. The baked onion bowls with baked beans in an onion bowl are probably the thing I'm going to make more often now that I tried it for the first time on that recipe. But glad you enjoyed that, Phil. And if you guys haven't seen it, in my shorts, there's a cooking short where I show how I make my recipe. And I think there's a link in the pinned comments for that, for Danielle's longer video. It's about a lot of other Sarah Boone stuff, but there's a cooking segment towards the end. Working together separately, but together on the same project.
Thursday? Yes, sir. That's Thursday.
That's acceptable to the state.
Ms. Boone, that would give you additional opportunity to prepare for trial as well. Are you amenable to changing that date to September 26th at 9 a.m.?
So an additional 2 days.
Just throwing shade. Like,
Heartache and
it
pain.
would have been the
Heartache and
24th.
pain.
Now it's going to be the
Welcome back.
26th. Are you okay with that? So, an
So you ended
additional
up-
2 days.
You would still have that time to prepare regardless if we had the hearing on September 24 or September 26. I'm just moving it so that we don't have 50 or 60 other cases and I can focus more attention on your case specifically.
Oh, well, if it means all eyes on me, then how can I refuse? Sounds like some main character energy you're throwing at me there, Judge Kraynick, so I'm going to have to accept this.
Of course.
Okay, all right. So pretrial will be rescheduled till September.
That's funny. He threw it out. I almost was like being facetious, but it worked faster than I thought.
Attention on your case specifically.
Of course.
Okay, all right. So pretrial will be rescheduled.
Of course. You finally understand me, Judge Kraynick. Please do go on. What else are you going to do for me?
September 26th at 9 a.m. One of the issues that I wanted to address was deadlines for production of the state's exhibits and the defendant's exhibits. Now, I'm mindful, Ms. Boone, that you have not reviewed some of the documents that may have been provided. I know most recently, Ms. Cashman spent 20 hours with you alone going over questionings and reviewing some of the materials. I don't know the breadth and scope of what was reviewed to you, but some of it may have been reviewed to you based on counsel's representations. State, I want to address with you first, because Ms. Boone hasn't reviewed the discovery yet, as to what your position is with regard to assembling or finalizing an exhibit list or your exhibits for trial.
As far as providing a list of the specific items that the state seeks entry of?
Correct.
Love that duster.
I do want it before pretrial. So let me just kind of lay the map for what the court's thinking. The court would have the state provide a...
I'm going to try and hot swap here. I think I've set it up so we can have a minute of Danielle's video. If this works. Okay, that's full screen. I think I want to go from 541. There was an official complaint
Dorm Officer Johnson
launched by Sarah about the treatment by a white-collared officer named Vickers. So let's give the floor to Danielle Chavon.
called me at 11:53 a.m. Wow, they checked in at 11 a.m. and she wasn't called until 11:53 a.m. I don't know if they were being processed or if they were just waiting around, but this is an inside look at the visiting at Lowell, the in-person visiting at Lowell. Number 2. Dorm Officer Johnson called me at 11:53 a.m. after he was called to have me report to VP. I don't know what VP is. Number 3. I need my people that have been incarcerated to let us know in the chat, what is reporting to VP? I think that's count, where they count the inmates to make sure that they're there. We'll continue with less commentary. 3. I ran to be at count from being called so late and to not miss any more time. 4. Vickers was at the VP door, asked who I was and where I'd been, stating, quote, "Your visit has been here over 40 minutes, end quote. 5. 5. I said the officer just called me. He can radio him to verify for understanding. I'd been waiting on VP. Johnson confirmed. 6. Vickers opened the door where I thought he was allowing me to finally go in and attend my overdue visit. 7. Vickers then yelled, quote, "Not you, fuckface," and Forbes heard him say, walked out instead.
What did he say?
Vickers then yelled, quote, "Not you, fuckface."
I didn't quite hear that.
then yelled, quote, "Not you, fuckface." 7. Vickers then yelled, quote, "Not you, fuckface."
My God.
And Forbes heard him say, "Walked out instead. Then they just left me outside." Oh, then Sarah gets a
If you want this complete story, you need to go to Danielle Chavon and see this video. It's 29 minutes and 54 seconds long. It's her second most recent video. Don't miss out on the most recent video. That one's about Kevin Beck. We'll check that one out later, but that was just to give you a taste, just so you know that this is out there. This is out in the ether. It's out in the internet tubes. Danielle Chavon brought it to us, and I'm bringing her work to you. But it's her work, so check it out on her page. Give her the view, give her the like. Subscribe to Danielle Chavon. Now let's get back to the dusters of the prosecution.
Exhibit list and a witness list by X date. Ms. Boone would have the opportunity to look at that list. We would then have a hearing where all of the exhibits would be shown to and provided to Ms. Boone. They would be provided on a USB thumb drive. They could be utilized with a laptop at the jail. And then she could view all those exhibits here in open court.
Thank you, Danny.
And then she would be afforded the opportunity to make an objections in writing to any exhibits at a later time by a certain date.
I guess one of the concerns would be that if the state...
Is that Mr. Cacciatore wearing a duster?
Yeah, I was impressed in the first time.
That's a pretty sweet long jacket. Like, that's the kind of jacket that that Cake likes, the lead singer of Cake likes girls in short skirts wearing. That's a fantastic looking long jacket.
Identify specific items.
Oh, yeah.
Yeah, good
Mr.
looking.
Cacciatore.
Good looking Mr. Cacciatore.
Like a 1930s detective.
If you like the cut
Brown
of Mr.
shoes and
Cacciatore's
a
jib,
long jacket.
That we would seek.
If you like the cut of Mr. Cacciatore's jib, make sure you continue watching this trial coverage, because we do spend an extended amount of time looking at his yoga class during the jury instructions towards the end of the trial.
Entria, depending on the course of the trial and the question.
Hey, Malgarita's feeling
other,
the same.
Items that have already been disclosed in discovery that may necessitate being entered in, would potentially not be part of this original witness.
Oh, let's just be a little sneaky here, too. Can we see any of these screens?
We can't. I tried.
No. There was a motion before where they were warning the cameramen, like, you can't be focusing in on.
Now, the interesting thing about that motion, we do get to it later, and again, it shows Kevin Beck, questionable Kevin Beck. Immediately after Judge Kraynick warns the courtroom, and particularly the cameraman, don't show the laptops, don't zoom in on the screens. Kevin Beck, for the first time in the trial, was holding a laptop, looked like he never held one before, and is just shoving it in the face of the camera as intentionally as unintentionally could look, I guess. I don't know if he's trying to, get the whole thing thrown out. Well, you were showing my laptop after. Stupid Kevin Beck moment. We'll make sure we revisit that in the best of.
The screens of the defense or the counsel. I really thought we were going to get that yellow legal pad. That looked like I was going to get Sarah's notes. That would have been gold. Fortunately.
Are you kidding? That Philip Dubois guy was making fun of Mr. Cacciatore's jacket? No, Mr. Dubois. I beg to differ.
Probably sort of thing other people tried to zoom in on at the time.
Exhibit list. Items that were in the discovery, but if that makes sense.
That does make sense, yeah. And I understand what you're saying. And that seems to be more of a fluid situation as to what may happen at trial, right?
Sure. I don't imagine the court's intent would be for the state to just produce the exact witness lists that have already been sent in discovery and just make a notation of every item of evidence. The idea would be to try to pare down.
That's exactly the idea. Now, obviously, that wouldn't foreclose you if something was produced in discovery and something that would not be relevant or admissible at a certain stage of the trial, but maybe later became relevant or admissible due to something that happened or something that was said. I would not foreclose the state, nor would I foreclose Ms. Boone.
Every girl in chat crazy about this sharp-dressed man.
From attempting to move that piece of evidence into evidence for the jury to consider. But it would be almost like civil
I'll hold the phone for you.
conference where you and opposing counsel would go over what your exhibits are prior to proceeding to trial. And I think that's important to do that so that Ms. Boone has the opportunity to view those in court, so that's on the record as to what she's reviewed, and then give her the opportunity to provide any objections, if any, to any of those exhibits. And again, I wouldn't foreclose you if you want to use items A, B, and C, and that's all you intend on using. I don't know what you intend on using. I don't know what evidence you have. If you only want to use and only show A, B, and C, but are saving D, E, and F for later, depending on what happens, I won't foreclose you from...
Super Kelly G says, I thought Cacciatore got called to court unexpectedly and didn't have a jacket, so he had to keep his coat on in the courtroom. That wouldn't explain why Mr. J is wearing a matching duster. And you'll see Mr. J pops up with little advice for Mr. Cacciatore, maybe immediately after this pause. Probably not, because that would be too perfectly scripted. But Mr. J also, not known for his fashion, wearing an equally fashionable long jacket.
Readdressing D, E, and F. But it's just an opportunity to address what it is you think you're going to be seeking into evidence at this time.
So essentially...
There we go. That was pretty skookum.
What'd I miss?
Go ahead, sir.
So,
Sorry, I got to see what they were talking about. Probably didn't miss much, but go back about 12 seconds.
To be seeking into evidence at this time.
So essentially...
Yeah, I got to give credit to the microphones because Mr. Cacciatore's loud and clear. I didn't hear a damn word that Mr. J said.
Go ahead, sir.
So, I think we could
Probably a pocket. He's pressing a button on and off.
accommodate that if we could go around September the 1st for that, and then that would give her an opportunity to review that USB and lodge any objections.
That's right, Victoria. Top corner, bottom corner. I'm here.
Address those objections and go from there.
Okay. And that would be September 1 to have the evidence viewing, for lack of a better word, or for the list to be...
That's a special look, too. So Mr. J's long jacket has that tight neck collar as opposed to the flattened out detective-style trench collar of Mr. Cacciatore's.
Provided.
For the list and the USB.
Okay. We're going to make this work for an October 7th trial date, Judge. I think September 1st is probably about the right time frame to have this in-court hearing.
Hey there.
All right. That was the end of that clip. I think, and I'm just speculating here, but I think that you guys want to hear that report one more time.
Finally, go in and attend the visiting at me at 11:50 and visitation.
So if you're just joining us, Danielle Chavon has been putting out some fire videos. This one was released 19 hours ago. I'm the 639th like. A white-collared officer named Vickers called Sarah Boone a fuckface. Can you believe it? Sarah Boone. Fuckface. So here's the chain of events that led to her being called fuckface and narrated by Danielle Chavon. Here we go.
For withholding me from utilizing all of my rightful time to visit with my family. Number 1, visitation. My family checked in around 11 a.m. as planned. 2, dorm officer Johnson called me at 11:53 a.m. Wow, they checked in at 11 a.m. and she wasn't called until 11:53 a.m. I don't know if they were being processed or if they were just waiting around, but this is an inside look at the visiting at Lowell, the in-person visiting at Lowell. Number 2, dorm officer Johnson called me at 11:53 a.m. after he was called to have me report to VP. I don't know what VP is. Number 3, I need my people that have been incarcerated to let us know in the chat, what is reporting to VP? I think that's count, where they count the inmates to make sure that they're there. We'll continue with less commentary. 3, I ran to be at count from being called so late and to not miss any more time. 4, Vickers was at the VP door, asked who I was and where I'd been, stating, quote, your visit has been here over 40 minutes, end quote. 5, I said the officer just called me. He can radio him to verify for understanding. I'd been waiting on VP. Johnson confirmed. 6, Vickers opened the door where I thought he was allowing me to finally go in and attend my overdue visit. 7, Vickers then yelled, quote, not you, fuckface. Vickers then yelled, quote, not you, fuckface. 7, Vickers then yelled, quote, not you, fuckface. And Forbes heard him say, walked out instead. Then they just left me outside. Oh, then Sarah gets a response. It's your grievance. Not you, fuckface. 7, Vickers then yelled, quote, not you, fuckface.
So there you have it. Sarah was called fuckface by Vickers. I don't know who this Vickers guy is, but his judgment sounds sound. Love to have Mr. Vickers on the show if you ever want to do an interview.
Hey there.
I'm Dan D. I would love to talk more about your assessment of Miss Fuckface. I'm sorry, Sarah. Easy to get those two confused. I can see how we got into the problem in the first place. Before we move on to Fine and Dandy Clip 3, this is a long one. This is the one, this is the show. It's almost 3 hours long. It's from the Pro Se days. Some highlights include a battle with Mr. Shevenell. Mr. Shevenell is actually Scott Shevenell, who is a lawyer for the jail and speaks up a number of times, more often than he has to. Got a lovely shade of snark and just the perfect tone for dealing with Sarah. So we have that to look forward to, but it's a 3-hour clip, so we're going to take our time with it. And before we go immediately there, we will go to a little bit more transcript read. I don't even know where the transcript is going from this point, to tell you the truth. But we'll read it. We'll see if it stays interesting. If it's interesting, we'll do more of it. If it's less interesting, then we'll do less. There's the transcript screen. This is page 7. Hold on, that's the judge's 16-page order. I have the judge's 16-page order up. We're not going to read the transcript yet. I have the order ready to go. Is it super ready? Is it? That's it. Okay, it's ready. Pivot, hard pivot. We're doing the 16-page order. This is the order that Judge Kraynick wrote and repeatedly referred to. So every time that Sarah tried to litigate it, well, I think you were wrong, I have to reject it. No, not rejecting it. The order is the order. I'm not revisiting it. I'm not discussing it. I spent a lot of time thinking about it. And now here it is. Oh, let me change the scroll because this is, okay, the scroll's gone. We'll keep up. Yeah, okay. Okay, and how's this? Let's see. Anyone wanted to know what my palm looked like? Maybe there. Is that a good? Yeah, okay. Okay, that's a... Let's read. Do we need music for the background? Probably not. We're doing it live. We're doing it live.
fuckface. Put it in the monitor. We'll do it live. This cause came before the court on June 28, 2024, on defense counsel Patricia A. Cashman Esquire's motion to withdraw as counsel filed June 11, 2024. The court, having reviewed the motion, having reviewed the court file, having reviewed the audio transcripts from various hearings, having considered the positions offered by counsel Patricia A. Cashman Esquire, having considered the testimony offered by defendant Sarah Boone, and having considered the positions offered by counsel for state, hereby finds. Charges. A. On March 23, 2020, by way of information, the defendant was charged with second-degree murder. B. On February 26, 2020, the Office of the Public Defender, 9th Judicial Circuit, in and for Orange County, Florida, the Public Defender and Attorney Number 1, was appointed to represent defendant. Oh, this is a history lesson. This is bringing, okay. Attorney Number 1, what's your name? C. On March 9, 2020, the Public Defender moved to withdraw due to defendant retaining private counsel, to wit, Mauricio Padilla, Esquire, and the Padilla Law Group, Padilla and Attorney Number 2. On March 11, 2020, that certain order allowing withdrawal was entered, which withdrew the Public Defender from further representation of the defendant. So, okay, just for perspective then, less than 3 weeks after the incident, Sarah already had 2 lawyers. Although, not crazy, like, had one appointed to her, had a different one, so the one appointed left. So 3 weeks, two lawyers. E. On April 18th, 2022, this is 2 years later, Padilla moved to withdraw due to, quote, irreconcilable differences arising between undersigned and the defendant that have made it impossible for the undersigned to effectively represent his client. As always, it is difficult to convey all particulars to the court, and at the same time maintain all duties to the client, end quote. Reading between the lines there, that's the sort of statement that you have to make as an attorney, I'm guessing, when saying more would violate the attorney-client privilege, but you still need to convey to the judge that you've been asked to do something that is outside the bounds of standard ethics. So it's a loaded statement. It's and I'll read it again, but now listen to it with the tone of, this is a lawyer saying my client asked me to do things that I can't do, and I can't tell you about it, so this is how I'm telling you. Irreconcilable differences between the undersigned and the defendant have made it impossible for the undersigned to effectively represent his client. As always, it is difficult to convey all particulars to the court and at the same time maintain all duties to the client. This motion was served upon the defendant, and defendant confirmed receipt. See letter dated April 20th, 2022, and filed on April 26, 2022. That's interesting. If I remember that date, April 20th is one of Sarah's letters. So he just took that letter as, oh, well, there's confirmation of receipt. Boom. Ignored like all the whining, all the jibba jabba, all the nonsense, and like, oh, okay, so you've confirmed that you did get that letter to withdraw from Padilla. I see that you've been notified, and I can now certify that. This is page 2 of 16. On April 29th, 2022, a hearing was held on Padilla's motion to withdraw. At the time of the hearing, Padilla had been representing defendant for 2 years. Defendant was present for the hearing and was sworn. The court advised Padilla that the court had received a letter from the defendant, a letter dated April 20th, 2022, and filed on April 26, 2022, which seemingly objected to Padilla's withdrawal. The court advised Padilla that the options were not to proceed on Padilla's motion to withdraw or provide the court more about the irreconcilable differences. Padilla requested an opportunity to amend the motion to address the irreconcilable differences. The court reserved ruling on Padilla's motion to withdraw, gave Padilla until May 3, 2022, to prepare and file an amended motion with a hearing to be heard on the week of May 9, 2022. The state advised of Padilla's diligence in preparation, and the court commended Padilla's work. Defendant testified to a lack of trust between her and Padilla. G. On May 4, 2022, Padilla filed an amended motion to withdraw, which supplemented the original grounds. Subsection 1, paragraph 2. Undersigned's relationship with the defendant has become adversarial. The aforementioned adversarial relationship has interfered with undersigned counsel's ability to effectively represent his client, especially preparing for trial. Subsection 2, paragraph 3. Undersigned appreciates the court providing him the opportunity to amend his previously filed motion to withdraw. However, after further researching the issue, undersigned is still under the belief that the specifics of the adversarial relationship may disclose information that may prejudice his client, as well as will stand mute. And as such, will stand mute on the specifics. So that speaks to what I was just saying. Basically, I'd love to say more, Your Honor, but anything more I say would actually get her in trouble and violate the whole relationship that we have as attorney and client. So respectfully, not going to do it. Going to H. On May 6, 2022, Padilla filed a second amended motion to withdraw, which further supplemented the original grounds. Subsection 1, paragraph 3. Undersigned relationship with the defendant has deteriorated to a point where the undersigned counsel can no longer give effective aid in the fair representation of Ms. Boone's defense. This motion is in compliance with Florida Retired Judge Administrative 2.505, Rule 4116B. Rules regarding the Florida bar are present, or whether the attorney-client relation has deteriorated to a point where counsel can no longer give effective aid in the fair presentation of a defense. I'm not going to read the footnotes about irreconcilable difficulties. Don't think. I'm scanning them to see if there's anything. No, there's nothing good. You want to pause it, you can read it yourself. Item I, May 10, 2022. A hearing was held on Padilla's second amended motion to withdraw. Defendant was present for the hearing and was sworn. Padilla advised the court that he had no other choice to file the motion due to ethical concerns. Defendant confirmed that she wanted to terminate Padilla as her attorney. The state expressed concern of a strategy to allow defense attorney after attorney to represent defendant. The court advised defendant of the state's concern regarding a strategy of defendant being unhappy with every attorney and advised defendant about the dangers of self-representation. For the record, this is on attorney number 2 that this is happening. Well documented, Judge Kraynick. The court appointed public defender. Okay. The court appointed the public defender, attorney number 3. J, on June 6, 2022. And by the way, I can't check chat while I'm reading, so if you see this screen up, it means I can't really be looking down here. So apologies if there is anything that I need to get to in chat. Remind me after I finish reading. J, On June 6, 2022, the public defender moved to withdraw due to a conflict. K. On June 7, 2022, that certain order allowing public defender withdrawal was entered, which withdrew the public defender from further representation of the defendant and appointed the Office of Criminal Conflict and Regional Counsel, RCC, Attorney 4. On June 10, 2022, RCC moved to withdraw due to a conflict. And just for the record here, the conflicts aren't Sarah's fault. They could be, maybe, ripple in a pond effect her fault. I think one of the counsel's conflict was that they'd represented George in a previous matter. So that, maybe Sarah's fault. But these are just conflicts. There's nothing she could do about it. She was appointed the lawyer. Hey, can't do it because of XYZ. So less serious than the ethical, the Padilla withdrawal. Of these first 4 lawyers, Padilla is really the only serious one. Like, really? 2 years in, you're going to give up? Let's move to L. On June 10, 2022, RCC moved to withdraw due to a conflict. That's the Regional Counsel. On June 22, 2022, that certain order allowing the Office of Criminal Conflict and Civil Regional Counsel withdraw was entered, which withdrew RCC from further representation of the defendant and appointed Mark Consuelo and Attorney Number 5. On July 8, 2022, the Consuelo moved to withdraw due to a conflict. The Consuelo. Maybe it's a team of attorneys. On July 11, 2022, that certain withdrawal order was entered which withdrew Consuelo from further representation of the defendant and appointed Frank J. Bankowitz, Attorney Number 6. And that's where we started our stream today. On July 12, 2022, Bankowitz in open court requested a continuance due to his recent appointment, and same was granted. Thereafter, the court set a pretrial conference for October 25th, 2022 at 9 a.m. and trial during the trial period beginning November 7th, 2022. On October 25th, 2022, court held the pretrial conference and addressed the court's understanding that a continuance was being sought and the court's judicial assistant was to reach out to the parties to confirm if a continuance was being sought. October 27, 2022, Bankowitz filed defendant's motion to continue. Next day, court entered a certain amended order on defendant's stipulated motion to continue, which set a pretrial conference for January 17th and trial during the trial period beginning January 30th. On November 22, 2022, the court set a status hearing. On December 19th, 2022, Bankowitz moved to withdraw due to irreconcilable differences which have arisen between the undersigned, his client, and his family. The undersigned will be his family. Why didn't I notice that detail? The irreconcilable differences which have arisen between the undersigned, his client, and his family, the undersigned will be unable to effectively and properly continue representing the defendant herein. Wonder if his family got contacted by flying monkeys. That was December 19th, 2022. On December 20th of 2022, the status hearing was held. Bankowitz did not appear due to a car accident. The court reset the status hearing for December 22nd, 2022. On December 22nd, 2022, the reset status hearing was held. Bankowitz appeared virtually. Due to technological issues, Bankowitz was unable to hear the court. The court reset the status hearing for December 27, 2022. On December 27, 2022, a hearing was held on Bankowitz's motion to withdraw. Defendant was present for the hearing and was sworn. The court advised the defendant that the court had received letters from a defendant, the letter dated October 3, 2022, and filed on October 7, 2022, a letter dated November 3rd, 2022, and filed on November 7th, 2022, and a letter dated December 5, 2022, and filed on December 14th, 2022. The court conducted a Nelson hearing, and defendant was not seeking to remove Bankiewicz. Bankiewicz advised the court of the thousands of pages in discovery that he had reviewed and organized, and his contact and potential use and collaboration with expert witnesses, including experts that Padilla, attorney 2, utilized. Bankiewicz advised the court of defendant's attempts to call Bankiewicz at a rate of 5 to 10 times a day. Bankiewicz further advised of his efforts to balance the demands of other clients with the defendant's expectations for communications. In response, defendant riposted. I know riposte, that means like a quick reply, like a rebut kind of thing. In response, defendant riposted. I wish I knew how to pronounce it. Seems like the kind of word you only read. Okay. Bankiewicz further advised of his efforts to balance the demands of other clients with defendant's expectations for communications. In response, defendant riposted that Bankiewicz's representations were untruths, raised Bankiewicz's prior public demands for lack of communication, alleged Bankiewicz's action in this case rose to a similar level, and then sought to remove Bankiewicz. The court pointed out that the defendant's inconsistent statements within minutes of them being made, and the court pointed out defendant's inconsistent statements within minutes of them being made and addressed concerns over defendant's motivations, especially when there is something defendant disagreed with. The court specifically advised defendant that she is, quote, not entitled to an endless line of court-appointed lawyers until you find one you personally prefer, end quote. And then a couple of little footnotes. The November 3rd, 2022 letter sets forth ad hominem attacks on Bankiewicz's professionalism. See page 2. The December 5, 2022 letter sets forth ad hominem attacks on Bankiewicz, including severely mislead and neglect. See pages 2 to 3. The court also explained the circumstances where defendant could represent herself. Ultimately, defendant did not request to remove Bankiewicz. The court denied Bankiewicz's motion to withdraw and directed Bankiewicz to have a conference with defendant prior to the pretrial conference previously set for January 17, 2023. The case was continued several times due to Bankiewicz's attempts to retain an expert through JAC and JAC's response to same. During this time period, the court had received several letters from defendant, a letter dated January 10th, 2023 and January 17th, 2023, a letter dated March 22nd, 2023, and filed on April 14th, 2023, a letter dated April 6th, 2023, and filed on April 14th, 2023, a letter, my God, okay, for somebody who likes the Oxford comma, he omitted it in this particular, you guys can see the dates. There's a letter on Jan 10th, March 22nd, April 6th, May 15th, June 29th, and August 2nd. And they were all mailed about 5 days afterwards. And yeah, he omitted the Oxford comma here. I don't use the Oxford comma either. It's not a Canadian press style thing. You want economy of space. So unless it's confusing, you omit the Oxford comma. Anyway, moving on. On August 22, 2023, Bankiewicz again moved to withdraw due to Section 1, Paragraph 2, irreconcilable differences arising between the undersigned and the defendant that have made it impossible for the undersigned to effectively represent his client. As always, it is difficult to convey all particulars to the court and at the same time maintain all duties to the client. That's word for word what Padilla wrote. I bet Frank Bankowitz calls Padilla, how did you get out of it? Well, what did you write? Okay, well, I'm going to write the same fucking thing. Jesus Christ, he won't let me out. He won't let me out. All right, so the footnotes here, see defendant's quasi, that's a good one. Quasi means not real. So see also defendant's quasi ex parte motion. So sort of ex parte, but not quite. See defendant's quasi ex parte motion for appointment of defense forensic psychologist and request for sealed order e-filed. Okay, so that was on the record, but is now sealed. January 10th letter, ad hominem attacks on Banquet's professionalism. May 15th letter, ad hominem attacks on the court, on Judge C. Wooten. The fact that he's being monetarily compensated from third parties' use of information that is publicly available. June 29th letter sets forth ad hominem attacks on Padilla, which were not raised during the April 29th hearing or the May 10th hearing on Padilla's motions to withdraw. See page 4. God, this is like Sarah's mess somehow tied into an exquisite package by Judge Kraynick. There's so much like loose shit, loose ends, and turned it into a rather becoming little package. The defendant will not be satisfied with any attorney unless said attorney does not have a caseload and can dedicate his or her time solely to Miss Boone's case. The best possible avenue is to have the defendant represent herself, as no attorney can satisfy her. So that was Bankowitz saying that. That's not Judge Kraynick's motion yet, but it's interesting that he includes that quote as part of his rationale on page, what is this, page 8? We're halfway through. I'm going to leave it at halfway. We'll go back to the video and we'll come back to this motion later because this is fun, but it's kind of nice to keep it. Well, it's nice for my throat to just watch instead of read. So we'll read this last one. We'll let Bankowitz get dismissed, I think, but we'll leave the Cashman for later. On September 8th, 2023, a hearing was held on Bankowitz's motion to withdraw. Defendant was present for the hearing and was sworn. Bankowitz addressed defendant's derogatory statements, i.e. dud, buffoon, and berating behavior. The court advised the defendant that the court had received letters from the defendant, a letter dated August 26, 2023, and filed on September 7, 2023, and a letter dated August 30, 2023, and filed on September 7, 2023. After the court's colloquy of defendant and her acquiescence to Bankowitz's withdrawal, the court granted Bankowitz's motion to withdraw and appointed Winston Hobson, Attorney 7. Thereafter, the court set a status hearing for October 30th, 2023 at 10 a.m. and set a pretrial conference for November 28th, 2023 at 9 a.m. After setting these dates, the court pointed out the deterioration of the working relationship between defendant and Bankowitz. The court further cautioned that if this becomes a problem with another court-appointed attorney, I'm going to look more closely at what the alleged disputes are. The court further advised that there are certain decisions the attorney gets to make and certain decisions the defendant gets to make, i.e., go to trial and or testify. The court cautioned the defendant's unrealistic expectations regarding court-appointed counsel and reminded the defendant of her right to retain private counsel. On October 30th, a status conference was held. Hobson advised to his conversations with defendant and setting a status of January 2024. All right, so that'll take us to January 2024, which is crazy to think how much happened in that year. So at the beginning of the year, Winston Hobson is her attorney. This moves to Patricia Cashman. It moves from Cashman to Pro Se Summer, hazy shade of Pro Se Summer, which is what we're going to be getting into next. And continues to the till Hurricane Milton blows in, and Owens, Henderson, and Kevin Beck all get deposited on the Orange County Courthouse steps. Let's move to, I think that's, that looks like it's where we want to go.
Our live stream's just too damned long. Do you wish somebody would just take a chunk of that stream and turn it into a standalone video? Well, here it is.
If the information is out there, the discovery in this case has been public, there's no reason to close a hearing that's simply going to discuss things that have already been made public.
This is a media lawyer?
I think heightened public attention only increases the need for transparency. Closure of judicial proceedings is a drastic remedy, and I don't believe the plaintiff has met her burden in this case, Your Honor.
Okay.
Unless you have any other questions.
I do not.
Thank you, Your Honor.
All right. Any closing remarks from you, Ms. Boone?
100%, yes.
Yes, Your Honor.
Yes.
First, I'm only asking for this one hearing.
Right. This will be the last thing I ask for. I'm only asking for one thing. I don't know why you guys are so unreasonable. I asked for one thing, just one thing. I've never asked for anything ever before in my life, ever. You guys won't give this to me? Just one thing.
Hairball Yarn reminds us that Cicero invented shorthand. Did not know that. But I have seen Cicero abbreviated as CIC. Is that part of the first shorthand?
Which is a very important hearing. I believe
Now it's important. Well, if it's important, the media should be there, right?
that the press is simply in it for ratings and publicity.
I think you said that in your initial argument, but go ahead and repeat it because it was very effective.
My evidence
I think the press is just trying to press themselves into my case, literally into my case.
is active. And I'm trying to salvage the little bit of anything that I have.
Salvage is something you do with a sinking ship. Sarah, you're correct. Your case is a sinking ship.
Pertaining to my evidence that is not available online, which would be in that hearing. And I also...
Hello, Margaret Adam.
She was speaking in regards to once discovery has been received, that is therefore public record. I just received my discovery for the first time, and I'm still reviewing most.
We'll clarify on the drunken history I reported from Hairball Yarn. No, Dan D. He invented the shorthand that stenographers use to record speeches before computers. Okay, well, there we go. Welcome to the chat, Raintree. Glad you're having a good time here. We still have lots to go. We've just jumped into, this is a 3-hour clip from her unshackled and unprepared hearing. Really looking forward to her battles with Scott Shevenell from the lawyers, the JAC, lawyer for the jail. But lots to look forward to yet. We're going to read the other half of the 16-page order before we go today. And we may even revisit Danielle Chavon saying fuckface.
If not all of it. And I have not had the time to go through all of it, but I literally, on the record, just received my discovery to even have an opportunity to prepare.
And Charles Grieve, correction there. She just received her discovery for the 9th time.
Look how fresh-faced I look with my short haircut.
Or no. Oh, hold on. Just received her discovery. To even have an opportunity. Hold on. Let me just go back a little bit. This is about getting her discovery. What is she saying? She just received her discovery. Oh, and this is where she gets it wrong. Once discovery has been received, that therefore is a public record. Right. Your discovery was received in 2020 with your first attorney. The attorney receives the discovery. Boom. Received. Public.
Received my discovery for the first time, and I'm still reviewing most, if not all of it. And I have not had the time to go through all of it, but I literally, on the record, just received my discovery.
She does not have the time to go through all of it, even though she's in jail and supposedly has endless amounts of.
To even have an opportunity to prepare to review any of that. And in regards to the hostile publicity, I have letters, I have messages, I have tablet information.
I have letters, I have messages, I have tablet information from around the world, just like Pitbull, worldwide.
I have an entire folder dedicated to publicity in more than one way as being hostile, good, bad, ugly.
Remember that. She has a folder of all publicity, good, bad, ugly, hostile.
I bet she keeps it in the red folder for Lana's love.
The reason that becomes important is she starts itemizing all the shit she has in her fireproof bags. She talks about having 2 folders. She's wasting one of them on her publicity rather than her case.
It's publicity. This will incredibly enhance my inopportunity to have a fair trial because of the
Incredibly enhance my inopportunity. Words that have never been said together in a sentence right after each other. Look at that. Literally got smoke coming out of my head. Like literally.
already millions of viewers that I have in my case, literally in my case. This would just contribute to it.
Don't say literally in my case when your crime is literally locking someone in a case. Note to criminals.
Even greater because of the already millions of viewers that I have in my case, literally in my case. This would just contribute to it even greater. I'm not asking for all hearings to be.
That one I'll give Sarah. That's way better. Like she really worked. The press is trying to press themselves into my case. That one, that was labored. Literally in my case. That was pretty good, Sarah. Like that. That's how you use metaphor, analogy, simile, whichever one that is. That's how you do it. Return on that. We'll give you credit where credit is due. Even a broken clock is even a broken clock is right twice a day.
And rolling along, just so you know, it's all practical sound effects here on the Dan D Show. I don't have a soundboard, so when it comes to ringing a bell, that's what I do. I do it for you.
Same way, Sarah's grammar choices can be right by accident, I think.
An opportunity to have a fair trial because of the already.
We're going to take a break for the Daily Double. I invented shorthand.
Millions of viewers that I have in my case, literally in my case. This would just contribute to it even greater. I'm not asking.
Because, yeah, we definitely were literally in her case. There was people, well, she might be referring to Tanika getting into her docket. But, yeah, there's people like both in her case, you know, oh, what's going on? And actually literally in her case files. Tough luck, Sarah. That's what you get for doing crimes in Florida. Love the sunshine law. I'm walking on sunshine, yeah.
I ended up doing the Walking on Sunshine spoof almost immediately after this episode.
Don't it feel good?
Ooh. Closed. I've not had an opportunity to review my discovery, which I just received. I have an entire folder and more information and letters and evidence in regards to publicity, hostile, any type of emotion that you can come up with. I have received.
Any type of emotion that you can come up with, I have received. I don't think that's true. I don't think she's received letters with pure love, affection. You know, there's scammy ones, but not pure. So no, right off the bat, I came up with a couple.
From Australia being the most recent. So
Australia. Oh, I gotta love Australia.
Isn't it funny how Australia is the most recent in this video and is like the last one, last man standing, last rat on a sinking ship? And no offense to rats, just using the rats on a sinking ship analogy. No personifications of people, intentional or otherwise.
Shout out to Australia. Australia, you keep pushing the UK. You are occasionally getting in there for third.
And this is where I didn't quite realize that when you say shout out to Australia, it can mean two different things in the Sarah Booneverse. But at this point, I'm just commending Australia for pushing the UK as far as third highest international audience of Dan D True Crime. But, you know, shout out to Australia too. For all that Miss N gets, kind of, I don't mind her being a pen pal. Like, I think that a lot of prisoners need a pen pal. It's probably the only way for them to, get out what they have to, so that they don't need to get their vileness out on, the general public. So it's a good outlet and resource. The biggest issue I have is the whole helping and assistance and, doing recon and that sort of thing. But it sounds like some of that is maybe being taken care of by Mr. Beck. Watch Danielle Chavon for more.
Highest fans of Dan D True Crime. I see in those geography reports. So love the Australians. Yeah, I understand why Sarah's excited about having Australians care about her case. It's pretty impressive to me to have Australians give a shit about what I'm doing. So another one that I'm with you, Sarah. Doesn't happen often.
I do not believe just because they would like to, again, in my opinion, for ratings and for publicity. It's one hearing. There also is a solution that I believe, my understanding was that this could be held at the Orange County Sheriff's Department.
Stick a pin in that. Stick a pin in that. She's arguing it out. And why do you have that impression, Sarah?
The question was in regards to transport, which is a possibility. It was a matter of the decision being with the court.
Look at the judge just sitting there like a photograph, too.
Properly prepare for this, would I have received everything prior as everyone else did? Having the internet would have helped also in regards to receiving the notice via email. As everyone else had, I'm sitting in front of you, yes, unhandcuffed, but I am unprepared for this rebuttal in regards for me to have privacy, expected privacy to a certain degree, and by law, to have this one.
I'll take a quick second here. The silence of the goats has broken the silence and spoken up in the chat. First time here. Hello, everyone, and good evening. Good evening to you. It's a morning for me here on the west coast of Canada, the North American continent, but maybe you're one of the Australian viewers that fan of Dan D and as far away as Sarah Boone's fans. In any case, welcome to the chat. It's fine and dandy here. We're glad to have you.
One hearing closed. And we also have an active case that is ongoing, active evidence, and there's a solution for it to be held at the Orange County Sheriff's Department as well.
Okay. Anything else from the state?
I wasn't going to bring it up until after the ruling on the motion, but
Mr. J wasn't going to bring it up until after the ruling on the motion. So it's funny because it seems like it's going to come out right here. This is 22 minutes into.
If there's audio issues, let me know. I'm seeing two different sources for the audio that's going in on the replay. So I'm trying to fix that in the background. Let me know if you're not happy.
The video, I don't think he plays his card until about 40 minutes later.
the parties have reached an agreement to do this on our own. And as soon as that gets accomplished, if it's accomplished to both of our satisfaction, then I'll let the court know so you can free up the hearing time.
Okay, we'll address that momentarily. Ms. Fugate, anything else? All right. Under the Miami Herald versus Lewis case, ma'am.
So yeah, Mr. J's basically, you go ahead and make the ruling on this first. Then we'll talk about what I have.
Ms. Boone, you had the burden of producing evidence and proving by a greater weight of the evidence that closure is necessary. What has been presented today has failed to meet that burden. Your motion to close the September 3rd viewing is denied. The court will follow up with a written order that you'll be hand delivered today. Ms. Fugate, if you don't have no longer any business before this court, you are free to go, ma'am. Thank you. Have a pleasant afternoon.
So just like that. Okay, well, Ms. Boone hasn't presented any evidence, so dismissing hers. You've won, Ms. Fugate. Is there anything else? And then that lawyer gets to leave. And now everything that we just spent the last 23 minutes of this video watching is going to be rendered mute by the next 5 to 10 minutes.
Mr. J. Yeah.
Okay, speaking of mute, I just muted one of the two sources. It seems like it's going at the same time as the video. Let me know if it's better now.
Yes, ma'am.
Forgive me.
Forgive me.
When you stated to the court that my motion was oral, was this during the last hearing that we had?
You requested this both, ma'am, on August 5 and on August 9.
What was it specifically that I requested?
You had requested privacy with regard to the September 3rd hearing. And I advised you that I needed to look at the law on it. And you asked again on September 9th when we were going to address it. I said that we would address it on the 14th.
That was one slip by Kraynick. It was actually August 9th. But this is great because he's given all the receipts. And for anyone who's wondering where we are in the trial, this is exactly where we are. We're on August 14th. August 9th was the last Friday's show that we watched, where she was shackled and argued to be unshackled. And here we are 5 days later. The media thing came in right at the last minute, and Sarah's still trying to argue, like, can I ask, what was the chain of events? What led to this meeting happening? I don't remember being informed.
You asked for copies of the law, and those were mailed to you on the 9th.
Which I have yet to receive. And I was not aware of, I was not instructed by anyone in the court, including yourself, that that was an oral motion. If I needed to actually do a proper motion, I would have correctly done so.
That's why we had the hearing, ma'am, because you asked for it orally. So you orally moved or tennisly moved to have that motion heard. And we set it up for today since we already had the hearing time carved.
Or tennisly, which is Latin for oral, I'm sure. But it's funny how she hangs on to this. This is a little detail that she brings to her family court case. Like, I made an oral motion. No, you didn't, Ms. Boone.
Out to address you receiving the hard copies, which seemingly has already been remedied. And last week when we had our hearing on the 9th, I said I don't want to lose that hearing time because we already had it carved out. So we would proceed with the hearing on the privacy issue at that point in time. You then asked for the case law. I said, absolutely, I will get it to you. Mr. J had advised that he was familiar with the case law. But regardless, it was provided to all parties and mailed to you on the 9th.
And welcome to Suzanne Kinlaw. I haven't seen you in the chats before. Glad to have you here interacting with us all, having a good time, all the fine and dandies. Bernice Conklin also here with her bloody keyboard. Good to see you.
Which I have yet to receive.
Which I have yet to receive.
Parties and he was familiar with the case law. But regardless, it was provided to all parties and mailed to you on the 9th.
Which I have yet to receive.
Which I have yet to receive.
By anyone in the court that was an oral motion for me requesting privacy. I thought it was just a comment that I could have on record.
Ma'am,
I don't need to do anything further.
That's why we set the hearing, because it was something that you had asked for. And that's clear in the order that was provided to you on the 9th as well.
And that's such a weird thing, too, to say, oh, I just wanted it to be on the record. It's like so high school. She just like, I just wanted credit for it. I just wanted y'all to know. I didn't realize it had an impact on my trial. I just wanted you guys to know how hard it was for me.
It says that we would have a hearing today on the 14th.
And when did I receive this?
Well, that was orally told you on the 9th.
This is where Sarah, I think, picked up the oral motion for Judge.
Sometimes I repeat myself. I don't know if, I have an idea and I'm like, oh, I should share this with the people. It's the danger of rewatching my own content is sometimes I steal ideas from myself.
Jackson. I think because this worked so well against her, she thought she could just, I made orally.
Thank you, Ramona.
No, the judge could say, I told you orally, because anything the judge says is automatically in order, but you can't just orally. Yeah, anyway, I think this is where Sarah thought that orally would work for her in the Judge Jackson case.
The letter itself was mailed to you on the 9th, but the
Hairball Yarn brings up that ore tennis, Latin for by word of mouth.
The order itself was read to you during the course of that hearing. Specifically on August 14th, 2024 at 1:30 p.m., a hearing will be held in courtroom 12A, Orange County Courthouse, 425 North Orange Avenue, Orlando, Florida 32801, regarding defendant's review of the USB drug drive, which contains the state digital evidence, the defendant's August 7th letter to the court delivered to the court on August 9, and the media's participation in the physical evidence viewing on September 3, 2024. The pertinent case law is attached. That was all.
And a little heads up, the next video, we might watch it today. If enough people are into it, we can definitely do that as the next video. It is the September 3rd hearing, but it is not an evidence hearing.
We're not
the September
getting to that.
3rd hearing is interesting for reasons all on its own, but the evidence gets seen before that September 3rd hearing that will be watched.
Sue's what? Do you think the motion was sodomized or maybe it was Gomorra'd? Might have been a Gomorrah-ing.
Either later today or next Friday.
All addressed with you, ma'am, on August 9 here in open court.
In the order I have yet to receive.
But it was read to you, ma'am. It was read to you as to what we would be doing today, and that we would be addressing the issue regarding the media's participation. And that's when you asked for the case law. And I said, I will give it to you. Absolutely. And it was all mailed to you on the 9th.
I'm not ever sure of what it is that I'm supposed to be doing with, I guess now, oral and also in writing. And again, I'm sitting here waiting empty-handed for everything that was mailed to me day before yesterday and or could have been readily available on the internet, which I do not have access to. So I'm guessing that...
Yeah, that sounds like another, we'll slow it down and listen to drunk Sarah.
Your motion is denied, fuckface.
Playback speed, slow it down. All right, Sarah, let's listen to you whine.
Yes, now oral and also in writing. And again, I'm sitting here waiting empty-handed for everything that was mailed to me day before yesterday and or could have been readily available on the internet, which I do not have access to. So I'm guessing that your verbalization of the order that you read to me, which I have not received, is supposed to suffice.
Ma'am, you were told about the hearing in open court on Friday, August 9th.
If I knew to be prepared, I know that everyone knows that I would be prepared, which I am unprepared because of.
Everyone knows I would be prepared, but I am unprepared because of. The hanging prepositions. It's the easiest way for me to imitate Sarah, and it also pisses me off the most when I hear finish sentences that way. Of which I am unprepared because of.
That's certainly your opinion that you're entitled to. Any reason for Ms. Fugate to remain? State? Okay.
From the state.
All right. Ms. Boone, any reason why counselor for the Orlando Sentinel and WFTV should remain?
No.
Okay. Thank you, ma'am.
No. She wanted to keep talking. She really wanted something more.
In addition to what was set to be
Hey, Sub Rosa.
Addressed today,
which I've yet to receive.
Ms. Boone's review of the USB jump drive, which contained the state's digital evidence, Ms. Boone's August 7th letter.
Bill Russo was asking about the award on the desk. That's a much better. Yeah, it's a glass microphone, but it's an award. It's not a real microphone, I don't think. No, it can't be a real microphone, right?
It's a public speaking
award. He must have got it for being some sort of effective public speaker or something like that amongst judges. Good call for noticing. I've never even noticed that on the desk before either, but it's got to be something of, a point of pride for Mr. Kraynick to have it up on the desk. There's, it's not full of tchotchkes and, trolls and little pencil nubs and stuff like that.
Regarding her requests from the Orange County Jail, Mr. J, you made reference to a potential change in the September 3rd meeting. I want to hear about that, sir.
Here we go. So all of Sarah's whining, all of her complaining, this isn't fair, and this is my one and only meeting. And then Mr. J, just like casually, you know, the lifeguard throwing out a buoy to the passenger for the sinking ship.
I believe we have reached an alternative solution to an evidence view with the defendant. And as soon as that is accomplished to both parties' satisfaction, then I will notify the JA so that we can release your hearing time.
Okay.
I know it's valuable.
Can you explain to me what the proposed plan is for the viewing?
Welcome to the chat. I'm Ofo Show. If you recognize that name, but or maybe don't recognize the name, because I think I bleeped out the name to give it a little bit more of a hidden effect. If you've been on the community page, I'm Ofo Show posted quite an inflammatory comment on one of the videos, and it's gotten a lot of traction from people enjoying that snarky tone of voice that I'm Ofo Show brought to his commentary of Dan D True Crime. So thank you for that comment. Congratulations on your gifted membership, and welcome to the live chat.
There will be a time and place where the evidence will be brought, the defendant will be brought, and she will be given as much opportunity to experience an evidence viewing like a defense attorney as possible. Her investigator will be there and allowed to take photographs and ask if he wants any particular bag of evidence opened so that it can be photographed, inspected, tested, copied as provided by 3220 in the criminal procedure rules. And then the evidence will be brought back to where it's stored, and then the defendant will be brought back to the Orange County.
Okay. Have you had a conversation with Ms. Boone prior to today regarding this proposal?
Well, with Mr. Lane, who has indicated her position, which was that she agreed to that.
Okay. All right.
So if Sarah had properly listened to Billy Lane, I imagine she would have already known coming into court today that none of the earlier stuff mattered, and that she could have just said, you know, Your Honor, we don't need to discuss it because an alternative arrangement's been agreed to. But for whatever reason, she wanted to fight everything, you know. Well, if I'm acting as my own lawyer, I will fight every little thing right down to the last.
Hey, I'm Ofo Show, just handing out the gift memberships as a great way to jump into the first chat. Sandy Rodriguez, Cindy Then, Claire Morton, Woman of Steel, and Teresa T. You've all received gift memberships to Dan D True Crime, courtesy of, in my opinion, Ofo Show.
This is already negotiated, decided. I'm going to go back about just 7-8 seconds to 12 seconds.
Okay. Have you had a conversation with Ms. Boone prior to today regarding this proposal?
Well, with Mr. Lane, who has indicated her position, which was that she agreed to that.
Okay. All right.
And just in case I stepped all over myself explaining what's happening here, Mr. J worked out, you know, hey, we can go visit, we can look at your discovery at the sheriff's office. Media doesn't need to be there. Billy Lane knew about it. If Sarah had talked to Billy Lane instead of just sitting there, well, I've only received the documents today. How was I supposed to argue against the media lawyer if I'm only getting this today? Whining, crying, blah, blah, blah. None of it mattered. You already knew you had a solution. And Mr. J just sat there letting her go through, literally letting her go through the motions. Thank you. I'm not buying it. I'm not buying it. Received a gift subscription. Gave a gift subscription. If your name is Dwarven Angel, you've received a gift membership thanks to I'm Not Buying It, who received their own gift membership earlier today.
Ma'am, I don't want to go into specifics of what you've had with your investigator, but has he relayed to you what Mr. J just advised the court of?
Yes, to a certain degree. It has not been fully explained because it is in the process of being.
Wow. What is going on? Got hair all over. Oh, what have I done? The big.
Spoken
there
about
we go.
two of them.
Learning
Yes,
how
I
the
do know
Zoom
that
worked
that
on my MacBook.
The way the sun is coming into the courtroom, it's lighting up all the hairs on her shoulder, all the stray ends and stuff. Like, distracted. 29 and 36.
And fully explain, because it is in the process of being spoken about between the two of them. So yes, I do know that that is a solution to my request.
Okay. And did you understand what Mr. J advised the court of today regarding how that process for you viewing the physical evidence would be?
If you could please do so again.
Sure. If you could explain it again for Ms. Boone, Mr. J.
Please explain it again for the children. Explain it like I'm 5 years old. So, Mr. J, I think it was pretty clear. We all understood that, right? There's going to be an evidence viewing. Everything, the last 15, 20 minutes that you bullshitted about with the media and how important your case is, but it's not important, but it's super important, but it's not that important, but people from around the world are watching. None of that matters because we already came to a separate agreement. But I'll explain it again one more time like you're stupid. Here we go.
And I'll take an opportunity to try and explain like I'm smart. We have a smart comment from Rolling Along in the chat explaining the award on Judge Kraynick's desk. The Florida Court Public Information Officers Awards. Florida Court Public Information Officers honors judges and court communication teams who excel in public service, video technology communication, and community outreach. And the award is usually a crystal microphone.
Defense attorney wants to do an evidence view, we typically go to where the evidence is stored, depending on the law enforcement agency. He or she can bring an investigator, and an investigator may take photographs if so requested. We typically don't let the defense attorney manipulate the evidence him or herself. The CSI, who would be present as well, the crime scene investigator from the law enforcement agency, would be the person to manipulate the evidence on the cutting paper, and then you would have the opportunity to review, test, and inspect each piece of evidence. So, for instance,
Welcome, Yolanda.
the evidence for a piece of clothing, goes to the front, goes to the back, you have the CSI turn it inside out, those sort of things. And then it can be documented by an investigator with photography. Between each piece of evidence, there's a new piece of cutting paper, butcher paper laid down so that there's no contamination for any DNA testing. And this is basically how the process goes on. If it gets opened, it'll get resealed.
So Sarah's sitting here looking like she's listening, almost the same way that an obedient dog, looks at an owner giving detailed instructions in English and, obviously can only understand their name and the 2 or 3 commands that they know. But she's sitting there, she's looking. All she's wanting to hear is, when do I get to turn on my phone? Will I have a chance to charge it? And can I go through my phone? When does that get to happen? Not going to happen, Sarah.
By the CSI right there in front of all of us, and CSI will reseal the tape, re-put his or her initials over it with the new date, so everybody will be on the same page about why it was open, when it was open.
Thank you for that. If I may, is it closed or is it open?
If I may, please.
If I may.
No. People that are not involved with the case will not be.
Sarah, who realizes that her life is doomed to be public now, just assume that wherever she goes becomes a public space. And it's like, no, it's the sheriff's office. The media doesn't get to go into the back rooms of the sheriff's office like they get to go into a public courtroom. I love how condescending Mr. J is with her. But also, it's olive branches. These are the kind of things that help keep her case from being appeal worthy. And yeah, it's all he can do. He's just, look, it's the least I can do. It's also the most I will do.
And if I may, will my phone physically be there?
There we go.
If it is stored in physical evidence, then it can be brought over. We're not going to be turning it on. If it needs to be photographed or examined, it can be.
This is good too. So she's digging. She's trying to get into her phone, like literally into her phone. She doesn't want to look at the Cellbrite breakdown of her phone. She needs to get in to see her contacts. I think because she's too stupid to use the Cellbrite information to find her contact information. And Yeah, but she's just fighting for that access, and Mr. J shuts that down.
Physically examined, but in order for it to be turned on, it would have to be done at a different location with something called a Faraday box, a room where electronic signals cannot come in or out.
Do I need to write a motion for that?
Can I have a motion for a Faraday box hearing?
For what? For your phone to be brought over and turned on?
If I can extract any type of information from it.
So
Again, all of the information has been extracted from your phone. You're just too stupid to access it. You need it to be packaged into software. And, that's not a huge diss. I don't think I'd be able to break down a Cellbrite report super easy. I think I'd be able to, say, organize into file types and show me all the videos and show me all the text messages. Like, those might be two key things to have a look at. But, I probably wouldn't know how to get all the app data and stuff like that. But
Hairball Yarn points out she has no idea what a Faraday box is. Yeah, if she had the opportunity, it would be, am I able to fit one of these Faraday boxes inside my fire retardant bags at the jail? And then I can use my phone in there?
Yeah, that's not what she's asking for.
like we discussed in the last hearing, that would be up to you to hire a digital forensic examiner, and then we would make arrangements with that person that he or she could image the phone in the same manner that it was imaged live on.
Thank you, I'm grateful.
Welcome.
Okay. Thank you, I'm grateful.
Then, ma'am, after having Mr. J explain that alternative solution to the evidence viewing, is that something that you would like to participate in?
Absolutely.
Okay. So then, is
Absolutely.
it the parties' agreement to no longer have?
And a correction, the comments comes from Hairball Yarn. It's usually called a Faraday cage, by the way. I played with one at Los Alamos. Totally recommend it.
The evidence viewing here in open court on September 3.
That's the state's position, but again, been doing this long enough to know that you can never predict every possible hiccup. But I will defer to the court if you want to free up your hearing time.
Hey,
now,
Kalia.
or wait until we're able to tell you that we're satisfied.
Spoiler alert, you're going to need that September 3rd hearing.
Okay. Ms. Boone, are you in agreement with that alternative solution?
At the Orange County Sheriff's Department?
Wherever the viewing is going to take place. I don't know that a specific location was identified, but yes, where it's going to take place.
That's the clue that she already knew was happening at the Sheriff's Department, because even Judge Kraynick's like, I don't know, wherever. But you're okay with that?
Okay. So then here's what we'll do. I will keep the hearing for now. The deadline to have that viewing as set forth in the August 5 scheduling order and notice of hearing will remain of September 3.
I'm going to pause this. Detective Wilbefit brings up Dan D. True Crime. It's an evidence. It's impossible for her to touch. And exactly, that's what Mr. J was kind of explaining was, if you want to view this evidence, you can act like a real lawyer and, you could come in and you could have your expert talk to my expert and, ask for things to be opened. And we're not going to turn it on. If you want to do that, you need to hire an expert who will pay for a Faraday box and will go to there and, do it in a way that doesn't affect the electronic data that is affected every time you turn on such a device.
If that evidence viewing takes place.
I have to say, I really like working with this Dan D guy. We can bounce back and forth off each other, giving me a chance to just relax and enjoy the stream with you guys.
At a law enforcement agency based on the protocol as identified by Mr. J, I'll just need a notice that's provided, signed by Ms. Boone, signed by the state, signed by Investigator Lane, as to when it took place and how long the viewing was. And if that's provided to me, we'll then cancel the September 3rd hearing.
Yes, sir. We'll do that, and we can even list physical items that were brought. Indeed.
My only question about that is we had sealed at the last hearing the witness list and the exhibit list.
I think all the property
Glad to have you,
receipts and all
Suzanne.
those sorts of things are already in the public record.
Okay.
I think there's a vast difference between a list of evidence that's already in the public record versus having them look at it with television cameras. And
Okay. All right. Fine. Ma'am, are you amenable to that additional procedure that after the evidence viewing takes place, you would sign a notice reflecting when and how long that evidence viewing was?
Of course.
Okay. And then once that's provided to the court, it can be filed and then the court will cancel the September 3rd hearing. Yes, ma'am.
That is done by the state?
The state will prepare it.
Documents and bring them.
Yes, ma'am. The state will prepare it. All you need to do is just review it and sign it. Okay. All right. Thank you, Mr. J, for providing an alternative solution. Ma'am, I wanted to go back and address your request.
I feel like I'm going to say, like, prioristic me is going to say something immediately after I make this comment. So the September 3rd hearing doesn't really happen because James Owens and the team comes in. So September 3rd kind of becomes the snacks motion and some of the craziness that happens. Well, no, snacks is later. Snacks is around September 17th. But September 3rd kind of gets derailed. This is the, there's this and one more before James Owens and the team swoops in.
For the freedom of movement motion that we addressed last week and your desire to use a stun cuff. I understand.
My feed kind of froze. That's a good place to pause too, because
I'm going to say exactly what I
stun
just
cuff
said.
Hearing was hilarious.
Thank
that
God.
was in the last meeting or the last video we watched, and was basically her negotiating being able to move around the courtroom as her own lawyer and wearing a stun cuff so that she, could take a 50,000 volt charge. Wouldn't that have been great to watch? If she ever had to do pro se and like got too close to the judge's bench where the guy, sorry, I didn't know if you're going to jump the judge's box. I would have loved to have seen her take a stun cuff to the leg, but
That a representative from the public defender's office spoke to you about clothing and what they may be able to provide to you. Is there any preference with regard to clothing that you may have?
As opposed to a skirt and pants?
that caught my attention when I was re-listening to this, preparing for the stream. As opposed to a skirt and pants? Who wears a skirt and pants? You wanted to come to trial wearing a skirt and pants? A skirt and pants.
I mean, it's a look. Some people do that.
And what they may be able to provide to you. Is there any preference with regard to clothing that you may have?
As opposed to a skirt and pants?
Correct.
Yes, I very much would prefer to wear a skirt.
Okay.
Yeah, well, you know, as opposed to a skirt and pants, sure, a skirt. I'd have worn the pants, but do you have any pink shorts? I'd really like to wear pink shorts for my trial, my lucky pink shorts.
So if you wear a skirt, as explained to you by Officer Barnett, the stun cuff is located on your calf Achilles area. It would be something that would be viewable by the jury. So
I understand.
Or do you understand that if you choose to wear a skirt for clothing purposes, that's going to be viewable by the jury?
I understand. My belief by you asking me was that maybe it could be moved to a higher place where it cannot be seen, or is it strictly to the one area?
So think of that. It's an ankle cuff, like, you know, kind of thing that's just going to send a shock through your body and put you to the floor. Sarah thinks it's worth negotiating wearing it high up on the leg, like, you know, some sort of a thigh. I guess she might have been small enough for it, you know, 5 years ago. Definitely at her, you know, new wings meal and burger wings meals. She's, I don't think she's small enough to be able to wear an ankle cuff up near her thigh.
Let's not imagine it. Let's get a demonstration, because I was really curious what it would have looked like in court if she was set up to this device. Like, could you let's just take a second and imagine it. Sarah's a pro se lawyer, right? James Owens never comes in, and she's up there and she's making her case, and she has to sit down. Mr. J says something really mean about her, and there's nobody on either side of her. So she gets up and like, no, and they have to zap her. Wouldn't that have been awesome? Just you're just watching, it's just like this nothing moment, and all of a sudden, oh my God, she just got zapped the fuck out. So anyway, I looked up a stun cuff magnum demonstration. It's a law enforcement official sampling it on himself, and let's watch it. Let's watch it together. See what this, and try and picture Sarah. Stun cuff magnum demonstration.
Face it right at the arm.
Very simple. Make sure you have contact. Strap through.
All right.
Now we instruct the inmate. You will comply with all the regulations that we give to you.
Okay. But you know what?
This is just a wrist cuff.
I'm going to now. There you go.
And these are on taut so that there is contact. Now you instruct the inmate that he will comply with all the directions. If he fails to comply with any of the directions, he could be electrocuted at any given time, or shot, stunned, not electrocuted. He will be stunned at any given time. So with that, the inmate acknowledges, do you understand that? And the inmate looks and he doesn't say anything. I'm gonna ask you one more time, do you understand those acknowledgements? He failed to hit him.
Adhere.
Yeah. So it goes. Now it's on a cycle. You've seen how the cycle worked? Now it's not done where it takes him and then he mobilizes.
All right.
Yeah.
Okay. All right. That satisfied my curiosity. But that's just the little cuff one. And that's one that they'd slap on like you're not behaving yourself. They're trying to get you under control. They've wrestled you. They've thrown one of those on your cuff and they're like, settle the F down. Settle the F down. We'll keep hitting this fucking button. We can do it all day. Why did I say settle the F down? Yeah, anyway. You gotta use some discretion in your swearing. Can't call everyone a fuckface all day long. You gotta pick and choose your people, like Vickers chose Sarah. Can you believe he called me fuckface? Not you, fuckface. Not you, fuckface. We saw how short the skirt was that she wanted to wear, so think about where she wanted to wear that stun cuff.
Mr. Barnett, or Officer Barnett, explained at the last hearing how the stun cuff is affixed to a person. It is on the lower leg ankle area.
Oh, and that's kind of gets to the point of that demonstration too. Could you imagine if she's got it up on like her upper thigh, like she's trying to say, couldn't I just wear it in a different area so I could wear a skirt? And then take one like just your whole quadricep seizing on you while you're standing at the podium.
Okay. I'm not understanding why this is being...
Mr. Barnett, or Officer Barnett, explained...
I'm in some difficulties with this new spot that I'm broadcasting from. I've moved down from the True Crime Attic, which is quite hot. Take a look at the clerk, Judge Kraynick's clerk here. Normally she's quite busy doing her own thing, but she's taken time out to watch Sarah talk this stupid shit about wearing a stun cuff with a skirt rather than pants.
The last hearing, how the stun cuff is affixed to a person. It is on the lower leg ankle area.
Okay. I'm not understanding why this is being asked.
Because I want to bring it to your attention that if you have a desire to wear clothing which would reveal the stun cuff, I want you to understand that it's something that the jury can and may be able to see.
I understand. Is it a decision I need to make today?
It's something that you need to consider.
I
If you're wearing pants, they obviously cannot see it. If you're wearing a skirt, they can see it. And you're making a intelligent, knowing decision that they can see that and that you want to proceed with wearing a skirt. Your other option, if you do not like either of those, is the parties will remain, you'll be hands-free, as we discussed, but you'll have the leg restraints like you have today, and everyone will conduct everything from counsel's table, all direct examinations and cross-examinations, any questioning of any witnesses, any argument.
Sorry, that was me trying to pause it again and waiting for the screen to come back alive. Okay, never mind. Did have something to say there, but we'll just let it play.
Apologies
Any
for the
opening
technical
remarks or
difficulties
closing
of the first
statements,
stream
closing
too,
arguments
you
or
know.
opening statements will be
Live and
made
learn.
from counsel's table. You can certainly stand, but we will not have the opportunity to walk around the courtroom.
I understand.
Because I want to bring it to your attention that if you have a desire to wear clothing which would reveal the stun cuff, I want you to understand that it's something that the jury can't.
That's what I wanted to say. Judge Kraynick, super smart in saying you are making a knowing and intelligent decision. This is him not wanting to give her legal advice, and quite the opposite, playing into, I'm not going to give you the clue that it's a stupid decision. I'm going to say intelligent and use it correctly. You're using your intellect to make a decision to wear a stun cuff that will be seen by the jury. That's your intelligent decision. And by saying intelligent decision, Sarah's like, yes, well, I am intelligent. So, okay, that's my intelligent decision.
Fuckface.
So I think really clever use of language by Judge Kraynick to call it an intelligent decision on her part to avoid giving her the advice of, that's pretty fucking stupid. Can't give you advice, but that's pretty dumb.
And may be able to see.
I understand. Is it a decision I need to make today?
It's something that
Sleep
you need
on
to
it.
consider.
I have.
If you're wearing pants, they obviously cannot see it. If you're wearing a skirt, they can see it.
Actually, Your Honor, my intention is going to be to bring up the fact that I've been incarcerated the first time my lawyer, and I will be getting a lawyer, just so you know, my lawyer's going to ask me about my weight, and then I'll mention that it all happened since I was in prison and make all of this moot. So the first 20 minutes, moot because, they're not doing the evidence hearing in public. The last 20 minutes, moot because she gives away the fact that she's been in jail, regardless of her outfit. And even her first day outfit, what'd she pick? She picks a blue smock top, like a blue blazer top, basically looks like the same prison issue suit. We'll be seeing that in a few Fridays.
And you're making a intelligent,
Hey,
knowing
Aaron.
decision that they can see that and that you want to proceed with wearing a skirt. Your other option, if you do not like either of those,
If you don't like
is the parties will remain, you'll be hands-free, as we discussed, but you'll have the leg restraints like you
chained to
have
the floor.
today. And everyone will conduct everything from counsel's table. All direct examinations and cross-examinations, any questioning of any witnesses, any argument, any opening remarks or closing arguments or opening statements will be made from counsel's
door.
table. You can certainly stand, but we will not have the opportunity to walk around the courtroom. Now, I know that we talked about in our last hearing that we would have another hearing when we
see
have our
the
trial
Ted
case
Liquor.
management in September, addressing the box as to where everybody would go to. And last week on the 9th, I said that we would limit access from counsel's table to the podium, and we wouldn't be allowed to approach a witness or the jury. And those same restrictions would be placed on the state as well. Now, I'm not telling you what to do. I'm just giving you a series of options. Because if you want to wear a skirt, you have to understand that the jury can and will be able to see that device that's affixed to your leg.
And by my hearings that we have spoken about the stun cuff, they are televised, correct?
To the best of my knowledge, the media has participated in the majority.
So this is again stupid Sarah. She thought maybe it might be a secret, that the world wouldn't know that she's wearing a stun cuff. It's like, no, we're just keeping that secret from your jury. That's it.
If not all of the hearings that this court has had with you.
Does the court broadcast live, or is it uploaded to the clerk of the court's website?
What is broadcasted live?
My hearings in regards to all of them, basically, but
are my hearings uploaded to the clerk of the court's website?
Recently, the sun cuff. Is there anyone that would know that I'm already wearing it if they could see it or not?
We all know.
I can't speak to what everybody else knows.
So if I may, please, my options are pants hiding the sun cuff or a skirt.
Shout out to a friend of the channel, if I may, please.
I can't speak to what everybody else knows.
So if I may, please, my options are pants hiding the sun cuff or a skirt with it being visible, or I am able to sit here at the council's table with leg chains on and no one is able to move except for here at the council's tables.
You certainly have the opportunity to stand, but we wouldn't be able to move around the courtroom, and those same restrictions would be placed upon the state.
Okay, I just wanted to confirm that those were my options.
Correct.
And when do I need to make that decision?
You don't have to make that decision today. It's something that we can address at the trial case management in September. Ms. Click, I see you raising your hand.
Your Honor, I just wanted to let you, so being in there fully.
Okay, Miss Glick is from the jail's wardrobe office. So there, I guess the public defender maintains clothes for prisoners to wear at jail. So she is sitting in the gallery directly behind Sarah. The reason I bring this up is Sarah doesn't turn around. She has freedom of movement. She's in a chair that doesn't move. It doesn't have wheels. But when she is talking to the woman behind her, she talks straight forward and just kind of turns her head a little bit, like so her voice goes to the side rather than addressing this person as a person and, you know, fully turning her body around. So that's an interesting part about this exchange.
I don't know how I know this, if there was maybe there's like a tighter view, because sometimes I zoom in to make it, you know, more dynamic views for my viewers. But she's standing in the gallery. She's basically one row back of the defendant's table. So she's standing up talking, and Sarah's just got her head backwards, or, you know, her head facing the court. But, you know, for all the time she turned around to make eyes at the gallery, she can't turn around and listen to the person that's telling her about her wardrobe options. Just showing how entitled and like, yes, please speak. I'm listening. Mm-hmm.
If you could, before you get to it, and just announce yourself for the record, please. Yes, ma'am, go ahead.
Oh, that's how I know. Here I am thinking I'm all clairvoyant. Like, I don't know if I had a different view of the court. It's because they pull back immediately after you said that. So that's where she is. And yeah, Sarah's not looking at her, and it's about her.
Just pausing that to make sure that I've got her in frame on my studio view. Okay, yeah, you guys can see her. The woman in the pink skirt with the blazer that's standing and
I'll leave
talking.
you with that for a second.
And yeah, you'll just notice that Sarah does not turn around to address her. Makes the, you know, the least I can do kind of motion of turning her head to project towards Mr. J. But
Right now, unless you had any donations to each side that happen to match that size, we have 8 pairs of pants, 3 shirts, and 1 dress, and that is every, well, we do have shirts, but for in terms of shirts versus pants versus the dress, that is everything we have that would fit this size range. So I just wanted that to be aware, so that if Ms. Boone is taking any sort of what we have to be able to find.
Okay. Ma'am, did you have the opportunity to hear what Ms. Click said?
I did.
Do you have any questions for her?
If you could.
so just in case you didn't hear what Miss Glick said, basically it was just about how they would get stuff to her and what stuff they have the opportunity to provide. So probably in accordance to, you're wearing a stun cuff, we have 3 pairs of pants that would cover it. If you're not wearing a stun cuff, we have 2 skirts that you can also choose from.
Please repeat what it is that you all have available, the numbers.
But yeah, did you see how she turned to her or didn't turn to her? Go back just slightly. 28.
Okay. Ma'am, did you have the opportunity to hear what Ms. Click said?
I did.
Do you have any questions for her?
If you could please repeat what it is that you all have available, the numbers.
8 years of pants, 3 skirts, 1 dress.
8 pairs of pants, 3 skirts, 1 dress.
Ma'am, do you have any other questions for Ms. Click regarding the clothing that the public defender is endeavoring to provide for you?
And if I do come to the decision, I can always have someone externally bring something into me.
Absolutely, you can always
Jiminy Glick's a great interviewer.
be at the visitation center, which I described across the street from the Withdrawal center. That is not, the public defender's office is in no way involved with that. It would put it in your property and the corrections with transport property.
Just again, if you didn't hear, it's basic how they get the clothes from the office to the court, and that's it. You know, I'm going to try refreshing this page. Hopefully that doesn't cause a bigger problem.
You come to the decision, I can always have someone externally bring something into me.
I could also have someone externally bring something into me. That was what she was asking about. It's good that we had that slowed down there. And this ends up becoming James Owens and the girls bringing in equipment. And she's asking, can we use the same transport method that would get me clothes from you? Can I get my clothes to you guys so that they can bring them to me?
Provide something in your personal property at the visitation center, which I described across the street from the Withdrawal center. That is not, the public defender's office is in no way involved with that. It would put it in your property and the corrections with transport property.
So somebody can put stuff into her property, and then that's her property. That could be transported to the court by corrections, but not by the defender's office.
Yes, ma'am. Thank you.
All right. Any other questions for her?
And yes, this is immediately before Owens. I think we'll be sticking around today. The next video is where James Owens makes his first appearance. And if nothing else, the very beginning is a lot of fun watching the pure joy on Sarah's face as she comes in with her successful outcome to her circus ad. But yeah, ask for, place a circus ad for a lawyer, get a circus clown for an attorney. And
Can Ms. Click be excused?
Yes, thank you.
Thank you, ma'am. The next issue that I wanted to address was the review of the digital.
Go back a half second there. Look at who else is in the courtroom. Billy Lane is there. I don't know who anyone else is. There was somebody here on another matter on one of the 2 days that
Shevendell
I was looking at
is still
video
way to come.
Possible they're just
next issue that I wanted to address was the review of the digital discovery. Ma'am, Mr. Lane.
At this point, we are 48 minutes into the 2 hour and 48 minute video, so 2 hours remaining. I can probably find out where Shevendell comes in. Might be about a half an hour away. He comes in multiple times after that, so. But yeah, 2 hours left of what we're reacting to. Probably 3 hours of stream left then. Maybe a little more when we throw in extra transcript reads and the other half of the 16-page order. If you're wondering what we're eating, it's lovely chili. It's a multiple bean chili. I've got pinto bean, navy bean, as well as white and red kidney bean, and some black turtle beans. So 5-bean chili. Ground beef, onions, tomatoes. I've got some sour cream on the side because it's quite hot. I use crushed the They're cayenne peppers that have been dried and just hand crushed. This is bread for, to eat with. That's what I'll be eating if you're wondering.
Was provided at our last hearing on the 9th, the hard copies of the discovery, the USB jump drive, which contained the state's digital evidence.
This is getting into the third part of the trial now. This is the Billy Lane part, the discovery, the jump drives, the evidence. This is where Mr. Shevendell makes his appearance. I think it's Shevendell. Mr. Shevendell is the attorney for the jail. And Mr. Shevendell came to this
Sorry, I stepped all over your lines, prioristic dandy.
hearing with no fucks to give for Sarah, and immediately shows that he's all out of fucks right from the start.
And digital transcripts of the deposition.
I have made people hungry with the chili. Suzanne, my secret ingredient is it's a slow cooker. I always throw in some cocoa. So chocolate if you don't have it, but even cocoa powder, unsweetened, it just gives it it's a really balanced earthy taste, especially if you like it spicy. It gives it a nice undertone. You combine the cocoa with cumin and then whatever other spices you like. I like a lot of garlic, but delicious.
Of detectives Chelsea Copsel and Scott Lowen. And he was to meet with you on Saturday at 9 o'clock.
Carolina, we'll be
Did that
glad to
meeting
see you
take
later.
place?
Did.
Okay, what was provided to you, if anything, at that meeting?
What he and I
Lakeisha, good to see you.
What was provided to you?
This is perfect too. So Judge Kraynick is trying to get on the record that majority of the discovery is on digital files and provided to her. But she's like, provided to me? I don't think anything was provided to me. When I think of people providing for me, I'm thinking of, hot meals and wings, not my evidence. It's my discovery already. Was it provided to me? Is that what you
Take a second to welcome Addie as me to the chat, one of my very first moderators. Big welcome to Addie, as well as for people who like a slow cooker. I assume if you watch my channel, you're also a fan of SKR. Start making SKR chilies. When you know SKR has a broadcast coming up, get all your ingredients together. You usually have a few hours notice, right? Get your ingredients together. Put the pot on the counter. Throw everything into the crock pot. Start watching some SKR. Every time you have to get up, stretch your legs, you stir the pot. By the time the stream is done, you have a pot of awesome chili sitting there waiting, whether it's, you put it on warmer and wake up to it the next day. But yeah, I'll give you recipes. I say, but if you want to start making SKR chilies together, we can all, chat it up and chat and be like, what's with all the dandies talking about chili while we're listening to SKR? But that's what we'll do, because we can do what we want.
What was given to you by
Lakeisha?
Investigator Lane?
the digital evidence we went over.
Good to see you, Roberta.
Reviewing the discovery, but I don't
Love seeing you in the chat.
Physically being handed to me.
Okay, all right.
Okay.
And when you say that you went over the digital evidence, are you referring to the USB drive with the 9 items that were identified in the state's exhibit list?
Yes,
Not more than one.
I do have that. We have not concluded going through that. We have other meetings tentatively scheduled, which we will be concluding that also in order to meet the deadline for the objections of the 23rd of August.
How many?
The deadlines of the 23rd of August is basically at the August 9th hearing where the digital evidence was provided to her. If she wanted to object to any of the evidence that's coming into the trial, she had 2 weeks to do so. So she has to file that motion by the 23rd.
Any of those 9 items were you able to review with Mr. Lane on Saturday?
Quick guess in the chat. So there was 9 items. Now, of course, a lot of you have seen this before, but some of you haven't. So you can put a number from 1 to 9 or 0 to 9, 0 to 9. Of her 9 items of digital discovery, how many do you think her and Billy Lane reviewed at their first opportunity to do so. If you've been watching along, you'll know that she's wanted this discovery. She doesn't understand why she's not getting it sooner. Why can't it be here now? Why can't it be here yesterday? Just give Sarah a chance to say her answer very quickly. So once again, number from 0 to 9, how many items of her digital discovery did she have an opportunity to open and review once it was provided?
No more than one.
Not more than one.
Not more than one. Not more than one. So you had 9 pieces. You had a chance to meet with your investigator, Billy Lane, looking fantastic in his tailored suits as always. Not more than one. What numbers are there that are not more than one? There is 0 and there is 1.
Line.
Zero's a number.
On Saturday.
Not more than one.
Okay.
Okay.
Were you able to access all of the 9 items on that USB drive?
For the brief moment that he and I were able to attempt to do so, yes, they seem to work.
Okay.
For the brief moment that him and I were able to attempt to do so, they seem to work. Of course, I didn't really care about getting any of this because all that stuff makes me look guilty as fuck, so didn't want to really see the evidence, but it was my right to have it. Now that we have it, we're able to move on to other things. Harassing Brian.
You did not have any issues opening up any of.
Kelp suggests adding carrot to a chili. That's an excellent one too. Again, if you like it spicy, the carrot really cuts in a little bit of sweetness that helps offset it. This particular chili could have used carrot.
Those files.
I personally myself did not open all of them.
I personally myself did not open all of them. No, you don't care. Kelya brings up that she needed time to flirt, and yeah, there's some evidence. There's at least speculation, maybe not evidence, but speculation that she was saving up her staples from previous legal documents in order to make her uniform more tight-fitting. But it looks like she's accomplishing that all on her own. I don't see staples doing the work here. This looks like that's her body filling out that that jail outfit. Could you imagine what kind of staples would you be putting in that to make it tighter? Like, maybe it's for the pants.
Okay. All right. Okay.
It's on our to-do list.
It's on our to-do list. Yeah.
Ma'am, Mr. Lane also took possession of the hard copies. Have those been provided to you?
Like she's wearing a spandex bodysuit.
They have. They were waiting at the dorm for me upon my return of the last hearing.
Okay. And where are they currently?
They're located at my bunk area.
Okay.
Okay, that's a bit of a problem. Because this whole time we've been told that she can't have the boxes. That's why they were going to put them on digital. Judge Kraynick wanted to get this on the record, and this will be part of the next hour of the video here, is a little discussion over why do you have those paper documents, who said you could have them, and what are we going to do because you can't have them.
And what are they stored, or how are they stored?
The hard copies you're referring to?
Yes, ma'am.
The 2 boxes are at my bunk on the side in between other bunks.
Okay. All right. Are they in?
Big hello. We have 100 live chatters. The last time I've had 100 people in a chat was when I was reading the supplemental final judgment. So a big welcome and thank you to everybody who's here for the first time, to Dan D True Crime, everyone who's here again after a long time.
Thank you. Thank you to the 109 people who were here today. Like the 100 stayed and we gained 9 more.
Welcome aboard. It's a fine and dandy chat crew. We really appreciate your company and thank you for coming in. We'll be going live for at least another hour today, and if the attention remains what it is, we're going to stay through for the James Owens hearing. That's about an hour more of video. So we've got 2 hours of video, which means probably 3 hours of video and commentary. So sit right down, put your feet up, grab a medical cigarette and a medical snack, and hang out. We're glad to have you.
It's a type of bag, or is it just the 2 boxes that are right there?
Just the 2 boxes.
Okay, all right.
And immediately we drop to 99.
But you've told me that you live in the female dormitory with limited privacy. You understand by keeping those boxes there may be a risk as to other persons looking at them.
I understand.
I don't have any other choice.
You do,
But
though.
you understand that
You do have another choice. You could have respected the digital evidence procedure that would have secured your belongings. She's more concerned about the guards leaking her digital evidence online, and that is like the source of YouTube videos, without realizing that all that evidence is already out there. There's no need for a guard to be sneaking her digital evidence out of the lockbox, to get a special post on YouTube. Suitcase videos out there, that's the one that's putting you away. The other videos, they were bad too, but it wasn't going to ruin your case if somebody saw the video of George saying today was going to be a good day. That wasn't going to prejudice your case worse than the suitcase video. But yeah, she's so concerned about the jail staff that she's being completely naive about her fellow prisoners. Who wouldn't be going through that? If you were in jail with someone, the suitcase murderer, wouldn't you want to be picking through her evidence files when she's not around? Like, so stupid, so dumb.
risk exists.
Of course.
Okay. Do you understand that there's a risk that those items could disappear?
I understand.
Okay. All right.
Okay. All right.
Do you understand that it's your request and choice to keep those documents in your possession?
I do, and I'm
So these are all, again, Judge Kraynick. You can't give advice to a pro se.
I was just about to say what prioristic Dandy is saying right now, so take it away, Dandy.
Client, or someone who's representing themselves pro se. But all these questions, if you had the modicum of perception and reading between the lines,
Get one more
you'd realize that each one of these questions are like, you realize this is a stupid thing to do, but he's phrasing it as okay, and you understand that this, yes, I understand, Your Honor.
also requesting in my letter to the captain and to the major to also be able to store all of the USB drives and the hard drive in my locked drawer, also for an extra security measure.
She wants the digital evidence in her locked drawer for an extra security measure. You're in jail with presumably people who have the ability to pick locks. And I'm sure the locks that are available to you inside the jail as an inmate are not super robust. There's a channel, I haven't watched it in a while, but it's called Lockpicking Lawyer. Kind of cool. It's just it's a top-down view of his hands working locks, and it kind of shows you how easy most locks are to open if you're an experienced lock picker. So the idea of having your things locked as an extra layer of security within a dormitory prison is the stupidest thing. Well, not the stupidest thing she said, but it's in that top 15, 20% territory anyway.
Okay. All right. I see that we'd have Investigator Lane here. Sir, if you could come out. Madam Clerk's going to go ahead and swear you in.
Mr. Lane, looking good.
I do.
Sir, good afternoon. Could you state your name for the record and your affiliation with Prison Break Investigations?
Barbara
Billy
King,
Lane,
welcome.
Owner and Chief Investigator of Prison Break Investigations.
All right. Thank you, sir. I did see that your notice that you provided regarding the distribution or providing the discovery. You provided the hard copies and the USB with the digital and the USB with the depositions of the two detectives.
That's correct.
Okay. All right, sir. And when you met with Miss Boone on Saturday? Again, I don't want to go into any specifics, but were there any issues accessing any of those USB drives or any of the files?
Not at the progression in which we made through the files.
Okay.
I will be happy to let you know.
All right, very good. But as of right now, there's been no issues as to access from what you've reviewed. Okay, all right. State, do you have any questions for Mr. Lane?
No, Your Honor.
All right, ma'am, do you have any additional questions for Mr. Lane?
In regards to the drives?
Correct, based on what was teed up for hearing today, which was...
In regards to the drives, you can see why Sarah wanted her outfit to fit tight. She likes the way Billy Lane's outfits fit and was like, ooh, yeah, I can cut mine in. If I did a little of that on the waist and really accentuated my hips, get that nice looking Billy Lane look.
Addressing your review of the USB jump drive, which contains the state's digital evidence.
Mr. Lane, are you able to briefly meet with me downstairs after this concludes?
I'm
Probably
sure
not.
that's permissible with the policies and procedures. If not, I'm going to try and schedule a meeting with you.
Okay.
Any other questions for him, ma'am?
No, Your Honor.
All right, can he be released?
Yes.
All right, state.
Your Honor,
Thank you, sir. Appreciate you.
Goodbye, Billy Lane.
Okay. The next, ma'am, is your letter from August 7th to Captain DiGiovanni, which is the court has had the opportunity to read. I believe that we have a representative from the Orange County Jail who's appearing virtually. If you could please unmute yourself and turn on your camera, whoever it is that may be appearing from the Orange.
Billy Lane, could you meet me by the back door? No, downstairs? No?
County Jail. I have a Administrative Sergeant De Jesus.
Yeah, all right. It's going to get good now. Well, it's been.
I think this, so the video call here is going to be, well, I'm probably going to say it. So, but I think this is where Scott Shevenell joins the chat.
Been good. It's going to stay good.
Good afternoon, Judge. This is Captain Gina DiGiovanni with Orange County Corrections. I'm the captain of the Female Detention Center. And yes, I have Administrative Sergeant Stephanie De Jesus with me.
All right, very good.
I will also want to make it clear that I have Orange County Corrections Department Legal Counsel Scott Shevenell on the phone with me.
Okay, very good. If all of you can, if the Captain DiGiovanni and Sergeant De Jesus, if you could please, I only see you, Captain. If Sergeant De Jesus can come into frame, we'll have Madam Clerk swear you in. If you both can raise your right hands.
Yes, ma'am. I do.
All right. Could you both state your names for the record for me again?
Administrative Sergeant Stephanie De Jesus. Captain Gina DiGiovanni, Security Operations, Female Detention Center, Phoenix Facility, Genesis Facility.
And can I get appearances for legal counsel for the Department of Corrections, please?
Scott Shevenell, County Attorney's Office, representing the Department of Corrections.
Okay. All right. Very good. Captain, have you had the opportunity to review Ms. Boone's August 7th letter regarding some of the requests that she has in this case?
Yes, and if it's okay with you, Judge, I'd like to address each request one by one. Do you have a copy of the letter?
I do, and we can proceed with the 7 different items that she has requested. So if you
actually, so with number 1, the request to have her review time extended, I can make the extension in the following fashion.
And just before she gets any further, just so anyone who's listening knows, I did everything I could with the audio feed the first time I broadcast this. Now I'm rebroadcasting it, and I have better filters, but you can only upscale so much. So if you're getting a lot of white noise in the background combined with audible audio, that is the improvement from the original, where there was large stretches where if you didn't have a Bluetooth speaker up to your ear, you weren't listening to it. So the balance isn't great, especially compared to me speaking directly into the mic. But
for the most part, it should be listenable, that was my plan.
Still have to collect the laptop at 4 p.m.
This is, I think, pretty smart by the jail captain Giovanni, addressing the points one by one rather than as a group, because some of her requests are reasonable and some of them are outlandishly ridiculous. So the one by one allows, rulings on each thing, or at least keeping them organized, because Sarah's requests are all over the map here. And also by opening with the first one where she's able to, I think, be a little generous, like Sarah asked for, 10 hours rather than the 8 she was given. And the captain comes up with a plan that's going to give her, maybe 12 hours of access, but she still has to turn it in at the shift change. So it works for the jail, but it still ostensibly works for Sarah if she gave a shit about going through her materials instead of just giving people shit for not getting her materials.
This gives the staff and supervisors the ability to conduct the afternoon head count, conduct the meal dinner service, conduct the shift change, and then the evening head count. I am willing to allow her Sunday through Thursday to get the laptop and the USB drives from 8 p.m. to 10 p.m. and Friday night and Saturday night from 8 p.m. to 11 p.m. That is more than the requested time that she has asked for additional viewing.
Ma'am, do you understand the extension that's being provided by the Orange County Jail regarding the laptop, that on Sundays through Thursdays, additional time from 8 p.m. to 10 p.m., and Fridays and Saturdays, 8 p.m. to 11 p.m.?
Correct, with them collecting it at the normal 4 p.m. time.
Correct.
Yes.
All right. Do you have any questions regarding that extension?
I do not.
Seems
okay.
generous.
Is that acceptable?
Very much.
All right. Moving to the next issue, Captain, the USB drive security.
Number 2, USB drives. It's a matter of security. The metal tips, the drive itself can be fashioned into something other than what it's originally intended.
Other than being fashioned into a weapon, why can't I have the USB drive? I guess no other reason. That we just stopped looking for reasons after the first one there.
Intended for. The drive itself can be fashioned into something other than what it's originally intended for. These items are secured in a secure control room and inventoried by our supervisors on every single shift. They're also inventoried and acknowledged being in good.
I'll read your version of it. That looks like it's that's the thing I like about writing as opposed to just speaking freely. Other than being fashioned into a shiv, what is the problem foremost?
Working order and repair by my DSTs, the escorting officer, and my supervisors.
Sarah scoffs at the idea of a USB drive being fashioned into a weapon. And the weapon is just one of many things that a piece of metal can be used for in a prison. I'm just showing the top of a lighter here. Obviously can't have a lighter, but even just this little piece on top would be about the same amount of metal that you could get maybe from a USB drive. If you're making jailhouse weapons, like, the old movies in the 90s.
Just a note for the algorithm, don't make jailhouse weapons. Even if you're in jail, bad idea. If you're not in jail, bad idea. Don't make weapons. Don't try this at home.
Showed them with the hard plastic toothbrush. You would heat that up enough to get a piece of metal in there so that it's affixed, and then.
But this isn't instructions on how to make weapons, so don't do it. I saw this in a movie. I didn't come up with this.
Once that melts back together again, you sharpen the metal over and over, and you've got yourself, a pen knife that might work for, anywhere from, 20 to 30 stab wounds before it breaks. So it's a real thing. People in jail have nothing but time, and the jail captains have seen everything before. So Sarah scoffing at, other than possibly being made into a weapon, is there any other reason I can't have them at my bunk? It's like, that's way enough of a reason. Like, you know, there could be other reasons, but that on its own is a fantastic reason that you can't have it.
Fuckface.
You know?
So there's, at this point, unless directed by legal counsel or consultation with legal counsel, I believe that these drives are secure and managed. This, by the way, is the same way it's managed by other facility captains, that you get a viewing period and then everything gets secured and inventoried.
Ma'am, do you have any questions with regard to the USB drive request in your letter and the position of corrections regarding it being a matter of security and how the USB drives are secured, controlled, inventoried, and confirmed to be in good working order?
I understand the process. My only concern is if I'm able to have my hard copy of 2 full boxes of my discovery, I'm not sure why.
You're not able to have your hard copy of 2 full boxes of your discovery, but
Hard no. But we'll get into that. We had to take a pause to welcome Fletcher Boy to the Fine and Dandies. Welcome aboard. Woo!
More on that later, Sarah.
Other than the fact that the assumption could be made that it could be made into something other than a USB drive.
You all are trying to assume.
And even the way she puts it, I didn't even, well, I definitely saw assume because old me put it, being snarky. But other than the assumption, it could be making, it's not an assumption. They work in a prison. They've seen everything made into everything. Like, they have, when you're talking about time and they have abundance amount of, there's no shortage to the creativity of weaponry in a prison. To be dismissive, like, you assume that it'll be made into a weapon. Yeah, your USB drives would get stolen and be made into weapons, Sarah.
That it would be made into something other than a USB drive? I think you all are trying to assume that.
And I'm trying to avoid any further leaks of information that could possibly be suppressed or utilized in my case. So I didn't know.
Hey, Devs
if I
for
could have my
Dummies.
hard copies, I'm unclear.
Oh,
Other than those reasons.
Fletcher Boy, that's a great point, and it's we're far enough into the stream that nobody's going to be pissed off at. He keeps just trying to sell memberships. If you notice there's no super chat, it's because I made a strategic decision for the channel that there will be, well, at least for now, no super chats. No super chats, no super stickers. If you want to be a super fan, if the membership fee is just too darn cheap, buy a gift membership. You can buy as little as 1 if you want to, double up your monthly membership. If you want to buy 5, you can buy 5. If you want to buy 1 every stream, you can buy 1 every stream. Or you can buy none. You don't have to buy them. But instead of super chats, which, and I'll get into my philosophy real quick on super chats. I used to follow completely, like, outside of true crime. I was just on YouTube following other stuff. And I would get annoyed every time super chats would come up where it just felt like it was derailing the video from what they were talking about. And there's certainly useful super chats. I see our community uses them a lot better. But it was just something that kind of rubbed me the wrong way as somebody who just couldn't afford to be part of the super chat culture. So, and I was watching bigger channels, to be fair to, like, channels that, had 10,000 people in the chat. So certain people would just buy their way to prominence. And as somebody who was just trying to chat with people in the chat, I didn't like it. So I that was one reason I just kind of had, I don't like super chats. But then, YouTube tells you, hey, if you unlock super chats, your fans want to support you. And I thought about it, and I'd much rather have anyone who wants to, be a patron of the channel, give a little bit more, invite more people to re-engage with the channel. There's a lot of people who might have subscribed because they saw, one music video 5 months ago and haven't watched the channel since, and YouTube's never going to show it to them again.
despite being subscribed. So when you give out 5 gift memberships and somebody finds out, oh, that channel's still going, and holy shit, he's doing videos every Friday, they're hours long. Okay, I'm going back to it. So I'd rather build community than my pocketbook, and it's the same amount of money anyway. So if you give $1 to a super chat or $1 to a membership, it's the same dollar at the end of the day, same cut, same creator support. So that's a long way for me to say, if you want to support more than free, and free, I appreciate. That's all I can ask, is that you watch the videos and give a shit and interact and chat and friendly with the community, all of that. You want to go over and above, buy a membership. And if the memberships are too cheap, buy more. And if you want to do super chats, if you've gifted memberships, I'll do your super chats. You can just say, hey, Dan, can you super chat this? And, you know, the people in the comments, Dan, you know, Fletcher Boy needs a super chat. You guys will let me know. And I don't mind doing them. It's not like I'm going to get embarrassed by, you know, I'm not going to read that super chat. That makes me look dumb. Go ahead. Have fun. That's why I even rewatch my own streams, to kind of show you that it's okay to laugh at me. I find I see a lot of humor in the things I do. So, and laughing at, not with. You guys can laugh with me when we're doing the streams live, but we can laugh at me in retrospect, especially if I'm leading the charge. Anyway, that's where we are with that. I'll get back to the video.
That's why I cannot have those as well.
Thank you, Yolanda.
To the extent you're able to answer that question.
And I would just chip in that, obviously.
All right, that's Scott Shevenell chipping in.
Oh, good.
Scott Shevenell is the jail lawyer. We'll give it a second for people to return to their computers, because this is the first of many great interactions from Scott. Elizabeth reminds us, Elizabeth 3236, I seem to remember that Tanika's 2 cents got inmate contact forms, and that Sarah never got the laptop in the evening. And there were days she only had it for a couple of hours or not at all. And that's that tracks. She would rather argue for her right to have the laptop than she would use the time to use the laptop effectively. And the only thing she really wanted the laptop for, I think, was so that she could use it to trade favors within the jail. Like, hey, I have a laptop. I can get you that message sent out, or I can do XYZ if you do XYZ for me. And yeah, that wasn't realized because the jail's smarter than you.
Tim Stole My Fish Soap says, Dr. Pepper is my favorite, but I gave up soda 7 months ago. Now I have to drink the vodka by itself. I tried that strategy on a previous stream. If you want to see me reading Sarah's appeal letter, like, hey, I know you didn't want me to send this, but I'm sending it anyway. I got the bright idea of, well, just sip some vodka. That'll help me get into a drunky Sarah voice. It doesn't go away. It's not like, okay, and now the vodka's gone, I'll do my, regular voice. It's in you. And then next thing you know, everyone's like, more. You guys were actually pretty good with me. Nobody was encouraging me to get out of sorts, but it's the third good time I've had out of this bottle. And looks like there's many more good times to be had.
Sarah, a lot of people are smarter than you. Another person who's smarter than you is Mr. Scott Shevendell.
See the safety issues, and you can definitely distinguish between, paper copies and anything made out of metal, which is what the captain just testified to. That's the problem. It sounds like to me is anything that could be a safety hazard is an issue for us.
So, ma'am, do you have any other questions regarding the corrections department position with regard to the USB drives?
What was the outcome?
It sounds like they're, unless...
That's so good. Sarah's just so out of her element, right? Scott Shevenell's saying stuff and she's listening like, well, that doesn't sound good for me. Okay, well, what was the outcome of that? Well, it sounds like they're not going to let you have the USBs.
Corrections department position with regard to the USB drives.
What was the outcome?
It sounds like they're, unless I've missed something, it sounds like the Orange County Jail is going to continue with their protocol of...
What was the outcome? You won, Sarah. I ruled in your favor. Did you not notice that? You must have missed it while you were ruminating on what you were going to ask. What was the
Storing,
outcome?
Inventorying, and keeping the USB drives in accordance with the procedure as provided to you and read to you in open court.
And Judge Kraynick summarizes, the outcome is they're not...
Donnie, you're out of your element.
Going to do it. They're going to follow their policies. Does that sound familiar to you? Do you remember?
John Lennon, give peace a chance.
You were sitting here when it happened, Sarah.
And that's due to metal?
That's due to the reasons that were already identified. The matter of security regarding the drive being fashioned in a way that may affect security.
And that's another point. So they're not just saying, no, not just as a weapon, fashioned into something that isn't the USB drive anymore. So it could be for anything for, say an inmate's trying to copy a key and they take an impression of a key using a piece of gum. You can now use that piece of metal, shape it to fit the contours of your, all sorts of different ingenious little...
Don't do that. Don't copy keys if you're in jail. Don't use gum if you're not allowed to have it. And make copies of keys. This is not an instructional video. This is just commentary.
Things that you can do with a flexible piece of thin metal. So, Sarah, just because you're too dumb to figure out what it could be used for, the other prisoners are very capable of using it in a way that could affect the security.
And it continues to ensure that those drives are secured, controlled, inventoried, and in good working order. Do you have any questions?
Could you please provide the last name of Scott, the legal counselor, please?
Oh, this is great, too. So she asks for the last name and takes the time to spell it. You watch her write it down on the thing. So let's, and I'll correct my spelling. I think I'm right. That's Scott Shevenell, but it might be Shevendell. We'll see.
I'll spell that, Judge. Shevennell.
Okay, so I've got it correct on screen. It is Scott Shevenell. Shevenell. Remember that. Shev-N-L. And she's writing it down, so there's no reason she should get this wrong.
One more time, please.
Shevennell.
She asked for it with the same energy as people who are getting arrested on body cam for DUIs, like badge number, name and badge number, because they know it's the one thing the police have to provide for her. So in order to try and, take that narcissist control of the situation, she's asking for spellings of names. And Mr. J, and how is that spelled? J-A-Y, thank you.
Thank you.
With regard to the third request is to a classroom, Captain DiGiovanni.
So that classroom is a multi-purpose classroom. It's used by programs and chaplain services. I cannot allow the use of a classroom. What I can offer is if the defendant is willing, I can move her to a housing unit and place her in a secure cell where no one will disturb her and she can...
This is really good, too. This is where Captain Giovanni does her Rick from Pawn Stars. I know what you're asking for. Can't do that, but what I can do is put you in your own cell, away from the big bay. You'd have all the time that you say you want to go over your files. You wouldn't be disturbed. It's really the ideal situation for somebody saying what you're saying if they weren't lying. But you're not lying, so isn't that a great offer? Isn't that a great offer, Sarah?
Review and conduct case review. She will still have access to a shower. She will still have access to open day room time. She will still have access to phones, but the review and her location will be in a secured housing location where she would be the only person in the cell.
I just noticed that.
And now Sarah trying to show off her, she's been in the...
I'm doing Sarah some favors here by covering her up with my own handsome image. But no longer Sarah. The free ride's over. Almost over.
Jail for a while, so she knows the dorms. So she's not going to call it K dorm and L dorm. That's Kilo dorm and Lima dorm.
Miss Boone?
Captain, is this Lima dorm?
K dorm.
Kilo.
Has to correct her. Kilo. Because I'm sure it's what they say in the prison, but just needs to correct even at things.
Kilo dorm. This is a raid. Take them out and bend over and spread them. Kilo dorm. Everybody out. That's what they're hearing. But yeah, K dorm. Kilo.
Has to correct her. Kilo.
And it's
Miss Boone?
Captain, is this Lima dorm?
No, it's Kilo dorm. Fuckface. Thank you, rolling along.
K dorm.
Kilo.
Has to correct her. Kilo. Because I'm sure it's what they say in the prison, but just needs to correct even at things that, really don't need correcting, just to show that she knows something. Oh, Kilo. Isn't that the former maximum security unit?
So my only options are being moved to the maximum security dorm or...
Tanika pointed that out in a video too just recently. I can't remember exactly what the context was, but in written communication, Sarah used Papa to refer to the letter P, like 1 Papa 5 or, something like that. And Tanika's pointing out, like, there's a reason you use that. Like a lot of times in air traffic, you'll use Papa because P can sound like T or V if you've got broken communications. So you say Papa and then it's clear, no matter what your dialect is, whether you're Russian, South African, American, everyone knows you said Papa. But she said it in written communication and it's like, you can see it's a P. You don't need to say P as in Papa. Oh, dumb Sarah, trying to be smart.
My bunk.
K dorm is no longer a maximum security. It's a multi-purpose area with inmates of varying needs.
That's right, rolling along totally like Mackenzie Shirilla, copying the language that she hears from the other inmates so that she can sound like she's a hardened criminal like all of them and therefore shouldn't get fucked with. But I bet she gets fucked with.
Being secured and housed there.
So it has, all the accoutrement of a maximum security wing, meaning locking doors and secure housing units. It would seem like an ideal situation. Like if I was in prison for something I didn't do and I wanted to review my documents, it would be a godsend to have my own room where I could just sit in there, even after hours, 2 a.m., wake up, work on my little documents and, try and find nuggets of information in the discovery that are going to help me. She doesn't want to do any of that, though. She has her comforts in the Big Bay.
So it is not the maximum dorm any longer.
That's correct.
And I'm unable to utilize the classroom for an hour or two per day while it's dark the entire?
While it's dark the entire... You can say day. You don't have to just end it at entire.
That's correct.
It's as much the dangling preposition as it is the implied nouns. Like she thinks just because she used a noun recently, it's somehow more profound to leave it off the end of the sentence.
Dark the entire. You can say day. You don't have to just end it at entire.
That's correct.
I do love the way that Captain T. Giovanni, if you don't need to use 100 words, use 2. That's correct.
Correct.
And I'm unable to utilize the classroom for an hour or two per day while it's dark the entire?
That's correct.
And if I may ask, other than it being accessed on a rare occasion,
Hey, Juror 3.
the two classes that do...
Juror 3 is here currentistically and prioristically. You hear your own names in the prioristic chat. Shout out to being on both of these streams. I believe this was almost 5 months ago.
Participate in that classroom.
No, not 5 months ago. 4 months ago, 16 weeks. 4 months ago.
Why is it that I'm unable to sit and be viewed by the officers at all times in my dorm comfortably to be able to utilize the phones on a regular basis, the day room on a regular basis, to be able...
I would like everything and then some. Can I get everything you're offering plus freedom to come back and just hang out and tell the people in the Big Bay how I have my own room? No, can't do that. I'm going to bring up Kim Stole My Fish Soap's comment here, talking to Disney, but says, you know, I might just go to jail to have a break from my kids. The single cell would be like a luxury resort. My mom used to fantasize about that, just running away and then renting a cheap motel room, like one of those 5 and dime, cheap neighborhood motels, and just having a sleep, turning off the phone, coming back in a day, like, where were you? Oh, I just, needed to get away. But yeah, no, dreams of a spa vacation, anything, just 24 hours.
to go outside to recreation, to have just for fresh air. How is that? I'm not
Hey,
understanding.
Detective Koala. You're not understanding how to act as your own best advocate. So all of those things is Sarah trying to testify when she should be asking questions. Detective Koala coming into the chat reminds me, because it is almost 1 o'clock. I'm going to premiere this video we're watching right now tomorrow at 1:30. Just this clip, I've already premiered the previous 2 episodes, but this is 2.5 hours. My thinking for that is that is the best possible time for both the UK and Australia. No, it's not the best possible time. The other would be 1:30 a.m. So I might set up a poll here. Please only vote if you're from Australia or the UK. Maybe I'll put in a third option for people who aren't from those that still want to participate. But basically, what is better for you? If I do 1:30 p.m., so right around now, like 45 minutes, then that's morning for the west coast of Australia, early morning, later in the morning on the west coast, and it's prime time evening, like into midnight viewing for like London and Europe and stuff like that. Flip side, it would be 9 in the morning for London and Europe, and then 6 p.m. for Australia. So either of those work for me. It doesn't need to, like 1 o'clock is fine for a North American audience, but 1 o'clock in the morning is fine too, because they all get to watch this now at 1 o'clock. Anyway. Sidebar. If she really wanted to follow this line of argument, she would say, Captain D. Giovanni, isn't it true that for fresh air, people in the Big Bay get let out for an hour a day? Isn't it true that in the secure housing units, you only have access to XYZ? You can ask questions to get this info on the record, but Sarah needs to pontificate on all the things that she knows, and then ends up just leading herself down like a dead end where she doesn't have a question at the end of it all.
Specifically why the reason is it has to be so extreme from going to being locked behind a door 24 hours a day to not being able to just utilize the classroom for an hour or two per day.
Nobody's using the classroom that's for all 400 jails at certain points of the day, so I'd like it all for me.
Ma'am, you will still retain your rights as an inmate and have access to all the services and day room time that you currently have during the same operational hours. And instead of having to move items from a housing area into a classroom where the officer may have line of sight, I cannot guarantee that my officer will have continuous unfettered access to you to ensure the safety and security.
Fettered. That word comes up a lot. Unfettered access. I'm going to look up in the background, but we all know what unfettered means. Do we ever hear that word without the prefix? I'd like to have fettered access to this and fettered access to this. Or, you know, you can imagine in prison that all your access to everything is going to be fettered, right? I'm going to look up fettered on my own time here.
Security of that classroom while something may potentially occur in the housing unit. So as a matter of security to the rest of the inmates in the housing unit that you are currently assigned, my staff and the facility, I can make the accommodation where I could put you in a single person cell.
Repeat yourself. Yeah, make it clear for her because she needs it told to her twice with simple words. Fettered means restrained, restricted, or bound, often in a way that prevents free movement or progress. It describes someone or something weighed down by literal chains or metaphorical limits. Fettered. Sarah Boone is fettered.
Where you would have unfettered access, uninterrupted access to your case material, and still have my officers in the housing area where if you had a question or you wanted to take your shower during normal day room time, you would be able to do so.
I love how they're making a point of like, and for God's sake, shower, Sarah. We're giving you every opportunity to shower. Please take the opportunity to shower. Whatever we do to move you around, you can still shower, Sarah, please. For the love of God, shower.
I've been in a situation where I have been behind the closed doors also when I was made PC, when I first got to.
We're going to go drunk Sarah for this because this is a little whiny diatribe that should be listened to in her drunk voice. Oh, I was made PC.
Area where if you had a question or you wanted to take your shower during normal day room time, you would be able to do so.
Okay. Why won't this work for you, Sarah? Please tell us how this would be, you know, something that you wouldn't like.
Crotch collar.
So
I've been in a situation where I have been behind the closed doors also when I was made PC when I first.
PC is protective custody. Protective custody is where a lot of inmates spend their first days because they're worried about both harming themselves or danger to them from other people in the prison. Sarah made a big point of saying how she was in danger from the Torres family, so probably threw herself into protective custody because of those complaints and concerns of hers going into the Big Bay.
Got to County Corrections Department, and if it's anything like that, I do not ever want to have that experience again.
Unfortunately, you will have that experience for life. For life. Life in a Florida prison. That said, she's still in the Big Bay. She's still requesting the Big Bays, right? She's in the annex, which is the Big Bay of Lowell. Lowell, you're in Lowell. But yeah, if it's anything like that, I do not ever want to have that experience again. Sarah, you're in court for locking someone in a fucking suitcase, and you're complaining about being locked behind a closed door. George would have loved to have a room with a closed door, Sarah.
And to be honest with you.
Oh, please be honest. Be honest, Sarah.
Forgive me, Captain.
Forgive
but
me.
I do not believe that it would be.
Take a break from Slow Sarah to read Kim Stole My Fish Soap's comment. I love how Scott told her that she'd be in the Big Bay.
And then they ended up putting her in protective custody. Hope she had a panic attack.
Is simplified, and nonetheless, I'm behind a closed door.
I don't think it would be simplified, and nonetheless, I'm behind a closed door.
For 24 hours.
No, everyone's at least 23 and 1. And it's that the door is closed to secure your belongings better than your stupid fucking drawer that you were going to put the USBs in to protect them from the jail guards.
Is there anything that I can do? Any kind of...
Can I do a special credit assignment? Is there something I can hand in late for bring my grade up to an A? It's very important I remain a straight A student.
Research or further explanation in order for me to try to still be able to utilize my dorm, which is general population dorm.
Yeah, some research will help you with that, Sarah. There's some research you can do.
Hairball yarn, from what I understand, I don't remember doing this for very long. There's just a couple of points where I thought she sounded ridiculous drunk, Sarah. I also do it for over and above. So there's that coming.
So that you can do this. You can secure your general population dorm. Is there any research?
Where I do have friends.
Friends?
I do have...
Friends? What kind of way is that to live? Ugh. Friends? No way to live, man. Comforts.
Some type of comfort there.
What kind of comfort do you think Sarah's getting there? You get some kind of comfort there.
In order for me to be able to access the classroom, or simply are my options from working on my bunk or to the extreme of being behind a closed door for 24 hours.
I think we return to full speed here. Welcome back.
We're in real time now. Because there's no question. Captain. Captain, I'd like an answer to my long rambling diatribe that really had no question.
My name is
Captain?
Fuckface. My number is 42.
Comfort there. In order for me to be able to access the classroom, or simply are my options from working on my bunk or to the extreme of being behind a closed door for 24 hours? Captain?
Judge, I'm going to object to that question. It calls for her to speculate at this point as to what all the other alternatives may be. She's simply here to, responding as to this particular request, and now she's asking her this kind of this broad, general question about alternatives.
The objection is sustained.
What does sustain mean, Your Honor? This is when Sarah still doesn't know what sustain means.
In regard,
She was just kind of waiting. Hello to Bedtime Lullabies, who's driving but listening. I hope you're enjoying this as much as we are. We're having a great time here. Scott Shevenell, please continue.
to number 4, earphones or headphones.
Bad
I would
idea.
need to consult with legal because I don't know what the ramifications of that is. We've not had a pro se inmate ask for earbuds or headphones. I would have to defer to legal counsel and my chain of command for guidance in that request. With regards to number 5, internet access. Again, we've not had a pro se inmate, or at least not one that I've been responsible for, request internet access without limits. So again, I need to refer to legal counsel with legal counsel and my chain of command to get
That little do. I think was a phone that was in the testifying room that Scott Shevenell and Captain Giovanni are in. But we're taking a pause to thank Bedtime Lullabies, who has given 5 Dan D True Crime memberships.
Double thanks.
Angel for Manny, Melody Hatfield, Allison Dolly Lama. I love that name, Allison Dolly Lama. The Dolly Lama. Beth Serrano and Kel X82, you've all received gift memberships from Bedtime Lullabies JLC, who's driving in their car.
Welcome,
and
Carolina.
Listening to us enjoy ourselves. Thank you. Thank you so much.
Carolina, just for your bearings, the orange shirt is live. The Aussie shirt is prioristic. We are right at the point of the pro se hearing where Sarah and Scott Shevenell, they're just jousting. Scott Shevenell hasn't pulled out the strongest arrows in his quiver yet, but he's got them.
guidance on that. Regarding number 6, a word program.
Sarah can't use the Notes app. She needs, headlines and fonts and the whole word processor program.
We've not had a pro se inmate, again, myself, that requested access to a word program. I would need to consult counsel, legal counsel, and my chain of command for guidance before we can make a response. Number 7, telephone access. In her statement here, as you are aware, my dorm contains payphones only and are limited.
Okay, so this is good too. Captain D. Giovanni is reading Sarah. So I'm going to slow her down, not quite as much, to about 40%. And it's funny that just slowing down someone reading Sarah makes them sound so much more like Sarah.
This is a much shorter interval
Pro se
of
inmate,
the slow
again,
down speed.
myself, that requested access to a word program. I would need to consult counsel, legal counsel, and my chain of command for guidance before we can make a response. Number 7, telephone access. In her statement here, as you are aware, my dorm contains payphones only.
So I have to say, I'm going to interrupt it right there, but Captain Di Giovanni slowed down sounds remarkably like Sarah.
And are limited to only 15 minutes per call, which are collect. I need to be able to communicate on a regular, normal phone.
Unfettered.
A regular normal phone, not an irregular normal phone.
Third.
To make all necessary calls.
Rolling along, I did a 1,000-piece puzzle in 2.5 hours, and we didn't get the damn flag done. We got about, I would say, as many as 30 pieces together. 3 magnums of wine, 3 people, 1,000 pieces. As many as 30 pieces. Not less than 20, but as many as 30.
I really love this Sarah impression by Captain G. Giovanni here.
I'm turning the page.
Hey, Jane Crow, welcome to the Fine and Dandy crew. I'm turning the page.
For my case. to use in trial. I have no other way to contact anyone that is not collect, which incredibly.
You know what? I am going to comment on the 1,000-piece puzzle because it's a little detail. It's a weird one. We've never seen the puzzle. There's the body cam footage. The one thing that I think speaks in favor of the puzzle actually existing is the fact that while Sarah's sitting outside of her own house and the cops have full reign of it, she says something about you can see the puzzle. So I believe that there's a puzzle there that's done. I think the reason you would leave a puzzle with one piece missing is to find the piece. So maybe it's something that Sun worked on. They, half hour here, 20 minutes there, a little bit more, and they finally get it done. And oh my God, there's a piece missing. Just leave it. We'll put a tablecloth over it. And they just left it on the table and, hoping to find the piece. And then when all this happens, boom, tablecloth comes off. It was puzzles. It was puzzles and paint night. Puzzles. That's why we did the puzzles.
I believe that diminishes.
Little shade on her handwriting.
I don't know what the other word is here. If not all of my opportunities to properly prepare. The phone
Looks like I'm bringing it back up to
system
full.
that we currently have in the jail for the inmates to access is as is. I don't have the ability to make any modifications.
It is interesting to slow it down so you actually hear the stupidity of it. The phone that they have for inmates to access is as is, so I don't have the ability. A bunch of words to say nothing. Oh, so the phone is what it is? Okay, moving on. Welcome, Nola
Okay,
Stevenson.
we'll go back to live. Because that's where she says basically the rules of the internet are what the rules of the internet are. I'm not making modifications.
The phone system that we currently have in the jail for the inmates to access is as is. I don't have the ability to make any.
We're just going to get a special bat phone for Sarah where she gets to make phone calls and we'll just put an extension cord and run it to your room like it's 1990 and you're a teenager. Oh, my parents just keep listening in. I have to shut the door with the cord on the other side.
Modifications.
Hello, Beth Serrano.
Number 8, discovery hard copies.
Here we go.
It seems that
I told you to stick a pin in that. If I'm allowed to have my 2 full boxes of hard copies, I don't see why I can't also have this.
Miss Boone already has access to her hard copies. The concern I have to do now is do some research with legal and my chain of command because that quantity of paper can potentially become a fire hazard. And we have standards in place. And Judge, I'm not certain if you're familiar with the Florida Model Jail standards.
Gen X Gamer Girl says, I still want to know who she was going to call. My speculation, and I don't know, maybe you guys can correct me on the timeline if I'm wrong, but we're talking August of 2024. So at this point, both Lana and Third Rail are fully involved with Sarah. So I imagine that she wanted unfettered phone access so that she could talk to them without it potentially having a phone calls from prison style jail record like Wade Wilson and Mackenzie Shirilla. I still don't understand how her calls aren't part of that sort of a record, especially if she was committing crimes on the calls Or, well, I guess if there is a name as the stuff that we've heard released, then, you know, maybe that's why they're not part of the record, is they're as irrelevant as she is. But yeah, that's a good question from Gen X Gamer Girl. And I think she was wanting a phone to communicate with her Flying Monkey crew as it existed in August of 2024. Because this is right around the time, I definitely remember from the Tanika tablet messages, going into the trial, we were aware that there was the Delapine Creative Company that was talking about doing documentary work for them. And at that time, we didn't know very much about them at all. Interesting side note there, the Delapine Creative website is no longer available. So if you look up Delapine Creative, you'll see just a 404 error type web page now, no longer that ridiculous running chicken. So,
all right, I'll conclude that side tangent with one of my own. Fletcher Boy is talking in the comments. It sounds like there's some malicious gifting going on. He has he's gifted some dipping sauces and oatmeal cookies to a certain inmate that we're all familiar with, may even be watching content on right now. Fletcher Boy writes, Dan D, I'm asking you in the chat for help with the next gift I send Sarah. Just so you know, the dipping sauce and is for chicken tenders, so pairing them with oatmeal cookies was a natural. Now, the last time I heard of this sort of tactic was Chandra Vander Ark, who, awful person, but used to punish her youngest by withholding food and using hot sauce, like, you know, oh, the stuff at the store's not hot enough, I have to order internet crazy hot sauce. So somebody started ordering her hot sauce on her commissary, and I guess you can only have so many gifts given to you in a certain period. So if you were gifted 4 hot sauces, then you can't be gifted the $50 because you've already been gifted the 4 hot sauces, which meets your limit. Something like that, anyway. Sounds like Fletcher Boy's doing that, so help him out in chat. Needs your help now.
That's the way that is.
But the quantity of paper is actually the problem. So we may have to come back to the table for a different type of resolution regarding the 2 cases of paper discovery.
Yeah, we still got to figure out the 2 cases of paper discovery. Little side note here too, but as they pull around the room, you'll see that Mr. Cacciatore, they're in rolling chairs. You see the chair over here for the court reporter is a, you know, nice ergonomic rolling chair. They found Sarah a green chair that doesn't move to sit in. So just a little fun note for us Sarah Boonophiles.
Ma'am, do you have any questions regarding Captain Giovanni's?
Yeah, a little update, Ramono. No, I never got contacted by Third Rail. I thought I made a fairly legitimate, you know, good faith offer, put it out there. If nothing else, you know, somebody probably mentioned it to them. If in any case, no contact was made, they're not interested. And upon reflection, like, first off, you can't just leave an offer out forever. So, you know, now they can come to me with a better offer than what I gave them if they're still interested. But my realization was I can barely keep up with everything I'm doing now. If you notice, the last 2 months, I've done more production per day than any other time in my channel's history. And there's less new Sarah news than at any time in Sarah Boone history. So, frankly, I think they need me more than I need them. And, you know, it was an interesting offer. When I was looking for something to do at the time that I made the offer, it seemed like, you know, that's something I could dig into for 6 months, 9 months and plug it out. But at this point, I'd rather have the freedom to do whatever the fuckface I feel like. So the offer was withdrawn. It was withdrawn immediately on the formal citizen complaint. My hope was that the jail calls might get released because of that
complaint to the jail, maybe to, verify the other jail calls, whatever. But I figured if jail calls come out from the prison, that's going to be so much more valuable than any kind of edited, recorded calls by a third party. So official source data trumps everything. So anyway, the offer was rescinded. I'm no longer interested in it. They can certainly contact me. They can prepare a pitch deck if they are so inclined. But yeah, there's nothing developing on that front.
And the Orange County Jail's position with regard
Boone aficionados. Yeah, I don't know what the quite word. Not file though. Those are lovers of. We're lovers of the downfall of Boone.
To the earphones, headphones, internet usage, word pro.
Speaking, this is completely off topic, but for people who are a fan of JD, A Lawyer Explains, I was watching a video from him, October of 2024.
Oh, this is good.
I believe the exact date was October 22nd, 2024. He used Boondoggle with the BOONE doggle, portmanteau, but used Boondoggle to describe Sarah's situation online one day before Third Rail had a channel. So credit to JD, A Lawyer Explains, for coming up with Boondoggle and using it correctly. I know Dreadful Penny 2, another fun channel for some Sarah Boone coverage, is annoyed by the fact that they spell Boondoggle just like the dictionary way. As a parody and satire person, I love that they did that because I can throw boondoggle in all of my titles and it's just an English word, so they can't trademark it. I can parody their stuff, and anyone who goes looking up boondoggle content gets delivered some dandy little fresh slice of truth and honesty with a musical backbeat.
Oh, there's so much commentary on this channel.
Telephone, and the concern regarding the hard copies and it being a fire hazard.
I do, and I was also including number 3, the classroom utilization. I just want to make it clear and in open court that I want to have the understanding.
She says clear and in open court. What she really means is like clear and on the record for an appeal, but she doesn't realize why people say that they want stuff in open court.
With everyone that it is an option of mine to decide to remain on my bunk with this discovery in the laptop, and it is
Hey, Bella's mom.
To be moved, but I have the ability to make that decision.
Judge, I have no objection to that. I am not looking to impede anybody's ability to access to a general population housing unit. I was simply offering an option that would be amenable to security.
It's a fairly good option.
Potentially Miss Boone.
Do I have to decide right now?
Am I able to proceed?
You can.
You can.
Thank you.
So for my understanding right now, you need to speak to your legal counselor in regards to the headphones, the internet, the Word program, and the discovery hard copies, which I already have. Is that correct?
And telephone access. You want unfettered telephone access.
Unfettered.
If I read your letter correctly.
Reasonably, I would like to have access to a regular phone. It could be 1, maybe 2 times a week where I save all of my calls for a particular day. I'm always up for solution. It's just whatever it is that I can do in order to progress properly and expeditiously. I'm trying to do.
I'm always up for solutions.
So by having this where I am confused why this was not all solidified prior to the implementation of the laptop.
Here we go to the trailer. Thank you. This is my first time doing a trailer for a live. I think I'm going to try and do this more often, but find something I'm looking forward to in the live, do a 2 or 3 minute clip of it, and then maybe a longer 5-minute video. And then way more people are aware of the fact that I'm even doing these rewatches. But if this sounds familiar, it's because it was in the trailer that you might have watched while you're waiting for today's episode.
So
Hairball Yarn makes a point that I feel that one of the guys might have been feeling embarrassed by the association and that he expected to be welcomed into the community with open arms. Found themselves kind of reviled. And yeah, I can see I totally get that they were looking at Tanika and thought that that the audience for this material was some kind of slavish Sarah Boone content zombie that, would just, creator with the new stuff, follow, and, weed out brains and just go, to the new creators. We built relationships with the people we watch. Like, I'm not going to suddenly stop watching Suma and suddenly stop watching Danielle, after growing and being a part of their community. I'm interested in everything they cover. Maybe some of the stuff isn't as interesting to me as the Sarah content, but that's fine. There's plenty of other content on YouTube to choose from. But yeah, I think he made the mistake of thinking that we were just these brainless Sarah zombies that would be, like moths to a flame of Sarah content. And then they were so ham-handed about their little compilations that it invited criticism. Like, it was like, who the fuck are these guys? Why would they be doing it this way? So they put themselves in a bad position right from the start. I don't want to go off on a rant. I'll save that for the ramble. But yeah, that's enough. That's enough.
I'm very, I'm waiting for whatever it is that I can do to fully access and become a pro se defendant and inmate. Do you know when, how long the deadline might be for the open-ended items that I would be waiting for?
Judge, this is Scott Shevenell. I'll chip in with the legal piece of it. The legal piece of it is simply that she's a pro se inmate. She's not the first pro se inmate that the jail has had. We've had several. And the issue is whether or not there's any constitutional or statutory violation with what we provide pro se inmates. And I would argue that there's not. She has access to the court as required by the law. Everything she wants is over and above, what our typical stance is for pro se inmates.
Hold
and
on.
all those policies are in place for a reason. But somehow she wants to go beyond that, and she wants all this extra.
Okay, so we've had one over and above, which means I need to pause and set up an over and above counter. But that becomes, if you remember Pee-wee. And just a spoiler, I had no idea how to set up a counter. I still don't know how to set up a counter. So very quickly, I realized I don't know how to do that, but it's a good idea. These Playhouse, they used to always have like a word of the day, and everyone would just go crazy, and they would tell kids, like, when you hear the word of the day, you just scream like mad. Don't tell your parents why you're doing it, just do it. So parents loved it. Got that cherry chair? In that vein, I'm thinking that this is the phrase of the day, because we'll hear it a lot now. What I'm doing is looking up something that says counter as a sticker. And how am I going to change number incrementally? You're not. I should have thought of that before I started doing the counter. Oh, no, that's not going to work. Okay, I'll just hit the ding. I like Mitch Hedberg points out. You could just count. I'm already doing 50 things plus the 50 prioristic things I was trying to keep track of. Please don't make me count. Please don't make me count. I'm doing it. Just don't make me count. Every time I hear above and beyond, we'll see how many dings we get. Above and beyond comes up a lot. The last 40 minutes of this video.
Consideration more than anybody has ever been given, frankly. And at the end of the day, again, it's a constitutional question. Is it a violation of her constitutional rights, the restrictions we have in place? And I would tell you it's not.
Is that a position, Counselor, that you're taking today? Because Captain DiGiovanni had stated she needed to consult with legal counsel as to the issues of the headphones, internet, word processing, telephone, issues. Is that the position that you're taking today, or is that something you need to further investigate to have a final position as to that?
No, that's my piece of it from the legal end. Now, of course, she's got to talk to her folks as far as the security end of it, because a lot of those things are in place because of security concerns. But from a legal concern, I can easily answer that today. And the answer again is, legally she's allowed access to the court and all these other things that she wants in her case, and she's kind of put herself in this position today. And the case law is not real favorable to folks that put themselves in that position.
Ma'am, do you have any other argument with regard to these requests as to the headphones, internet, word processor, or telephone?
So my understanding is that I'm being penalized by Orange County Corrections Department because of their misunderstanding in regards to my, in quotes, 8 attorneys prior.
So that has nothing to do with what Judge Kraynick just said. Let's even rewind it. Judge Kraynick gave her clear parameters, and instead she's focused off of she was triggered by Scott Shevenell, and all she could think, kind of in the same way that near the end of the trial, when their victim impact statements are being given, and George's daughter says, for a lot of you in this courtroom, this is just another day, but for me, this is forever. And Sarah probably didn't hear the part about other people in the courtroom, but just heard her say, for me, this is forever, and took offense, like, yeah, it's forever for me too. And it's like, yeah, you're not who she was addressing. Anyway, Sarah was so triggered by that, she let it infect her whole Kintu Sukuroi forgiveness speech, where she kept talking about, this is forever.
I'll take a
this
look,
is forever. Anyway, she gets distracted by Scott Shevenell and can't answer Judge Kraynick's very clear, do you have any questions regarding the phone, regarding the laptop, regarding the access?
Several attorneys are pointing to her case, and she's kind of put herself in this position today. And the case law is not real favorable to folks that put themselves in that position.
Not intentional, missed what I was counting with all the talk about how I'd count it. Just an over and above counter, because it starts with, I just want to know what's over and above. But because Scott Shevenell says, just so you know, what the inmate's getting is over and above what any pro say. What is over and above? And then she's so fixated on it because she's like, I just want to know what the minimums are so I could even ask for over and above.
Ma'am, do you have any other argument with regard to these requests?
Any other argument with regard to these requests?
As to the headphones, internet, word processor, or telephone?
Headphones, internet, word processor, or telephone. What are you going to ask about, Sarah? Which of those four?
So my understanding is that I'm being penalized by Orange County Corrections Department because of their misunderstanding in regards to my, in quotes, 8 attorneys prior. Is that
in quotes, 8 attorneys prior? And just so for people who are keeping track of time, there's 1 hour left in this video that we are rewatching and reacting to, which means probably an hour and a half left of stream. And we may extend that a little bit by reading some more of the 16-page order from Judge Kraynick. I think I want to turn that into its own separate video, but I'll share it with you as I'm learning it for the first time, because that's always fun.
why I'm unable to have anything in order for myself to properly represent
Thank
myself
you,
as a pro
Hairball.
se defendant and inmate?
Hairball yarn.
We might have to revisit Danielle Chavon telling us about Vickers and fuckface because, current news is important. Can you believe that someone called Sarah fuckface? And it's officially on the record, fuckface Boone. Fuckface Sarah Boone. Sarah fuckface Boone.
Has joined the chat. Thank you very much. One thing, I think I'm on subscriber only chat, so if you see somebody chat.
Note to self, mark this video for moderate profanity.
In the chat, they have subscribed, so thank you very much. I'll give a live subscriber update when we move to the next video. We still have about 30 minutes left in this video, so 45 minutes of this commentary, and then I think about an hour and a half in the follow-up, the James Owens joins the team video that we'll be watching next.
Of the Orange County Corrections Department?
I'm not going to answer that question.
I'm not going to answer that question. I love how Scott Shevenell jumps in, though, because later he's like, I'm not, what am I, a witness here? But on this one, he can't help himself. He jumps in before Judge Kraynick even says that he's not going to.
Standing in regards to my, in quotes, 8 attorneys prior. Is that why I'm unable to have anything in order for myself to properly represent myself as a pro se defendant and inmate of the Orange County Corrections Department?
I'm not going to answer that question.
Not being penalized, just the opposite. She's being treated like every other pro se inmate in the institution. She's not being penalized at all. She wants consideration over and above what everybody else has.
If I may please, what is over and above? What other pro se inmates, what is it that they've asked for? I don't see how they could successfully even represent themselves without internet and a regular working phone. And I'm pretty sure that they were not able to complete their case and the successful outcome that they were hoping for by being provided simply papers and pens.
Notice she does the little head turn like a dog again, like, why are you not responding? I'm not getting the response I expected from what I just said. It's because you didn't ask a question. Your questions are supposed to be for Captain D. Giovanni, not for Scott Shevenell. But they give her so much time to just marinate in her stupidity here, so we will give her the same time. 109:41.
This is before I learned about arrow keys.
9:29 will be her still talking. Yeah. Let's just enjoy every second they let her marinate in her stupidity.
Their case and the successful outcome that they were hoping for by being provided simply papers and pens.
Counselor, if you...
I'm not sure if she's asking me a question. I don't know if I'm a witness in this case or if she's trying to ask me a question.
I'm not. You're just simply the attorney.
You're the attorney. This is where all of a sudden Judge Kraynick becomes a traffic cop. Like, no, you're an attorney. Hairball Yarn is the newest member to Dan D True Crime. Thank you very much, Hairball Yarn. She's the defendant. She's an awful person. Her name's Sarah Boone. She locked her boyfriend in a suitcase and mocked him. For everything you done to me. For everything you done to me. And that's why she got the buzzles and the paint. Welcome, Hairball Yarn. Let's hear their response now that they've given her 12 full seconds to marinate in her stupidity. Judge Kraynick, what is everyone's roles here?
Attorney for one of the participants, sir. If you're under no obligation to answer that question. You are just providing your legal position with regard to the Miss Boone's demands and requests.
They're simply requests.
They're simply requests.
I'm not sure who it...
I don't know why you would categorize these as demands. I'm not demanding. All right, we're going to give that a full... Let it have its full time to play without interruptions.
Counselor, if you...
I'm not sure if she's asking me a question. I don't know if I'm a witness in this case or if she's trying to ask me a question.
I'm not. You're just simply the attorney for one of the participants, sir. If you're under no obligation to answer that question. You are just providing your legal position with regard to the Miss Boone's demands and requests.
They're simply requests. And I'm not sure who it might be that could answer my question, please, in regards to what prior or present other pro se defendants and inmates have requested. So I might have a guideline of something to go with forward. And I, again, do not know what is above and beyond simply.
What is above and beyond? Well, Becky again is above and beyond. She just sent 5 Dan D True Crime gift memberships out. She's gone above and beyond. So Kathleen Roloff, Kawiva Mom, Mrs. Shan, Sarah Bridget, Jess Melissa, you've all received True Crime memberships because Becky again went above and beyond. Thank you so much. I really appreciate the memberships are they really mean a lot to me. It's I'm just going to take a quick break. I'm terrible at quitting on myself. Like if I, resolve to go to the gym and work out 3 times a week, chances are I'll go 0 times a week and not really feel bad about it. But if I'm part of a sports team or like I used to play soccer and I would get out every week, whether I felt tired, whether I felt, sore, whatever it was, because I didn't want to let down the team. And every time you guys buy memberships, it makes me feel like I'm part of a team here on YouTube. And I don't want to let you down. I want to be here every Friday because I know people bought memberships and they're enjoying hanging out. So I just wanted to let you know that the memberships really mean a lot to me. Not that, I prefer members over non-members. Anyone being here matters to me. But the fact that people are buying memberships and gifting memberships, it's not just a small thing. It's a big thing to me. And it really helps my own motivation to make sure that I'm delivering content for you guys that you enjoy too. So thank you from the bottom of my heart. Just a real moment here.
Asking for more than paper and pens in order to properly and rightfully and lawfully represent myself.
Counselor, to the extent you want to respond to that, you can.
Yeah, I mean, Judge, like I said, we've got tons of pro se inmates.
To the extent you want to, I got to exhale before I talk. It's this rookie mistake. I've been doing it all morning. To the extent you want to respond to that. Yeah, you know what, Judge? I'll throw a bone on this one too.
In order to properly and rightfully and lawfully represent myself.
Counselor, to the extent you want to respond to that, you can.
Yeah, I mean, Judge, like I said, we've got tons of pro se inmates that have come through, that are there right now, that have come through the jail, and they get standard treatment, and she wants out.
Becky, again, has gifted 5 memberships. She just got herself a membership. Thank you, Becky, again. Thank you so much for gifting memberships before taking the plunge yourself and joining. But that's awesome. That's the way to think of other people first. That's pretty sweet. Anyone who gifts memberships too, nobody's really taken advantage of it, but anyone who, pretty much anyone anyway, but if you've ever gifted a membership, you get a free super chat. Just put capital SC at the beginning, like in capitals, and then maybe in quotes what you want as a super chat. I'll pin it, I'll read it, and that's my gift to you. Thank you.
A lot of things that are over and above that. For instance, again, unfettered phone calls.
Thank you,
She
Lakeisha.
wants to keep things in her cell that she can't normally keep.
Oh, well, thank you, Suzanne.
So there's a lot of issues. I mean, that's a wide open question. But, can I speak to everything that everybody's got in the past? How many pro se inmates we've had that have come through the institution? No, but I can tell you that, we could probably find plenty of examples if need be as to what people have received in the.
You know what? We're going to rewind Scott Shevenell because I appreciate this, and I'm going to give a public service announcement from Hairball Yarn. Her comment is, I'd give you all the memberships, but I'm on an iPhone and I don't have a computer. I understand why you don't have super chats, but you might consider turning it on every now and then. So 2 things, and it's a great point. If you're on a phone or going through the app, don't gift it. Half of it's going to Apple. Just keep it. Just keep it. Just keep it. If you really, really want to, I think the way to do it is you go through your regular app. You go to www.youtube.com. So you're no longer in the app. Then you can log in. If you're just wanting to do like a quick spot, gift or a membership purchase, that's the way to do it outside the app and not pay the app fee and still have an iPhone if you don't have access to a computer. So that's the workaround. Again, I'm just as happy that you keep it. You hang out, chill. Somebody will gift you a membership, and then awesome, you've got one. And but just get into the show, Dan. Come on.
And it's nothing close to what she's requiring or requesting today.
Okay. Ma'am, with regard.
So things in her cell
30
that she can't
seconds
normally
back.
keep, that they wouldn't allow folks to keep. There's a lot of issues. I mean, that's a wide open question. But, can I speak to everything that everybody's got in the past? How many pro se inmates we've had that have come through the institution? No, but I can tell you that, we could probably find plenty of examples if need be as to what people have received in the past. And it's nothing close to what she's requiring or requesting today.
Okay. Ma'am, with regard to your state, do you have any position with regard to any of these matters we've addressed? Okay, thank you. All right, ma'am. So with regard to your request as to the laptop, this jail will be able to accommodate your request, and those extensions will be provided as placed previously on the record. With regard to your request to hold the USB drives in your own personal lockup, for the reasons identified by counsel, Shevendell, it's a matter of security and the protocol which secures, controls, inventories, and ensures in good working order the USB drives will be complied with, so that request will not be accommodated. Your request for a classroom similarly cannot be accommodated for the reasons identified by Captain DiGiovanni on the record. However, there is an alternative housing offer that can be provided for you. With regard to your request for headphones, that has been rejected and denied by virtue of legal counsel's argument.
Think of it, headphones, like it doesn't take the most imaginative criminal in.
I was really in a conspiratorial mood when I was doing this stream, but that's like I'm just immediately going to, how things can be turned into prison weapons all stream. I think it's because where I was broadcasting from, it was the cinder block part of the basement. So maybe it just made me feel like I was in prison after 3-4 hours broadcasting from the same 4 square feet.
The jail or prison to do something with a set of headphones.
And what is being provided to you. With regard to the internet, word processor, and telephone, again, for the reasons that counsel for Orange County has identified, those cannot be provided to you. The court does note that you do have the services of...
This is another time of him giving advice. He can't give advice, but he does note, and this is great because it's also on the record, showing, she's not some helpless pro se inmate with no resources of her own. Judge Kraynick, what do you take note of?
An investigator.
Ah.
And JAC provided you $10,000 and $1,000 for travel.
How do I get that $10,000? I just want it to be paid directly into my account, Mr. Kraynick. Do I make a motion for that?
Or your investigator. To the extent, as requested for the purposes of internet, for locating witnesses and experts, you have a personal private investigator that can utilize, he can do that for you.
Beth Serrano just found the channel and really enjoys it. Just got herself a free membership from somebody gifting it.
Welcome to PSR, who's just joined the chat, and happy, not anniversary, but rewatch anniversary to Beth Serrano, who I know has been in on this stream and was in on her first stream the first time we watched this, all the way back, episode 3 of the Sarah Boone trial rewatch.
That's fantastic. I think that's kind of explains my strategy for gift memberships too.
Oh, for Christ's sake,
I was just
quit selling the gift memberships.
Doing music videos to really start out. So there might have been people who, watched a few Dan D shorts and then kind of forgot about the channel. So every time you gift and one of those original subscribers comes back, they're like, oh, well, this has changed a lot in 6 months. There's a lot going on here. A lot of back catalog. So that's, your gifts are the gifts that just keep on giving, just like Sarah Boone to the true crime world.
I know you've made requests previously to look at your phone to find contacts and information. You also have a private investigator who would accomplish some of those tasks for you. And those can be communications and conversations between yourself and to your investigator as to who and when and where and what persons you might be able to seek to find. So for those reasons regarding the headphones, internet, word processor, and telephone,
definitely a lot of
arguments
Elizabeths.
of counsel for Orange County, I'm unable to accommodate those requests. The jail is unable to accommodate those requests. Those requests will not be provided. With regard to the hard copies,
those are prioristic bells that I would ring the bell whenever I agreed with what the person was saying, but felt like I'd been talking too much. So it's,
okay, enough. Not just going to chime in and say, yeah, like a hype man. But every one of those bells was coming in just as Rolling Along was gifting 5 memberships to Dandy True Crime. So those memberships went to Carolina Hurtado, Dreadful Penny 2, N.J. Leonardos, Marianne Morris, and Donna S. Ellers, or Sellers. I think it's S. Ellers. Could be Sellers. In any case, you've all been gifted Dandy True Crime gift memberships thanks to Rolling Along 4.
That's going to have to be a matter, if it needs to be addressed, it can be readdressed with regard to
Special thanks to Fuckface Boone for making this all possible.
the potential fire hazard. Captain DiGiovanni, would that still be an issue with regard to the fire hazard based on the amount of paper if Ms. Boone elected to move to the secured housing in the K dormitory?
Big welcome to Christine Garcia. You are also a member of the only level. Well, Sarah's contemplating a move to the Kilo dorm. Christina Garcia has joined the only level. Congratulations on your bloody keyboard. It looks like this is at least your second month of membership. So congratulations, Christina. And congratulations to Becky again, also with a bloody keyboard. So it does remember your initial memberships. If anyone's looking at the badges, the progression is Drunky the Bear to get started.
Still
a bloody keyboard for your second month.
Yep.
The Pro Se as your third badge, and there's an LWAP badge. That is the final form of Sarah.
If you guys see any yellow badges in the chat, that means they've been a member for 6 months. 6 months, like Lakeisha Priol. Congratulations. And that is an emoji that is available to everyone that's a member, but is a badge for people who've been here for 6 months. Because once you're here for 6 months, it's like LWAP, right? It's like you've lived your rest of your natural life with Dandy True Crime.
LWAP.
It's basically the Florida Model Jail Standard 7.12. The officer in charge or designee shall determine what personal items may be kept in the cell or stored with the inmate. However, an inmate shall be allowed to retain a reasonable amount of personal property, including but not limited to his or her legal material, personal hygiene items, writing paper, and writing instrument.
A reasonable amount. You can see Sarah quickly scrolling down because, she's going to say, I think it's only reasonable that I get all of it. Why wouldn't I be able to get the whole horse's mouth? I actually want the whole horse in my jail. Only reasonable.
And authorized reading materials in reasonable quantities as approved by the officer in charge or designee. Personal items will be kept in an orderly manner. Fire potential is reduced by limiting the amount of personal property in the cells. So it is.
Exactly. So let's say somebody, unrelated to Sarah, completely unrelated, has nothing to do with her. Not a co-conspirator, just prisoner sharing space.
Welcome to California Dreamer in the chat. California Dreamer joined on one of my first live streams, vertical live stream, talking nothing about nothing before I knew what I was really doing here on YouTube. Welcome back, California. Thanks for sticking with me.
One of 399 other people in the OCC gets the idea of, I want to start a problem, and what I need is a bunch of paper so that I can start a fire. Who has paper? Oh, there's that bitch across the dorm that has 2 boxes of paper underneath her bed. I don't give a fuck about her discovery, but I could definitely use that paper.
The sheer volume of paper, and that is what I need to conduct an evaluation from. Now, in Miss Boone's letter, if you give me one moment.
Oh, she's going to read the letter? I got to go back to a slow speed.
Not that slow.
Captain Giovanni decides to start reading in Sarah's voice.
She does read Sarah very well.
In number 8, Discovery Hard Copies, she writes the following: as I am presently
I can keep these in the permitted property bag.
This is perfect because her difficulty reading Sarah's handwriting combined with the slowed down audio really replicates you just have to pitch it up to get it to sound like Sarah, but the cadence with the language is just perfect.
Discreetly located at my bunk. I will purge the document.
I will purge the documents.
We will take a break from this slowed down coverage to recognize VC Wants a Pony. VC Wants a Pony was one of 3 people who became a member to this channel after I'd unlocked memberships, but before I'd done any kind of live stream or video. So I got the notification, hey, you can now have memberships. And I think I just posted something to my community page. Hey, I can now accept memberships. And VC Wants a Pony was one of those first ones there. You can tell by the LWAT badge. Sent out 10 memberships. 10 Dandy True Crime gift memberships. They've gone out to J.A.B. Berries. Yep. So what? K-Swan. Chawavamum. Tracy. Terobrarian. Terobrarian. It's like someone who reads cards, but also knows how to organize them by the Dewey Decimal System. Crow Dog, David, KF2, Kims, and Stephanie Patterson. Congratulations. You are the 10 people who've received gift memberships. Thanks to VC Wants a Pony. And a big welcome to Suzanne in Low, who has become a member of the Fine and Dandies and just earned their Drunky the Bear badge. This is fantastic. Thank you all for having such a good time.
Yes, I have.
NJ Leonardo says, sorry for the delay. I'm driving and listening. You just got gifted a membership, NJ. And if you are driving and listening, there's nothing wrong with you. Do not adjust your dial. This is just what I thought would be funny the first time we were watching it. It is Captain D. Giovanni reading Sarah's letter at 0.35 speed.
Now, and keep only new
Insta Justice, welcome.
hard copies.
As long as I'm recognizing people joining the chat, I remember Insta Justice was like one of my first, more than 10 subs person that subscribed to my channel. So welcome to Insta Justice. Check out Insta Justice's channel if you're looking for new channels to join. And you can click on any member's profile picture, and it'll give you the option if you scroll down to go to channel. So if you are wanting to check out a channel or to see if somebody in chat has a channel, by all means, check it out.
I can send to the property department and will purge anything already being stored for easy convenience and extra space.
She's always up for solutions.
I'm willing to see what she's going to purge and send to property. But at the end, I have to reduce any fire liability to the building in order to maintain security and safety for the 399 other inmates that I have.
When she says that, I totally think of Captain Kirk. Scotty, I'm responsible for the lives of 399 other crew members.
I can try that again, but because I don't like my read there. Scotty, I'm responsible for the lives of 399 crewmen. We can't allow this to happen.
I'm responsible for the safety of 399 other inmates.
Have here, along with the almost 100 or so assigned staff,
We have to kill these tribbles.
civilian and certified. I will also say that pro se inmates in the past have been afforded a second fire retardant property bag, and I'm willing to issue a second fire retardant property bag to accommodate the excess, but anything over and above that.
Over and above.
Little spoiler. Do you think Sarah's going to accept the second property bag, or she's going to find a way to go over and above?
We may have to find an accommodation, and based on the willingness of the letter that Miss Boone has written, she articulates clearly that she's willing.
I don't know how much of this is showing up on camera, but I might need to shave the old flavor saver up front here. It's catching a lot of beverage. It's just hanging out in the mustache and making it a little difficult to podcast effectively.
To purge and send to property any paper that's over and above.
Thank you, Suze. What? I'm responsible for the lives of 399 souls.
Do you have any questions?
And
well, no, go ahead.
And I can have that second property bag upon her return this evening.
Ma'am.
Okay, so that sounds fair enough. We're going to take your boxes, but we can give you a second bag. What do you think of that, Sarah? How do you feel about a second property bag? Something over and above, or will a second bag do?
Do you understand the second fire retardant bag that could be provided to you regarding the hard copies of the discovery?
I do, and it was already provided to me, but the boxes unfortunately do not fit in the bag where I did attempt.
Dumb. Sarah, who's able to fit George into a suitcase, is unable to figure out how to fit paper into a bag. She's just putting the full fucking box into a bag.
Well, just imagine like those videos you see of people like moving a couch into a car, or like, you know, a mattress that's clearly not going to fit in the back of a sedan, but they have no spatial awareness or recognition. Sarah's there with her banker's boxes trying to put them in this floppy fire retardant bag.
Like, you know, she didn't play with toys, like did no spatial awareness as a kid. Like, sure, you can fit the circle into the square hole, but you can't put the square into the circle hole.
You can depend on how it's
And even
designed,
had others
but
try to help me put it in.
Even had others try and help me. This is, again, another little, let's rewind it again to...
Yeah. Put that picture in your head, like Sarah and all the inmates scratching their heads like the monkeys at the beginning of 2001: A Space Odyssey. Box bag.
Fully enjoy her stupidity. But yeah, she first is claiming to be putting a box in a bag that doesn't fit, and then asking other inmates to help her put these boxes into bags that it doesn't fit. That's like asking for help fitting something into your, you know, hatchback that doesn't fit. Doesn't fit.
Do you have any questions?
And
well, no, go ahead.
And I can have that second property bag upon her return this evening.
Okay. Ma'am, do you understand the second fire retardant bag that could be provided to you regarding the hard copies of the discovery?
I do, and it was already provided to me, but the box...
Oh, that's another thing. And it was already provided to me, so she already has two. She's already gotten this second bag.
Gotten. Bad dandy. Gotten's. You can do better.
That is supposed to be being negotiated for now. But it's useless to her because she's not able to put the box in the bag.
Unfortunately do not fit in the bag where I did attempt numerous times and even had others try to help me put it in the bag. I also did...
What a scene in the jail, eh? You know, 8 prisoners all trying to shove a box that doesn't fit into a bag that's too small for it.
Not know that they were fire retardant bags. I have the one already.
I didn't know they were fire retardant bags. If I did know they were fire retardant, what? That would change your ability to fit a box into it?
I didn't know it was a fire retardant suitcase. If I knew it was fire retardant, I wouldn't have put him in there.
At my bunk. And I'm in the process
Meowgarita.
of trying to figure out what needs to be purged.
Drink
I
up
also
for
have my
Meowgie.
second family law case that I'm trying to be able to obtain those copies at my...
Her family law case. So remember, that's still important to her. So in addition to all this shit that she's got crowding her bunk in the Big Bay, she's also got a box of family law documents.
bunk as well, because...
No, and that's exactly it, Seba. Seba says, no one thought to take the paper out of the box? That's what it sounds like from this little story that Sarah's relaying. She enlisted the help of other bunkmates, and they all stood around, you know, well, maybe if you hold the zipper together. Wow, this is really weird, because I can normally just do these zippers with one finger.
The difficulties of receiving and delivering anything to the property department, which is why I came up with the solution.
Not intentional. Don't be confused. Sometimes prioristic me is talking to prioristic people in the comments. Meowgarita is not here at this moment, but was there prioristically. And if you keep an eye on the live chat from the original when I premiere that, you can maybe even see what she's talking about. But yeah, it gets confusing. I'm even getting confused because sometimes I'm mentioning shit and I'm like, I just said that, man. But he doesn't know what I'm going to say, so I can't.
Of me trying to purge what I can specifically to be specifically removed from the jail completely by a friend who can come and pick that up. I was just waiting for this hearing to happen so I can figure out when to tell her to come to do so.
Her friend, so this is maybe Christina Pena, who testified, was a former inmate with her and testified on her behalf at the sentencing hearing as a former inmate. The idea here is that Sarah will have looked through her discovery, determined what isn't necessary for her to look at, and Christina can go put that, in storage for her until the day that she futuristically gets released. Look at it at her leisure.
The multiple Dans was very confusing when I was reacting to the stream where me and the cowboy had a bad time streaming together back on Friday the 13th in March. Because on top of the problems we're having with the stream, me restreaming it added an extra layer of me to confused me. And there's points in the stream where I have 3 different versions of myself reading passages from his book because I didn't realize they're all layering on top of each other. So the first read went great. Second read, not so great, kind of like row, row, row your boat gently down the row, row, row your boat. And by the third one, it's a mess, and they're all about the same length, so they all end at the same time. And I didn't have a headset, so when I was playing media on a stream, I couldn't hear it. I just had to assume it worked, and didn't work. Anyway, super confusing watching me react. There was 2 chats, and still, we had a great time watching it. Way better on the rewatch than it was in the moment.
So,
rolling along, exactly. It's like I'm 2 dandies. I'm 2 bodies with 1 soul.
is that accommodation acceptable?
It is. I returned the second fire retardant bag property.
She returned it because, I can't use this. It's stupid. So but...
bag because I didn't want to have anything extra on top of my extra already. And it...
Just so everyone knows, the YouTuber at work shirt is this is currentistic me. Aussie is a prioristic version. I used to wear the Aussie shirt as well as my purple sleeved Jimi Hendrix shirt quite a lot on the early streams. So that's one way of differentiating. That's almost like 80s me because we used to all have those 3/4 sleeve shirts with the different colored arms. But
is not able to be used for anything that I can put in there where I already have everything in the boxes in the one bag already being occupied.
Yeah, the facial hair is another giveaway. That's it. Clean shaven, like that hasn't happened recently.
You can't have the boxes. So right now she's got 1 bag, and in that bag she has 2 folders. And if you remember from the beginning of this stream, one of those folders is just full of her publicity, good, bad, and hostile and otherwise.
Are you satisfied then with regard to the
satisfied
treatment, for lack of a better word, of the hard copies?
What do you mean by that?
Sure. Are you the procedure for having them stored and where they're kept is identified today? Is that acceptable to you?
Meaning I can have them where I have them now?
That's my understanding.
Okay, count down until Captain D. Giovanni corrects Judge Kraynick's understanding.
Judge, may I say something here?
Didn't take long.
Countdown,
Sure.
0. I'm glad, Sub Rosa. Sub Rosa is somebody that I got to know through the Hear Me Out chats and let know that I was making a channel, and helped keep interest from there. Often get to see her just saying hi in the channel, but don't get a chance to communicate as much. But it's nice to have this kind of afternoon. I've always pictured my role as for the community is to provide a little bit of a coffee shop. So you can drop in, you can hang out all day if you've got nothing to do. You can come in 5 times during the day. You don't have to buy coffee every time. But it's a place that you just want to pop in, see if your friends are here, see, what's on stage tonight. Is there something interesting? Is it something new? Is it something old? But it should be a hangout where, you're just as likely to run into your friends as into new friends, but it should always be welcoming. And that's why I try and keep the same day so you guys, can just settle in, and whether you're into the content or not. And I know not everything's for everyone, but hang out in the chat, get to enjoy each other's company. And when the content and the chat is both great, then bonus, that's above and beyond.
Okay, and thank you for allowing me the interruption. The cardboard boxes are not authorized by the fire marshal. The fire retardant bags are. So the document
You can't have the boxes, even if they did fit in the bags. You don't get to have the boxes.
are going to have to come out of the cardboard box and into the fire retardant bags.
Okay. Seemed clear, right? There's a lot of dings there, but each one of those statements was correct. You can't have the boxes. You can have the bags. Paper's going to have to come out of the boxes, go into the bags. Sarah.
This is Forever Wanderers, echoing the same sentiment. Dan D. True Crime. I've had to work, so I've only been lurking, but I love your Friday streams so much. The chat and company and commentary are always wonderful. And that's the other point of it, is if you can't be a part of it, when you watch it on replay, you feel like you're a part of it. You get to watch the live chat. You see your friends being acknowledged. You get to keep up with the conversations. So if you join next week, you know what the new inside jokes are. Well, why is everybody spelling Mr. J's name funny? Ah, that's what you guys do now. Okay.
That was that as clear to you as it was to me and to all of us in chat?
Ms. Boone?
I would have to figure that out for the voluminous amount of paperwork that are contained in those 2 boxes.
Yeah, you will have to figure it out. You will. Do you think it'll be any easier to fit the paper in the bag when it's no longer in the box? Can you change the shape of paper to fit the bag if it's no longer in a box? Would that work?
And there is no way to organize or separate. So it would just be a large mass amount of papers. So if I may, in the meantime, try to come up with some type of organizational structure of those 2 fire retardant bags with my hard copy discovery enclosed in those. If I could.
Some type of an organizational structure, if I could, with my.
Please do so.
Thank you, Hairball.
Mr. Shevendell, I'm
Mr. Shevendell.
Giovanni, is there any way we can give her an additional bag or so, and she can switch it in and out of property, whatever it may be? Can we provide her an
3
additional
bags.
bag? That may
So above and beyond, this would be a 3rd bag.
help her to separate her documents?
I could provide the 3rd fire retardant bag, but
That's it.
It's the encroachment into another inmate's area. It's a limited space. But the cardboard box can't remain. And Judge, if you recall my request, I had asked for all of this to be placed on a USB drive so that we would not have the paper in the jail for this.
Exactly. So anyone who watched 2 weeks ago, we were watching the hearing where they were talking about digitizing everything so that she would be able to store it at the jail. Sarah pulled some kind of a fast one to say, oh, the captain said I could have it. It's my discovery, because it got delivered and whoever was on shift was like, I don't know what to do with it. I gave it to her. Captain D. Giovanni was not happy.
Very.
And I understand that. And Ms. Boone has continued to request the paper copies.
She's continued to request the paper copies.
That's why everything was digitized, so that she would have that access to it. Everything has been digitized, but she has continued to request for those, and we're trying to make that accommodation for her as well. Yes.
Scott, if everything's digitized, why do we have to get the paper?
It's a great question, but
now it's her own client asking, which is good because, you know, he works for her. But Scott.
Scott accidentally gives a little legal advice to Sarah.
That's up to her if she wants paper or not. That's fine.
All right.
It was never my decision to have anything digitized in the first place, and nonetheless,
She totally was asking, because at the beginning she's like, I don't know why any of this wasn't solidified before the laptop. She just wanted the laptop and the hard copies. She just wanted to be able to do both.
on a laptop that is not even fully accessible because some of the programs do not work, which I have not had the time yet to continue to go through everything that are on the USB drives.
Which I have not had the time. All you have is time.
Well, Suzanne, Ireland. I was looking at possibly doing an extended little backpacking trip through Ireland. May have to talk to you on future streams for information about the feasibility of such an idea.
You have 8 hours a day that got extended to 10 to 12 hours a day. Yeah, and you've looked through not more than one. Whose fault? Your fault, not ours.
And that being not my decision, and nonetheless, and most important to me, they are limited and restricted to particular time periods. When those laptop times are closed for the day, I can therefore pick up the hard copy discovery, be it in a fire retardant bag or in a cardboard box or whatever else it is that I'm able to keep them there at my bunk.
Wants to be at her bunk because, again, she was offered you could have all these hard copies in your cell.
Ramono asks in the chat, the only question that matters, why do you want any copies if you're not going to read any of them? And I think this keeps getting back to the 2018 arrest for strangulation, where her lawyer made ridiculous discovery requests as part of initial entreaties to the prosecutors about her strangulation claim. And they came back with, we're not proceeding with charges. I think Sarah thinks that there's some sort of magic power in asking for discovery that makes your case go away. And that's why she just is hammering it. Like, okay, well, what if I ask for it this way? Maybe when will my case go away? What do I have to do? I don't know what I have to say or how I have to say it. Just let me go home.
That as plan B when plan A is closed.
Judge, if...
So, yeah, I don't think she ever wanted her discovery for, the reasons a person would want it, like to study it and look for things that could be used in your case. She wanted it for the effort that other people would have to go through in order to provide it, and some sort of a pipe dream that it would be too much effort and they would just go, you know what, just close the case. Oh, she's a hassle. Let's just go home.
I might be able to offer a resolution here.
What do we got?
I love that too. I think I'm going to rewind it and prioristically too, but I'm going to rewind it 5 seconds for you anyway. Judge Kraynick's like, he's a little frustrated at this point. This is going a little long. And as soon as he is offered a solution, yeah, what do you got?
I might be able to offer a resolution here.
Okay.
What do we got?
Was the discovery that Miss Boone received, was it just a stack of papers in the box, or was there any type of manila envelope or filing separation system?
Hey, just me.
I haven't looked at them. I haven't copied them. They were opened in court back in, I think, June 28th, when we had the hearing where the court found that Ms. Boone had forfeited her right to court-appointed counsel and alternative.
Rita Schuler gets in a very important comment. Sarah pisses me off. Thank you for that, Rita Schuler.
Alternatively have waived that right by virtue of her conduct. I believe the box was open at that time, and there may be manila folders for some of the items, but I can't speak to all of it. I haven't reviewed it. I'm not able to review it.
I just have to go to the bathroom. I'm going to leave it play, but listen to the use of the word folder and envelope, because what happens here is Captain D. Giovanni does, she said envelopes first, then says folders. Folders goes back and forth, and then it comes back, and Sarah is kind of rightfully saying, you know, you can give me folders, but the papers are just going to be loose and would go everywhere. And then Captain D. Giovanni says, well, that's why you would use the envelope, and the envelope would contain the papers. Anyway, that's what happens in the next 2 minutes. That should give me enough time to go to the bathroom and come back.
You want me to go with you, Dan?
Would Miss Boone be able to indicate whether the paper is free-flowing paper, or was it bound in some way?
Ms. Cashman had represented that all staples had been removed and all paper clips had been removed. Ms. Boone?
It is a mass amount of paper.
Are there dividers? Are there manila folders?
There, I believe, are 2 manila envelopes that have contents inside.
And everything else is just free paper?
As far as my understanding is yes. I've not been able to fully dive into the boxes quite yet because of waiting for information for this. But I can further explore once I return back to the dorm.
I can provide some manila folders without any type of clasp or string in order to get the cardboard boxes out of the building.
I understand. And that would be appropriate. I don't know if I'm limited to a certain amount on top of the specified pen and papers I am able to have. My question is, I would like to know also, please, for the reasonable quantities that you quoted earlier in regards to the amount of paper, is that the definition that you provided, is that for the enclosed housing area, or is this also for general population?
Ma'am, I'm responsible for, based on the Florida Model Jail Standards, to reduce the amount of paper clutter in all living spaces. It's not specific to just your housing unit.
Thank you.
Captain D. Giovanni, does that now, can she switch out and get things out of the property within reason if there's additional documents in her property?
Through the request form, if she, we're going to authorize the second fire retardant bag. We're going to offer some manila envelopes without a metal clasp or string.
Envelopes.
So that she could get everything into the fire retardant bags. And then we're going to remove the cardboard boxes, which are...
They're a no-go.
Becomes is the fire risk, because it is not authorized or recognized as a, fire retardant item based on the fire marshal. The only thing that they consider fire retardant is the bag. And again, I will provide that. And then anything in excess, she could send to the property room. Well, and then upon her need for it, she could write a request to the property room, and the property room will bring it over. But she'll have to swap it out. I'm amenable I'm amenable to her keeping her documentation.
That just the localization? I would think amenable, but it could be just the local. Amenable seems like it could be fine.
Not looking to take anything away from her, but it has to be in accordance with, fire marshal and policy.
Yes, Kitten Pusher, we just have a little longer to wait, and Godot will be here. That's why I'm here, and that's why he's here.
Policy.
I understand.
No, you don't.
And I would be happy to comply with the extra bag and the manila envelopes for.
She would be happy to comply. Now, if you want to see Sarah Boone happy, stick around because we're going to be watching a video that is Sarah Boone at her happiest. I literally, like, even game show Sarah, even, Sarah high school picture, not as happy as she was the day that she got to show up to court and show everyone her circus ad worked. We'll be watching that in about 20 minutes. Thought I was going to transition real smooth there.
No such luck.
Separators in regards to that.
So, ma'am, if the jail was to provide you those manila folders for the hard copies and a third fire retardant bag, is that acceptable?
It is if I do conclude that I need.
It is, but let me just say some more things before I even take a breath after saying yes.
For the hard copies and a third fire retardant bag, is that acceptable?
It is if I do conclude that I need anything additional in order for them to be able to be held together in
Thank you,
regards
Hairball.
to some.
Amenable, perfectly fine both ways. Yeah, didn't want to, wasn't calling out as much as just hit my ear differently because I'm definitely an amenable. I don't know, I'm an amenable sort of guy. I'm amenable to various pronunciations, that's for sure.
Type of rubber band or some type.
At this point, they've said envelopes a couple of times. So again, it shows that Sarah isn't able to maintain and focus nearly as well as she thinks she is because she misses key details.
Love this guy's commentary.
By hearing, whatever triggers her into her notes, her, okay, this is what I'm going to say next. The minute she has that transition in her brain, she can't hear what's happening around her. They've mentioned envelopes a few times now, but she's worried about the papers just being free flowing and is talking about getting elastic bands and envelopes or elastic bands for her envelopes. I do like that Captain D. Giovanni kind of gives a couple just blunt no's.
Elastic, something to be able to bind the paperwork together. Is that a possibility?
I didn't hear the question.
You may have to speak more clearly into the microphone in front of you, ma'am.
Would I be able to, please, if I needed, to have a type of rubber band or some kind of elastic in order to bind?
No.
And I know, Captain, that you are.
No. Sometimes, less words do way more. Take that as a notice there, Sarah Boone, throwing out 400 words just to say two. No.
Aware the courtroom is not in regards to the property bags that you all do supply. There's no rigidity to them whatsoever. It's just a floppy bag. So when you pick that up, everything goes in the middle. So there's no type of, there's no way of actually being able to make.
There's no structural integrity to a floppy bag is what Sarah Boone's trying to say. Maybe you needed Pretend Son there to help you out, but Pretend Son doesn't like you any more than Real Son. Welcome to the chat, Pretend Son.
Sure that one pile stays in the one pile and so on and so forth. Do you have any suggestions other than manila folders that I might be able to utilize in order to keep those together?
Yeah, she said envelopes now a few times, but tell us about your manila folders.
The purpose of the manila envelopes is that you would put the paper in the manila envelope and that.
Welcome, Alexa's son. We're towards the end of this stream, but we've still got a little bit more to go. So anyone just joining, I see we're only at 2:30 in the afternoon West Coast time, so I can hang out with you guys for at least 45 minutes, up to an hour.
manila envelope paper in order.
Okay, so they're envelopes, not folders, and so on and so forth. Do you have any suggestions other than manila folders that I might be able to utilize in order to keep those together?
The purpose of the manila envelopes is that you would put the paper in the manila envelope and that manila envelope paper in order.
That was Captain D. Giovanni with a TED Talk on how envelopes and paper work.
Okay, so they're envelopes, not folders.
Correct.
Thank you.
And that's a fairly simple solution, like all of that, envelopes. Oh, yeah, envelopes would work. To take the paper out of the box, sort it into envelopes as needed. You don't need to gum the envelope. You can just fold the flap in, put all those envelopes in the bag as they fit, rather than trying to put the whole box in the bag. Oh, Sarah, always up for solutions.
Ma'am, is that acceptable to you? And is there anything else we need to address with regard to the hard copies?
And Janaski.
Not in regards
Welcome to the chat.
No.
Okay. All right. Is there anything else, ma'am, that we need to
Neighboring
address
province?
today, Ms. Boone?
Yes, please. If I may conclude with the remaining amount of questions that I have in regards to my request.
Sure.
If I may conclude with the remaining amount of questions I have in regards to my requests. First, what are you doing with that ring you're wearing? Can I have it? My ring, Miss Boone.
Raintree in the comments says, "What's shattering?" And you may have thought it was a misspelling. I think that it was intentional, Shatnering. William Shatner is the actor who played Captain Kirk in the original Star Trek serial television program. Also did a stint as T.J. Hooker, or on T.J. Hooker. I don't know if that was the name of his character. I famously remember him for sliding across the hood of a car to the sound of theme music. He had a halting way of talking. His delivery seemed like he barely remembered his dialogue. And Sarah kind of has that cadence to the way she talks. I think Shatnering was the term. Welcome to the chat, Raintree.
Yeah, I know, but did you pay for it? My ring, Miss Boone.
Is it Mr. Shevendell?
She wrote it down, right? I told you to remember.
Oh, I forgot that was coming, and that was perfect timing that I paused it. Okay, we'll go back 15 seconds. Anyone who just joined early in the broadcast made a big point, just like she makes a big point of spelling everyone's name, including Mr. J. Oh, Mr. Shevendell? How do I spell it? Mr. Shevendell? So she writes it down. And I can only assume she's using her handwriting, which, while flowing, while consistent, and, may have received a good grade in 4th grade, sometimes a little illegible when you're looking at a word like, say, Shevendell, where everything is just a looping letter. So she's looking at her notes, and she's like, oh, what's his name again? What's his name? We've heard it a few times today. I'm going to take a guess. I'm going to go out on a limb. Shemamel. So Shevendell could look like Shemamel, like the E's and the M's and the N's and the... But still, her own fault. She asked for how to spell it and can't read her own writing because she's too pretentious to just print it and make sure she gets it right. All right. Mr. Shevenell, with no drink in my mouth.
Is it Mr. Shevendell?
She wrote it down, right? I told you to remember Shevenell. Mr. Scott Shevenell, appearing for the OCC jail. Sarah made him say his name twice. She wrote it down. Sorry, can you please repeat it again? But say it for me like you're at Muldoon's and it's near closing time. How about you do that for me, Sarah?
All right.
Copies now.
Okay.
For the people who are new to the stream, I discovered that slowing down audio makes people sound drunk. It Admittedly, I'm not the first person to discover this trick, and I do grow bored of it. This isn't a staple of my my commentary, just something I had fun with this night.
All right. Is there anything else, ma'am, that we need to address today, Ms. Boone?
Yes, please, if I may conclude with the remaining amount of questions that I have in regards to my request.
Whole bunch of words to say nothing. I'm not rewinding it because of how slow I played it, but yes, I just have the remaining amount of questions in regards to my requests, which are...
Sure.
Sure.
Even at this slow speed, Judge Kraynick's sure was almost just normal. Sure. It was just a little more casual, which shows you how sharp he was. Sure. With it.
Is it Mr.
Pronounce it like you're drunk, okay? It's Muldoon's. Closing time. You're finishing your drink so they don't pour it out as you're going out the door.
How do you ask a random
You
stranger
need his
to buy
name
you
so
a
that you
drink?
can call him. Maybe he's going to be the new Brian. How do you pronounce it? He told it twice.
Shevendell?
Shevendell. That's almost like silver bells.
Mm-hmm.
Shevendell.
Shevendell.
Hear them smell.
Hear them
I have in regards
It's Christmas
to my
time. I'm in Lowell.
Sure.
Sure.
Ring-a-ring.
Is
Hear them
it
sing.
Mr. Shevendell?
Never will be your parole day.
Yes.
He doesn't correct her. Just get on with it. Yes.
Could you please provide me with
Hey, Marianne.
The
Little spoiler. It's a no.
protocol or policy that you will have a guideline for me to follow, please, in regards to what
That's not a thing.
previous pro se inmates may
Ooh.
have
Yalgarita has a suggestion for a new Dandy song parody.
Oh.
Closing time.
Right, I still haven't done this. But it's worth thinking about.
Last call for alcohol. But it's set inside Muldoon's.
But they're not even open anymore. Yes, that bar closed about 2024.
Sarah, you don't have to go. Yeah, I could work on that. Closing time at Muldoon's with Sarah. I don't know if I can do it as a sing-along because it may be a little outside my range. But,
You don't have to go home, fuckface, but you can't stay here.
But yeah, maybe there's something I could do to the lyrics on its own because I think there's a match for Sarah within those lyrics.
had access to and be able to utilize. Do you have anything in writing as a hard copy?
Check. Now, do you ask for? Are you making a public records request?
Sarah's head turns again like a dog that just heard. Did you say walk? Are you making a public records request? Can I do? Is that something I can do? What is a public records request? Please tell me more.
I'm sorry?
Are you making a public records request?
Because if you were, oh, you know what's kind of cute here too? I'm going to listen to this at full speed because we already just listened to it short. But I'm going to reframe the camera. There is a bailiff in the right-hand corner of the screen, just basically where I am.
Oh, yeah.
I'm going
yeah.
to move the screen a little
It's all
bit so that you can
snickery.
see her, because she is amused with Sarah.
What can I do to make this
She has
better?
a look of pure mirth on her face. He changed the scene slightly.
I think I'm going to
Crank it up so that you can see everything.
Move my head. Make room
You will
for wherever I'm
be
gonna move
peeking in
myself.
just over the Court TV logo as Sarah discusses this.
Okay, yeah. So look in the middle of the screen. You'll see the bailiff peeking in just over the logo there. This is like between
Questions
two
that I have
ferns,
in
but it's
regards to
between
my
two
request.
Dans. Sure.
Is it Mr. Shevenell?
Shemamel. This is the moment that the bailiff leans in and starts grinning.
Yes.
Could you please provide me with the protocol or policy?
She knows it's not Shemamel. Like, I'm sure she's, if this is the attorney.
I'm better at this now. I can give you guys a better view of this than I did originally. Okay. One more. Grab the... Is that it? Yeah, okay. We'll just make it the center of attention. So she's middle of the screen. Okay. So there. Now you can't see anything really but the bailiff. She's going to lean in over Court TV. You're not going to see Sarah, but we've all seen her say Shemamel a few times now. So remember that and watch this. Going to lean in.
Shevenell?
Shemamel. This is the moment that the bailiff leans in and starts grinning.
Yes.
Could you please provide me with the protocol or policy?
She knows it's not Shemamel. Like, I'm sure she's, if this is the attorney.
Yeah, you tell it prioristic, Dan. But yeah, she works for the jail. She knows who this guy is. And she thinks it's hilarious that Sarah just called him Shemamel.
Attorney for the jail. I'm sure she knows it's Shevendell. And she's just looking at Sarah now.
See that you will have a guideline for me to follow, please, in regards to what?
Oh, yeah, that's 100%. I'm blowing that up a little bit more because I didn't realize I was correct as I was.
Let's see what I do. Maybe I do better.
Center
or then
of
that'll
this.
just make what I've got up even better. We'll see. I do like working with this Dan D guy. He's
Do that so it's above me, and we'll get.
he's not distracted by what I do. He does his own thing.
Dell
could run this show without me, to tell the truth.
Okay, so right above me.
No,
where she is, and you can
we're pausing
watch
that.
her reaction to Sarah.
I've over zoomed it, so now I just need to move it over a bit. Base. There's the active screen.
Well, no, not in real time. I'll slow it down to 75%.
Oh, you don't need to slow it down. 75's not bad. Okay.
Too slow.
He doesn't listen to me. That's the problem of working with this guy, but I like the way he thinks.
Previous pro se inmates may have had access to and be able to utilize. Do you have anything in writing as a hard copy?
We'll have to check on that. You asked for.
In order to keep those together?
The purpose of the manila
copies, no.
Okay. All right.
And then I lost
Is
the part,
there
but don't
anything
worry,
else,
I'll
ma'am,
catch
that
it.
we need to?
And so on and so forth. Do you have any suggestions other than manila folders that I might be able to utilize in order to
I'm
keep those
panicking
together?
now in real time, but not me
Everything
because it's his
goes
fault.
Sorry.
in the middle, so there's no property bags that you all do supply.
Get it together, Dan.
There's no
People are
What have I
watching.
done?
in regards to some
I'm
type
sorry.
of rubber
doing policy.
Don't say sorry, just fix it.
clue that I need anything.
No.
Oh, I flew too close to the sun there.
You did, Icarus.
Okay, so I know it's after the no.
Let's go. Come on. These people have been watching all day.
Okay, so they're envelopes, not folders.
We were
All
here
right.
already.
Thank you.
Ma'am, is that acceptable to you? And is there anything else we need to address with regard to the hard copies?
Yes, Mr.
Not in
Shevenell.
regards to the hard copies, no.
Okay. All right. Is there anything else, ma'am, that we need to address today, Ms. Boone?
Yes, please, if I may conclude with the remaining amount of questions that I have in regards to my request.
Sure.
Thank you,
Is
Mr.
it
Justice. I'm trying to
Mr.
get him in line.
Shevenell?
Yes.
Could you please provide me with the protocol or policy that you will have a guideline for me to follow, please, in regards to what previous pro se inmates may have had access to and be able to utilize? Do you have anything in writing as a hard copy?
We'll have to check on that. Are you making a public records request?
I'm sorry?
Are you making a public records request?
I'm unclear of your question. I was just asking if Orange County Corrections Department had any type of guideline that you are.
I think I'm going to mention it, but I feel like that was a clue. I think a public records request might be something he has to respond to, but if she doesn't make it, he doesn't have to. So he's like, are you making a public records request? Sorry, I don't know what that means. Okay, then I guess no.
Are accusing me of going above and beyond other than the pen and paper. So I didn't know if you had a policy or process in, if you have a pro se packet, like JAC has a pro se packet, does Orange County provide something like that?
I'm looking for, hi, I'm Troy McClure. You may remember me from such pro se packets as drinking and driving, oops-a-daisy, or, hey, I strangled my boyfriend. I'll just ask for discovery up the ass. Welcome to my new primer on second-degree murder.
You have to ask the jail that question. I don't know. I advise from a legal standpoint, and I can certainly tell the jail what the legal standard is. I'm not going to advise you as what the law is, but I'll certainly advise the jail as what the legal standard is.
Not telling you what the law is.
Yes, please.
Yes, please.
Captain, I would be...
Yes, please. It's like she thinks that she just asked him to explain.
You know, that's a great point. Sueswat says, like pro se for dummies, you feel me? Except Sarah would need, like, do you have pro se for straight A students? I'm not reading pro se for dummies. Ugh. I need the $600 pro se for straight A students book.
To the jail what the legal standard is. And it's like, no, I'm not doing anything you ask. I'm not working for you. I work for the jail. I'll do whatever they ask me to. If they ask for help, I'll give it to them. You can hire a lawyer if you want that kind of legal advice.
Responding to you in regards to that or following up with you or Sergeant DeJesus?
Ma'am, we don't have any access to that. I don't know anything about what other inmates that are currently pro se get other than that laptop and the information transferred to a USB drive.
Yes, ma'am. Thank you. And Mr. Shevenell, you...
Sorry, did you just get it worse? Did you just get it worse? More confident, but worse.
Yes, ma'am. Thank you. And Mr. Shevenell, you...
Mr. Shevenell. It's going to show my age a little bit. If you remember the old Sesame Streets when Mr. Hooper was still part of the show.
Love Mr. Hooper.
That was one of the running gags, was that Big Bird could never remember Mr. Hooper's name and called him Mr. Looper and Mr. Cooper and Mr. Blooper, but never Mr. Cooper. And it was, I don't know, just a funny gag. I almost see Sarah doing this to Mr. Shevenell. So Mr. Shevenell, you wrote it down. Shev and L. Shevendell.
Repeated that I have access to the court. Could you please define to me what your access to the court is for me?
Yeah, I'm going to object. I'm not a witness in this case. I'm really counsel for the jail, so it's really not appropriate to ask me questions. I know I've entertained a few, but I'm really not required to answer any.
Ma'am, he's not in a position to answer those questions.
Could you please answer who might be able to? Because I am in
Could you please answer who might be able to? Again, ma'am, you're not getting legal advice just by asking questions in court.
desperate need to view the case docket, which requires internet, and
I'm in desperate need to view the case docket. No, your flying monkeys can view the case docket. They're telling you what happened. You're upset that they're telling you what happened, but you've got full access to the case docket.
still waiting for any documents that you have mailed to me. I am unprepared, it seems, every single time now sitting here at the counselor's table with not the same information and opportunity. And
Triggered a few memories of Mr. Cooper, Mr. Looper, Mr. Stooper. Loved Mr. Hooper. That was like, I learned on Sesame Street. Those were some of my, my formative years. So I learned how to count to 12. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12.
and advantage as everyone else in the courtroom because I'm waiting for the mail. So I didn't know if anyone had any other suggestion of how I might be able to receive those more expeditiously and in a timely fashion so I can be prepared in order to properly defend myself in apparently more than one way or every time that I'm here.
I think Mr. Hooper dying too. I remember that being a very early but poignant, reality of death kind of thing. And Sesame Street creators treated it. It was good. Like kids, kind of need to know that life is impermanent, and sometimes things just happen. And if they glossed over,
I got bored with slowed down speed. I don't think I did it again after this episode. So for people who were big fans of it, this is the episode to put in your bookmarks because I don't do too much more of it.
It would have made it that much harder for parents who had to explain loss to children as it happened in their lives later. So, that was a formative part of my childhood.
In the courtroom, and something new is presented to me as a surprise. So I'm just trying to avoid those.
Items will continue to be mailed to you at the appropriate address as required by the rules of judicial administration and general practice.
So if I may please clarify.
If I may
my
please.
understanding is the
This is early clarification, Boone. Could I make a motion to clarify my motion to clarify the motion for clarification?
that I can receive anything is through United States Postal.
USPS, ma'am. Not going to further. Good for Judge Kraynick, too, because somebody in chat, Hairball Yarn, says the strategy of asking questions until someone just gives in because they're tired of her has worked her whole life, and she's mystified as to why it doesn't work in court.
I remember
and Judge
Captain
Kraynick just
Kangaroo.
showed it. Like, not going to answer you, ma'am. So the only way I can get mail is through the court. And that said, Judge Kraynick gave a clue. You have an investigator. Your investigator has a budget. If these are things you want, you could ask your investigator to get them for you. That said, he's never explicitly told her. He's just said the court take note. The court takes note that you do have an investigator.
This fine and dandy clip ends in the next minute and 30 seconds. The stream does not, so don't... that was abrupt. I'm still here. As long as the orange shirt guy is here, that guy's just going to disappear like that. He's not even going to give much of a warning because he doesn't know. He doesn't know it's a clip. As far as he's concerned, he's still live, but it's going to end in a minute and a half. Don't go anywhere. We're going to cut back to the rest of Judge Kraynick's 16-page order, which made Sarah pro se. We're halfway through the reading of that. And we might go back to Danielle Chavon's read of Vickers. White-collar Vickers works in the jail, called Sarah a fuckface. Sarah.
Presented to me as a surprise. So I'm just trying to avoid those.
items will continue to be mailed to you at the appropriate address as required by the rules of judicial administration and general practice.
So if I may please clarify, my understanding is the only way that I can receive anything is through United States Postal.
I'm not going to answer that question because that would be me potentially providing you legal advice. But what I can tell you is that items will still continue to be mailed to you as required by the...
As long as we're talking children's television in the chat, I have to throw out a little... there's two from Canadian television that are giants. One literally a giant. The other, Mr. Dress Up. Mr. Dress Up was Canadian Mr. Rogers. Very friendly. Not that Mr. Rogers wasn't friendly, but think of a friendlier version of Mr. Rogers. That's Mr. Dress Up. He had Casey and Finnegan. They were sock puppets. One of them may have gone on to become a pretend judge. I'm not sure. But yeah, Mr. Dress Up. And then the giant of children's television in Children's Television for Canada is the Friendly Giant. I think that he actually moonlit as the ho 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 green giant. I'm making that up. That's supposed to be a joke.
If I may please just make sure
Hey,
that
you
everyone is aware
guys!
that I cannot be properly prepared, as you can see now and prior. I just want to make sure that everyone is aware and understands.
I just want to make sure everyone is aware. So basically, she just wants credit. So when it comes time for her final grade to be offered on her pro se representation of self, she gets credit for the fact that she was unprepared. We'll put it on your record, ma'am.
For the reasons that we've discussed previously, I understand that. You're entitled to that opinion as to
Mr.
your
Groach's
pro se representation of yourself.
Okay, now we're evoking memories. Suzanne and Kinloff says, "Oh my God, I so relate to Mr. Grouch now as an adult." So many of the, like even the Care Bears. I remember there was a Grumpy Bear. He seemed like, oh, why do you got to be the stick in the mud? You're the contrary bear. It's like, you're the only one I relate to of all of you Care Bears.
Anything else that we need to address today, ma'am?
Yes.
Yes, there is. Hey there. If you think live streams
Told
are
ya.
just too damn long,
We're not going anywhere.
We'll keep watching these fine and dandy clips. They're shorter.
He just cut. But so when I was making the clip, I was like, okay, 2.5 hours. Even my poll said, cut it after an hour and a half, right? So that was a really long clip. We'll re-premiere it for the folks that are in Australia and the UK. We'll do it around 1 p.m. tomorrow. If you see this premiering tomorrow at 1, basically this same version, but without me interrupting it the whole time. And there's nothing I can do about the slowed down stuff that's there. But it'll be the last time I use it. We are going to move to the rest of the read. This is the 8-page order where Judge Kraynick made Sarah a pro se client. We just got to the part where Winston Hobson was fired. And it's basically it's a point by point. So 8 pages have gone by with Judge Kraynick just explaining step by step how every single lawyer along the way, whether her fault or not her fault, how they came and left the work of being the attorney representing Sarah Boone. So we're up to Attorney 7, Winston Hobson, and the date is January 12th of 2024. And that looks like, that's current on your screen. So we'll continue the read. And if you're wondering, so we're going to read through Hobson. We're going to read through Cashman coming on board. We're going to read through Cashman leaving the team. And then we'll get into the meat of Judge Kraynick's reasoning for making Sarah a pro se client, even though she had no desire to be. Item DD. DD, dandy. Okay, that's a dandy item to start with. On January 12, 2024, Hobson filed that certain motion to continue, waiver of presence, and requested a 3-docket continuance. E. January 16, 2024, the court addressed Hobson's motion to continue, granted same, set a pretrial conference for May 3rd, 2024, 9 a.m., and trial during the trial period beginning May 13, 2024. On February 1, 2024, Hobson moved to withdraw due to, quote, irreconcilable differences including, but not limited to, ethical considerations. Now, very similar to both Padilla's and Bankowitz's letters that were eventually approved. On February 9, 2024, a hearing was held on Hobson's motion to withdraw. Hobson addressed a number of issues as the basis for withdrawing, including disagreements on legal strategy, on what can and cannot be done, a lack of resources, and defendant's demands make her difficult to work with, including defendant taking non-viable legal positions and being unreasonable. As to a key, substantive defense, Hobson advised that the retained, that should be they, that they retained an undisclosed expert. Oh, hold on. I don't know why I'm having troubles reading that then. I'll just read it as each word is. As to a key substantive defense, Hobson advised that the retained and undisclosed expert is not keeping with what defendant has in mind. That the retained... Maybe that he retained. Okay, the should be he. As a key substantive defense, Hobson advised that he retained an undisclosed expert, not keeping with what the defendant has in mind. The court advised the defendant that the court had received a letter from defendant, a letter dated January 19th, 2024. The court outlined the overriding claims for withdrawal by Padilla, Bankwitz, and Hobson. Adversarial relationships, lack of satisfaction, and inability to meet defendants' desires. Court found that all defendants' relationships with all court-appointed counsel have deteriorated such that defendant and court-appointed counsel cannot work together. The court advised defendant that although defendant has a right to court-appointed counsel, that right is not unlimited. The court twice, italicized, advised defendant that defendant may not, also italicized, be provided another court-appointed attorney, and that defendant would have to represent herself, large quoted and bolded section, if circumstances similar to Hobson's motion to withdraw occur. This italicized and bolded section, this is the equivalent of Sarah's triple underlined, and I emphasized with great concern in her written letters. That's the equivalent. That is, Judge Kraynick is kind of blowing a fuse here. And he let it all out on display using italics and bold for the same section of type. The court twice advised defendant that defendant may not be provided another court-appointed attorney and that defendant would have to represent herself if circumstances similar to Hobson's motion to withdraw occur. The court further advised defendant about the dangers of self-representation due to defendant's lack of legal training and knowledge. Defendant never stated that she did not understand that she may not be provided another court attorney. The court granted Hobson's motion to withdraw and appointed Patricia A. Cashman, Attorney 8. The court is aware of Cashman's extensive experience representing criminal defendants as both an assistant public defender and in private practice, including representing defendants accused of murder, and is widely known to be able and willing to deal with and manage difficult clients. The court set a status hearing for April 12th, 2024. On April 12th, 2024, the status hearing was held. Cashman advised as to the depositions that had been set, the hiring of an expert, and a request for a future status date to address a trial date. The court set a status hearing for June 7, 2024. On June 7, 2024, the status hearing was held. Cashman addressed her dates of availability for trial. Defendant was present for the hearing and was sworn. Thereafter, defendant advised the court to walking out of multiple meetings with Cashman, which was confirmed Cashman using a pretend judge to oversee defendant and Cashman, launching multiple attacks on Cashman's professionalism and providing the court with letters dated June 4, 2024 and June 7, 2024, both of which were filed on June 21, 2024. I'll just give you a second to soak that in while I have a quick sip and get ready for a quick reread. So this is referring to the first bit of footage we watched at the very beginning of the stream today, where Cashman is saying, you try and tell a client about things that are important, things that aren't, and you try and tell a client. But when you have a client that walks out of multiple meetings, when you have a client that creates pretend judge to oversee the discussions, what are you going to do? On June 7th, 2024, the status hearing was held. Cashman addressed her dates of availability for trial. Defendant was present for the hearing and was sworn. Thereafter, defendant advised the court to walking out of multiple meetings with Cashman, which was confirmed. Cashman utilizing a pretend judge to oversee defendant and Cashman. Okay, so this is, I think even Judge Kraynick gets this a little bit wrong in this thing. It's not Cashman using the pretend judge. It was Sarah using the pretend judge. Not to oversee herself, but to oversee Cashman's behavior and keep her professional. Excuse me, I'm just going to do a throat clear, just about 2 feet back. 1 sec. Me. All right, we're ready. On June 7, 2024, the status hearing was held. Cashman addressed her dates of availability for trial. Defendant was present for the hearing and was sworn. Thereafter, defendant advised the court to walking out of multiple meetings with Cashman, which was confirmed. Cashman, utilizing a pretend judge to oversee defendant and Cashman, launching multiple attacks on Cashman's professionalism, providing the court with letters dated June 4, 2024, June 7, 2024, both of which were filed on June 21, 2024. Cashman advised to her efforts and spent time on the case so far, 20 hours. Cashman addressed disagreements on legal strategy, including defendant attaching importance to issues that may not legally be important. In riposte, defendant accused Cashman of lies and half-truths. It's the second time this variation of that word has come up today. It's the word of the day. Footnote, the June 7, 2024 letter sets out ad hominem attacks on Cashman's professionalism and untruthful answers. See page 8. The June 4, 2024 letter sets forth ad hominem attacks on Cashman's professionalism. See page 3. Both the June 7 letter and the June 4 confirm defendant disconnecting and or walking out of meetings with Cashman. Item JJ. On June 11, 2024, Cashman moved to withdraw under Florida rule regulating the Florida bar for 1.7b2, substantial risk that the representation of one or more clients will be materially limited by the lawyer's responsibilities to another client, and, quote, irreconcilable differences, including, but not limited to, ethical considerations, have arisen such that counsel can no longer provide representation, end quote. On June 28, 2024, a hearing was held on Cashman's motion to withdraw. Cashman relied on Florida rule regulating the Florida bar 417b2 and Schwab v. State, 636 Southern District, 3, Florida 1994, as the basis for withdrawal. At no time has defendant refused to accept the services of any of her 7 appointed attorneys. Had a minor worry that I wasn't on the right camera, but that doesn't appear to be a problem, so we will continue. This section is called Law. Both the United States and Florida constitutions guarantee an indigent criminal defendant the right of assistance of appointed counsel. The Counsel Clause of the Florida Constitution under Article 1, Section 16 recognizes the right of counsel as well as the self-representation. The Counsel Clause of Florida Constitution under Article 1, Section 16 recognizes that the right to counsel as well as self-representation in all criminal prosecutions. Berkeley v. State. In a section called Forfeiture of Right to Counsel, Item 00, a defendant in a criminal case can forfeit a right to court-appointed counsel. Item P. And this is all quotes, so this is Judge Kraynick quoting case law to support this opinion. Forfeiture is an extreme measure that flows from the defendant's abuse or manipulation of the right to counsel and results in the defendant being required to represent himself even though he has not waived counsel and may still want legal representation. Forfeiture is, quote, a judicial response that adapts the course of legal proceedings to the defendant's choice to engage in misconduct that undermines the legitimate exercise of the right to counsel, end quote. And that cites State v. Nisbet. Item Q. As set forth above, defendants' recalcitrance to the attorneys who are not conflicted out, Padilla, Bankowitz, Hobson, Cashman, antagonism, hostility, and attacks on the professionalism of Padilla, notably over a year after the fact, see footnote 9 above, of Bankowitz, and of Cashman, and personal attacks on Padilla, Bankowitz, and Cashman. He uses the Oxford comma there. Each of these attorneys were required to withdraw. Item R. It has become apparent to the court that the defendant will not permit herself to be represented by anyone. See United States v. Travers. Item S. Additionally, the withdrawal of 8 attorneys, 7 of which were court-appointed, leads to the determination that a defendant had forfeited his rights to counsel. See Watson v. State. Item T. Under Florida law, the facts at bar amount to a binding forfeiture of right to counsel. See Jackson v. State. Footnotes in United States v. Thomas, the misconduct of relationships with 4 attorneys, including verbal abuse, tearing up correspondence, refusal to cooperate in producing a witness list, hanging up on counsel during a telephone conversation, resulted in forfeiture of right to counsel. Second footnote, citing United States versus Herrera, Forfeiture of right to counsel can be found through a pattern of serious misconduct, abuse, threats, and utter failure to collaborate in his own defense. See also Com v. Thomas. Repeated abusive, threatening, and coercive behavior towards counsel can result in forfeiture of right to counsel. United States v. McLeod. Item W. Not to be confused with a W. 2 U's. As the court finds defendant has forfeited the right to court-appointed counsel, under Florida law, there is no obligation to conduct a Faraday hearing or to otherwise warn a defendant of the dangers of proceeding pro se. Now we get into a section called waiver by conduct, and this would be basically to explain what that last statement said. No requirement because it's the own conduct that created the situation. So, item V. The court can find a waiver by conduct to the right to counsel. A waiver by conduct requires that the defendant be warned about the consequences of his conduct, including the risks of proceeding pro se. United States v. Goldberg. On February 9, 2024, defendant was twice advised that another court-appointed attorney may not be provided. On May 10, 2022, defendant was advised of the dangers of self-representation. On February 9, 2024, defendant was advised about the dangers of self-representation. Item ZZ. As of February 9, 2024, the instant case had been continued 16 times. Line AAA. As of June 26, 2024, this case has been pending, and let me just say, bold, underlined, pending 4 years, 3 months, 5 days. From the date of filing the information on March 23, 2020. Line BBB. Actions speak louder than words. Although defendant's words seemingly reveal a desire to go to trial, however, as set forth herein, her actions and inability to work with court-appointed counsel are repeated over and over. Allowing defendant to her 8th court-appointed attorney, her 9th attorney overall, will only serve to delay the case further, and there's a footnote about taking into the account COVID, the case was pending for 1 year, 9 months, 9 days. Continue the sentence. Allowing the defendant to her 8th court-appointed attorney, her 9th attorney overall, will only serve to delay the case further and encourage defendant to persist in efforts to prevent the resolution of the case on its merits, the concept of which was first brought to the defendant's attention on May 10, 2022. Defendant complains that Bankowitz and Hobson, 2 court-appointed attorneys, failed to meet and communicate when defendant is provided court-appointed counsel who will meet and communicate, Cashman, the ways and means of meeting and communicating are unacceptable to the defendant. Big key right there that he's throwing in. So he's saying, even if we take her complaints about Bankowitz and Hobson on their face and just say, okay, they weren't meeting you the way you wanted to communicate. I took special note of those complaints to watch Cashman's conduct. She's meeting. She's communicating. You're walking out. You, Sarah Boone. Not her, Cashman. You, Boone. Defendant complains that Bankowitz and Hobson, two court-appointed attorneys, failed to meet and communicate when defendant is provided court-appointed counsel who will meet and communicate. Cashman, the ways and means of meeting and communicating are unacceptable to defendant. Item CCC. Under Florida law, the facts that bar amount to a binding waiver of the right to counsel. See Jackson v. State. Now, the order. Orders and adjudges as follows. 1. Cashman's motion to withdraw as counsel filed June 11th, 2024 is granted. 2. As a condition of Cashman's withdrawal, Cashman shall provide the court an order for costs to obtain transcripts of depositions for the 2 witnesses Cashman deposed. Upon completion of the transcription of the depositions, transcripts, shall be sent directly to the defendant, Sarah Boone, by Cashman at the Orange County Jail. Thereafter, Cashman shall file a notice with the court reflecting that the depositions transcripts were provided to the defendant, Sarah Boone. And such notice shall include the date sent and the address of the defendant, Sarah Boone. 3. Defendant Sarah Boone has forfeited her right to court-appointed counsel. Item 4. Alternatively, defendant Sarah Boone has, through waived by her conduct, her right to court-appointed counsel. Item 5. The Trial Management Conference shall remain specially set for Tuesday, September 24, 2024, 1:30 p.m. 6. This case, all caps, shall remain specially set for trial for the 2-week trial period beginning Monday, October 7th, 2024, and will not be continued for any reason except by extraordinarily good cause, Hurricane Milton, and extraordinarily good cause shall not include retention of James Owens, Your Honor. James Owens for the defendant, Your Honor. Okay, I got a little silly there. Basically, he set the case for October 7th. They were lucky. They got a hurricane, gave him an extra week. But he made it clear. I'm telling you now, I know that someone might parachute in at the last minute. It's not getting you a continuance. So when Owens came in and was like, "Oh, Your Honor, I just got here. I'm doing the best I can." Margaret, she's a little slow. I'm a robust young lawyer, but my assistant's been with me about 40 years, and she's a little long in the tooth. I don't look a gift horse in the mouth, but anyway. So the case set for trial October 7th. We know what happened. It went to the 14th. He also set it up so that there would be 3 weeks with her pro se. Turned out we needed 6 days and 2 hours to figure it out in the jury room. But that was that. It was crazy that the hurricane was named Hurricane Milton, and that corresponded with the city that James Owens came from. Final item. Any and all pretrial motions in this case must be filed no later than close of business Monday, July 22nd, 2024. So we kind of know that there was more motions filed. Like the snacks motion didn't come until mid-September. The hair and makeup team motion, I think the hair and makeup team motion might have been the September 3rd hearing. There's a certificate of service. She's always wanting that. Anita Barrios prepared this. Okay, so that's that. We've done our read-throughs. We've done our watch-throughs. Let's have a little fun. Let's go back to Danielle Chavon telling us what happened with Vickers. Does anyone know about the Vickers story? Sarah was called an unfortunate nickname. Rhymes with duck space. Duckspace, the new social media app for ducks. Duckspace. That said, we haven't even checked out her Kevin Beck. You got to check out Danny Chavon's page because there's also some Kevin Beck news that Kevin Beck may be the mystery helper. We'll let her report on that. Okay, make sure that I'm up on the screens. You might have heard her in the background. I think that is her full screen. Perfect little transition screen, little peekaboo. You guys don't know what's coming. And then boom, Danielle saying fuckface.
Emily checked in around 11 a.m. as planned. 2. Dorm Officer Johnson called me at 11:53 a.m.
So this is from Danielle Chavon's new video. It is an official complaint that Sarah lodged because an Officer Vickers, who wears a white-collared shirt, said a name, and we get to that in item 7, but it is a 7-point complaint, and Danielle reads it off for us. So point 2, just basically going through the facts, one by one, what led to what for this duck space comment to ensue.
Dorm Officer Johnson called me at 11:53 a.m. Wow, they checked in at 11 a.m. and she wasn't called until 11:53 a.m. I don't know if they were being processed or if they were just waiting around.
Just saw a little plug in the chat for AG Tactical. I love his Shirilla content. The way that he does the Natalie voice. Like, oh no, Kinsey. Oh, that's so sad. Oh, yay, Kinsey. I love listening to AG Tactical react to a Shirilla phone call. He's got just the perfect amount of disdain and genuine interest in the topic, but yeah, a lot of fun to watch.
But this is an inside look at the visiting at Lowell, the in-person visiting at Lowell. Number 2. Dorm Officer Johnson called me at 11:53 a.m. after he was called to have me report to VP. I don't know what VP is. Number 3. I need my people that have been incarcerated to let us know in the chat, what is reporting to VP? I think that's count, where they count the inmates to make sure that they're there. We'll continue with less commentary. 3. I ran to be at count from being called so late and to not miss any more time. 4. Vickers was at the VP door, asked who I was and where I'd been, stating, quote, "Your visit has been here over 40 minutes, end quote. 5. I said the officer just called me. He can radio him to verify for understanding. I'd been waiting on VP. Johnson confirmed. 6. Vickers opened the door where I thought he was allowing me to finally go in and attend my overdue visit. 7. Vickers then yelled, quote, "Not you, fuckface." And Forbes heard him say, walked out instead. Then Vickers then yelled, quote, "Not you, fuckface." And Forbes heard him say, walked out instead. Then they just left me outside. Oh, then Sarah gets a response. It's, "Your grievance has been received and evaluated. Thank you for providing this information. This will be reviewed, which may result in a personal interview with you. Please notify, I can't make that word out, to include Sergeant so that in the future." Johnson confirmed. 6. Vickers opened the door where I thought he was allowing me to finally go in and attend my overdue visit. 7. Vickers then yelled, quote, "Not you, fuckface." And Forbes heard him say, walked out instead. Then they just left me outside. Oh, then Sarah gets a response. It's, your grievance has been received.
We'll give a little sneak peek to Danielle's other video, but you have to go watch these videos. They're
a few
half-hour long each. Let me see where we'll go for Kevin Beck story. Be right around the 10-minute mark.
The location of visit is in the classification annex. It lists the attorney's name, which is Kevin Beck, his state bar number, and it shows that he is approved.
So these are both videos that are featured from Danielle Chavon in the last 24 hours, so pretty easy to find if you go to her page, if you're not already a subscriber.
Remember, Kevin also scheduled a visit with another inmate that day. I believe it's a death row inmate by the name of Alyssa. If you're just tuning in, we will deep dive on Alyssa's case, futuristically, of course, and another inmate that is there with Sarah Boone, Sakina Thompson. Sakina has been...
Who knows if the officer didn't even just call Sarah a duckface and she got it all wrong. He called me fuckface. No, duckface. Like the duck that's named after you, Sarah.
Going viral for breaking all of the rules at Lowell, so we will definitely dive into that. Right now we are looking at the visit from Kevin Beck to Sarah Boone. Now we're going to deep dive further. This is where I name my people. Let's check out this mystery legal advisor timeline. June 24th, 2026. Attorney Kevin Beck requests permission to meet Sarah. The purpose is to review an appellate brief. June 25th, 2026. The FDC prepares the legal visit authorization. Legal visit is approved. July 7th. Beck meets with Sarah in person from 11 a.m. to 12 p.m. in the classification annex. From what we saw, the visit was marked complete and they reviewed the appellate brief. Exactly 2 weeks after this meeting about the appellate brief, we get a letter from Sarah. She emails the appellate court. Oh, what do you guys think? Is Kevin helping her? Was that even 2 weeks? I think it was about a week. Nonetheless, we were all dancing with the dogs when we got that letter from Sarah to the appellate court, especially knowing that she probably violated an order to not contact the court. Then Australia starts to come and clear her name online like, hey, it wasn't me who was directing Sarah, you guys. Not this time, okay? It was someone else. Looking at this timeline, could that someone else be Kevin Beck? What do you guys think? What's what and how many? And why would it be Kevin Beck? What would he have to benefit from helping Sarah Boone? Or this Alyssa? Oh, this is juicy. On our prior episode, we went over a visit where Sarah was strip searched, as she says, and called FUCK face. That visit was July 3rd. So Sarah had a very busy 2-week window there.
Gotta think a little one was around like FUCK face.
From the visit with Kevin Beck, writing the appellate court, and her family visit. Oh, let's do a quick rewind on Sarah's remedy for the white shirt that called her new nickname. How did you guys like her new nickname? Shout out to my sources. Let's do a quick rewind and see Sarah's remedy for the Lieutenant Vickers, our hero. You guys tell me what you noticed in the chat. I noticed that Sarah titled it "No Retaliation" in parentheses, and at the end she quoted the prison motto.
I don't think fuckface is the worst thing a prisoner's been called, to tell the truth.
And said, "It wasn't a good, productive day today." Her victim card never expires. Know that. Be right back. Oh, and
actually, there was a kid that my daughter went to school with that's nickname was Cockface, and I don't know that it was that his last name was similar to that, or how we got to having that name. And I'm gonna make up a fake
name, but his first name started with a C, and they just did the alliteration. So, we'll call him Clarence Cockface. Sorry, Clarences that are out there. I was trying to pick a name that there aren't many people of, but yeah, it's like, we're going to Clarence Cockface's house. What? You're going where? But yeah, I don't know. Fuckface isn't the worst thing somebody's been called in prison for sure.
It's important to note, in case you're keeping up, in case you're tracking, Australia, when she came to clear her name and said like, hey, you guys, it wasn't me that helped Sarah, she did not disclose who was helping Sarah. We are just getting these documents and now just piecing things together. That's why I need you guys in the chat to tell me, what do you think about the timeline, this mysterious appellate brief review visit with Kevin Beck.
Okay, so that's all I'm going to give you that. Check out Danielle Chavon for that. If you're more in the mood for shorts, I've posted a link to July. That's a weird. Where did that come from? July and August shorts that were produced, oddly enough, in July and August of this year. So if you like shorter, more musical content, or just bite-sized, the nice thing with that is it's set and forget. Once you launch it, because it's in show format, it's not going to keep replaying the same short over and over. It'll go to the next one and the next one. And 2 hours later, it might be time for the ramble. I don't think I'm doing a ramble tonight. If I continue drinking, I won't be, but unless I do. But it'll be an unscheduled ramble, if anything, at best. At best. Let me go to this page here, because this is kind of a good goodbye page. Yeah, maybe we should put on some goodbye music and close out this stream, because I think we've done what we're going to do today. And this is how we'll format this for the next couple of Fridays until we're finished with the Sarah Boone trial. I'll do about hour-long clips. We'll do 2 or 3 of them together for 3 to 4 or 5 hours on Friday mornings. Revisit the best parts of the trial, the funnest, most high engagement moments that we love together. And then, but yeah, so if I do go tonight, I think Robert Tellis, I'm wanting to do the Kevin Lickwich trial, but before I get into full trial, and even that's just 3 days worth. So that's near the top of my chart, but maybe just the Tellis testimony, where he's doing the narrative testimony from the stand. So not the whole trial, just the good part. I think that's what my plan is. A little off topic from Amy, who says, my mom took both my first and middle names from Little Women. I knew from that day that they were Little Women. I only know that quote because Mo Sislyak said it in Simpsons, trying to sound all literary here. Yeah, it was a fun stream. I really like this one. But that said, going into the next week, that means it'll be the Owens fiasco takes over. So we're going to get the snacks motion. We're going to get the glam motion. We're going to get even more of the transcripts from the jury selection portion of the early days of the hearing. So lots to look forward to. 7 hours in today. 7 hours feels like a solid stream. It's a little short by Dan D standards, but, not the shortest stream I've ever done. So yeah, let's lock it out there. We'll go to the music screen. We'll put on we'll find something appropriate for goodbye. Is that a goodbye song? No. A little bit more. We'll do 2 songs. We've got 5 minutes of goodbye here. If you want to leave now, you can leave now, but... This is Kind of a Party by the Mini Vandals. It has been kind of a party. Thank you, Carolina. Had a great time rolling along. Good to see you, Addie. Ramono, feeling good. Thank you to everyone who bought gift memberships today. You really brought the community together. I saw some people as they popped into chat saying, you know, oh, thank you for the membership. I've been away for a while. It's exactly what the memberships are designed to do. Remind people that, hey, there's that channel. Maybe I haven't checked it out in a while, but wow, they're having a lot of fun there. So thank you for being part of that. Punchable Babyface, thank you for sticking around to the end. Kootenai weather's looking beautiful. You know where I just was, Punchable Babyface? Rock Creek. There's a little private campground right near the city center, close enough that you get Wi-Fi access from your little campground, right on the Kettle River. $30 a night. You know, no power, dry camping, bring in your own water, bring in what you got, but fucking beautiful. A couple hours down the road. If you're in Vancouver, even if you're not from Vancouver, like for what it costs to travel, you could spend a few thousand getting here and then spend $30 a night and have the best week of your life out on the Kettle River. Yeah, it's called Rock Creek Riverside. If you're in the BC area, it's an easy drive off of Highway 3. Everyone passes through Rock Creek on the way to somewhere if you're going from Vancouver to the Okanagan to the East Coast. Oh, we're on this song. It means this is the last song of the night. This is Tonight Again by Rod Kim, featuring Mostly Moss. Thank you, Suzanne. I hope to see you again. Fuckface brings us all together. I'd love to do Dolly. But all the copyrighted music is sadly unavailable to me, Addie. That said, there's a beautiful version of Dolly Parton singing with Kermit the Frog. They sing a version of Everyday People, which, you know, I can sing, but I'm not Dolly. I can maybe do Kermit the Frog's version. But they sing Everyday People, and it's touching, it's sad. Look for it on my community tab. It's to see Dolly even... She was such an authentic person that even someone like Kermit the Frog, who's, you know, a Muppet, a puppet, right? You even felt like she cared about him. Beautiful person. I'll post it in the chat, Addie. I'll post a direct link.
Hands up for tonight again, even in another lifetime, find me there, and let's do tonight again, even in another lifetime, find me then, and let's do it tonight.
All right. Good night. Stay tuned on the community page. If there's anything happening, that's where you'll find out. Still working on my sunflowers short. Check out the pinned comment if you want to see Dolly Parton and Kermit the Frog singing Everyday People.